by the force of RPF, they have been made to close their trolleys, and when the affidavits are complete, it's absolutely ready for hearing. It will take only 15-20 minutes for me to place the matter before my lords. So if my lords allow this, isn't it? But I will
The
intimate.
hearing matter.
Yes, Lord.
That is the problem. Because I want to go all.
Since my
touch all
lord
the-
has
but,
designated Thursdays as hearing matter,
no,
that
that
I've
but even though there are several matters they are mentioning the urgent, so it is coming as a urgent most.
I can wait till the next week also. Lord, if it's so possible for my lord's list to be to accommodate me, I'll be very
Hearing will
grateful.
come
Lord.
tomorrow. Kal rak
Yes,
usko
Lord.
talk mein kar.
I'll
My
invite
lord,
my learned friends with
my lord,
regards to the
Hearing
same.
mein kal talk mein kar.
my lord, I'll be seeking your lordship's leave, my lord, to, sorry.
Learned friends' permission. One more matter. Extension of interim order. It can come in due course. Interim order is expiring on 19th December.
19th, so
Yes,
18th.
Lord.
18th has to be mentioned.
Very
for
well.
extension of-
I'm deeply
My lord, I'd be seeking your lordship's leave, my lord, to move an urgent writ matter, my lord, today, my lord, subject to your lordship's convenience. My lord, in similar situations, my lord, your lordship very recently has also passed an order. My lord, the party in opposition, my lord, wants to hold a public meeting, my lord, in a private land, my lord. Now your lordship knows it is going to be held tomorrow. We are aggrieved by the actions of the subdivisional officer Howrah, my lord. We have applied to them on the 8th of December. Till now, they have not responded to that. Your lordship knows this is nothing but a way, my lord, to throttle the democratic process. My lord, I'm only beseeching if it could be taken up for hearing today.
When is the meeting?
My lord, tomorrow from 3 o'clock to 5 o'clock.
So all the other formalities have been
All done. All done. Other formalities done. Your lordship, my lord, has very recently on the 19th of November, my lord, had also appeared in that matter. Your lordship has passed a similar order, my lord, with regard to the necessary my lord, compliance which we have to do. We have done all that, my lord. Lordship, can you take this at 2 o'clock, my lord? I'll serve the state. State is the only party, my lord.
I don't.
My lord, and as your lordship, any time today, my lord. Otherwise, it will let it become infructuous.
है क्या फिक्स मैटर है? फिक्स क्या रखा? स्पेशली फिक्स? Especially fixed. Okay, leave granted. And but yeah, supplement. Yeah, unless and until it is not been affirmed, how it the supplement.
My lord, your lordship will have to give the leave. My lord, I'll get it affirmed, my lord, and we'll give the number to your lordship's court officer. By that time, the supplementary list will come out.
तो देगा तो supplementary करके 230 कर दे.
Deeply
230.
230. Deeply
My lord, with regard to item number 235 to 240. So, my lord, pursuant to your lordship's order, my lord, the authority concerned has already filed a report. I agreed with the report, my lord. This is regarding the admitted amount which has been withheld. Now, authority has come with a report that this amount is entitled. My lord, the similar order which has been passed by your lordships, and my lord, I am entitled to, my lord, the same order, usual order, my lords.
Mention yes.
For inclusion, my lord.
Not today. Yes.
May I, my lord? Should be
On 2nd of December, I had mentioned this matter. On 2nd of December, your lordship has instructed for this to be listed under urgent motion. But my lord, today I find that it's listed as item 505. The urgency is, my lord, I have been blocked from the DVC tender. My lord, on 2nd of December, your lordship indicated.
Motion में बोल के वहाँ चला गया.
So, my lord, it's the same problem, my lord.
So Thursday.
2nd December, my lord, urgent motion is listed. The 10 तारीख बोला listing. But I checked on YouTube also, my lord. The lordship is instructed on 10th to be appearing under urgent motion. But it's appearing as 505.
Friday urgent motion.
The same, my lord.
So grateful.
May I have lordship's leave, milord. This matter must participate circuit bench at Jalpaiguri, milord. Milord, my
circuit is there.
Milord, every day I'm losing, milord. On milord, 4th order has been passed by the excise department, milord, for closure of my bar. I have my license with me, milord, which is valid until March 2026. The allegation is, milord, I was carrying on, milord, live performance. Milord, heritage, milord, last 150 years, milord, we are running this. Now, milord, our application is for this, milord, for live performance, the separate license is required. We have made formal application, we have paid necessary requisition fees, milord, but formal license has not been granted for because of a difference. Now, milord, entire bar has been closed. That's not the urgency every day.
Violated the conditions.
No, milord, so far, milord, legal license is concerned, I have not violated. They have not even indicated that I have violated any condition, milord. All that, milord, for live performance, there is separate license is required. For that, application is pending. Payment has been made. No formal license has been granted. Milord, I will not conduct my live performance, but so far, milord, legal license is.
What you want?
Milord, hearing, milord, tomorrow, milord. Otherwise, milord, every day, milord, I am losing, milord, every day, milord. Kindly grants me leave so that I can move it today or tomorrow.
Not tomorrow. Today, which we are on. Come on Monday.
Friday then. Kindly Friday.
You granted. Listed on 12th. Yes.
May your lordship kindly leave to mention
No,
extreme
no.
urgency.
Yes, call the.
My lord, kindly appreciate, my lord.
Nothing.
My lord, kindly appreciate, my lord. I have been detaining. After my detention period is over.
Already appreciated. 5 matters I appreciated. Yes.
I'm appearing for the respondent.
The impugn order dated 12th number 2025 issued by the respondent number 4 is not sustainable and such. Yes, next.
Number 2. Doctor, kindly seize this document for us.
That the matter is appearing at our instance. Mr. Ghosh had mentioned the matter. They've put in that
Yes.
they put in large number of tube wells, I'm told.
Arey Baba, document लो यार. Yes. Yes.
In last petition, this matter was mentioned.
Milord, I want to show your lordship.
17 at 2 p.m.
Yes, I know.
In the live streaming, your lordship, it has been said to your lordship that the water is being dried up to take away the nature of the pond, your lordship. But kindly seize this document, your lordship. They are only wanting to stall the regeneration of the water.
Milord,
body.
please
Maybe
have.
how they want to stall this. This is the
Milord-
document I have brought in, your lordship, for your lordship's
Milord,
satisfy your lordship that what is their motive to mention this matter again and again.
Milord, the
Because they know if the nature of the water body is restored, they won't be able to sell off the land.
on Google camera, your lordship will get the date. Your lordship will see the pumps. Please, Milord, turn over the pages. This is a supplementary affidavit, Milord.
They have issued the tender. Have you a knowledge? They have issued the tender.
And they have not.
They have issued the.
Tender.
Yes, Milord. Milord,
Have you challenged this?
Milord, I have obtained a decree, really. I have obtained orders in execution. This action is in flagrant disregard of several, at least 5 orders passed by this honorable court. Now, Milord, this is also for protection of the environment, which is, Milord, the court's first prerogative. And I have all orders. I can show them one by one.
No, the work order has been issued on 27th February 2020.
But question is subject matter of the contract. Is it in violation of your lordship's order?
Let me see. When it
Now,
is
if the whole water, Milord, please just turn over the pages and see, Milord, that the pumps fitted, which are, I don't know what restoration work is going on. Milord, this is a matter where there is a direction for the purpose of restoration of water bodies. There is a direction for demolition of, Milord, structures which have been created by politicians on a water body. There is a direction on the municipal corporation to forthwith restore the water body. Then your lordship is shown, Milord, a notice saying that we want to beautify the rest of the water body. Then I am showing your lordship proof that wherever there is water, they are taking that also out. And court will not do anything. It is a matter between your lordship and them.
Okay, the matter is fixed on 17th. No?
At 2 p.m. your lordship.
At 2 p.m. Like, come on 17. Come on 17.
But if they take out the water completely by then.
Already fixed, Mr.
Your lordship-
Chaudhary.
Already?
The matter is fixed on 17 at 2 p.m. Let come. If they
No, but-
continue
In
with the
order
court
to-
fine, then they have to bear. They have to face the consequences.
order to restore
You
the
have
water
brought a
body-
notice of this court. In spite of that, if they're continuing with and the court find that they have violated, then they have to face the
Your lordship,
consequences.
your lordship.
Lord, may I just indicate, Lord?
I have decided that I will not be incited. So, my lord, I have become very, my lord,
Come on, 7.
docile
Come on,
today.
7.
But, my lord, I must tell your lordship, sometimes, even as, my lord, officers of your lordship, when you see, my lord, persons with political influence trying to, my lord, overreach this institution, your blood curls and you get excited.
Correct.
Something must be done, my lord.
That's a
I've
come on,
got
7.
6 orders.
70.
I can't
Lord,
implement.
may I just indicate one thing, Lord?
I will hear you. I will hear you. That's what I'm telling. If this
Let them take out the water.
If this
Let
court
them.
fine
I will come on the 7th. Let them take out the water. It will be at their peril.
on that day, fine. Then let's see what can be.
Yes.
Though
Milord, may I just put a supplementary affidavit on record? I've given it to your lordship. I'll give my learned friend a copy.
matter is already fixed on 17th of December
What is it
2025 at 2 p.m. But the learned counsel for the petitioner has mentioned the matter for preponing of hearing. This court find that already the matter is fixed on 17th of December at 2 p.m. Let the matter appear on 17th December, especially fixed matter.
Milord, I'm filing the supplementary, Milord.
The affidavit
Your
filed by
lordship,
the
in that
petitioner.
case, I will be required to file my opposition because in
Do
my
whatever
earlier
you want to.
opposition, your lordship, they have yet not used any reply, your
File
lordship.
the supplementary
matter is fixed on
affidavit after
17th.
serving the copy to the learned counsel for the respondent. Let the same be kept with the record. Let me see
Yes,
whether
yes.
it can be.
My request to your lordship is, Milord, if your lordship finds that, Milord, my clients.
Please make sure. I am again telling in the open court, if this court finds, then you will be in trouble.
Your lordship, your lordship.
No, something.
To restore the water body, mud is to be taken out.
Whatever
your
it may be, if
That
this
is-
court
That
finds,
is the process, your lordship.
then it will be a problem
Your
to
lordship.
everybody. I am not bothered who is there.
Yes.
I am not bothered.
Milord, it's a collection of councillors from all over Kolkata.
Application is there. Why you are in hurry of this all the things? Let the court
Your
decide
Yes.
if you violated or not.
Terms of the order of 8-member committee.
Maybe
That the water body
once.
has to be restored.
That's why I'm telling. Once the
Milord.
matter is before this court, why you are
He's
you are
politician,
agitating
advocate.
all these things? If
He is everyone.
let you wait, and
Milord,
that's why I'm again and
this
again
is,
telling
Milord,
you.
this is the star accommodation in Calcutta.
The water body is being restored. For that, your lordship, the water has to be taken out so that the mud is removed. The mud is removed, your lordship. Then the water is filled up
Come on
again.
that day,
Milord,
come on
The
that
entire
day.
Bukil Pedi will
Milord,
be
this is this
This won't be able to
illegal
restore it.
structure houses, Milord, councillors from all across Calcutta. Star accommodation.
Okay. Come. You will get as
Yes, I want.
you will get
Milord, I have no political influence, Milord. What to do? I was additional government leader. I ran away. And that's a separate story.
Okay, thank you.
I am for the petitioner, my lord.
Yes.
It is the application for restoration, my lord. A bit of service.
Why you not appeared on that day?
Well,
2024, 11/2024. And when you file this restoration?
yes, my lord.
December. Till that
for
day,
my
the restoration application, why you are not pressed for this application since 2024?
My lord.
December 2024, you filed an application for restoration.
Yes.
November, it was dismissed. And now we are in December, 1 year you have waited for the restoration application. Why you not mentioned? What is the application? What is the prayer in the writ application? What is the writ application for? Ultra-virus. You have challenged the virus in the FSSI
Yes, ma'am.
and dismiss, and you are sleeping on the matter.
My lord, kindly.
Are you serious in the matter?
Yes, my lord.
I am not allowing, because you are challenging the virus and 1 year passed, matter was dismissed. Now after 1 year you woke up and finally mentioned the matter for restoration.
There was misunderstanding between the.
What is the misunderstanding?
There was a delay in the communication, my lord. That is fault. But my lord, kindly.
You challenge the virus of the act.
Yes, my lord.
Then,
My
and
lord,
the
there was
when the
delay in
writ petition was
communication.
filed, 2021.
2021, my lord.
Sorry,
My lord, kindly,
Sorry,
my lord, kindly.
this practice I know.
No, my lord.
2021 you filed that application, 2024 dismissed, 2025 you are
There was
pressing
delay
for
in
the
the
restoration.
communication with
And
the.
again it will restore,
No, my
then it will go to the 1000 number, then you will sleep over the matter.
No, my lord, kindly fix it in the January monthly list. Kindly, my lord.
Why January? I am fixing day after tomorrow for hearing. I will not restore, I will fix for hearing, then I will take the restoration application along with your merit. If you are ready, I will allow, otherwise I will not allow.
My lord. Kindly give some time, my lord. Kindly
No,
give
no time. If we are ready on Friday with the matter for hearing, I will keep this application for hearing. Otherwise, I am dismissing your restoration application with the full on full merit.
Well,
Tell. It is up to you.
The restoration application has not even been mentioned once. They've given notice of mentioning twice.
No,
They've
my
not
lord,
come to the
notice
court
has
to
been
mention.
given, my lord. Notice
I've
has
been present both times.
That time I will see to
Notice
the
has
notice
been
has been
given,
given or not given. I am giving the option. You are coming on the. I am fixing a date in the next week,
My lord.
15 or 16. You come ready.
My lord.
The petitioner has filed the present application for restoration for recalling of the order dated. Where is the order?
Lord,
And
20th
restoration application must file whom? Who has filed the restoration application?
By the petitioner.
Filed an application for recalling of the order dated 2011-2024 for recalling dated 20, wherein this court has dismissed the writ petition for default on the ground of non-appearance of the parties on the call. This court find that the writ petition is filed in the year 2021. Since then, the petitioner is not able to mention the matter for early hearing. In the month of November 2024, the writ petition was dismissed for default. December 2024, the petitioner has filed an application for restoration. 1 year, the petitioner has waited, has not mentioned the matter for hearing of the restoration application. Now, after a year, the petitioner has mentioned the matter for hearing of the restoration application. This court finds that the matter is filed of the 2021. This restoration application will be taken up along with the writ application on एक डेट दो कौन सा डेट खाली है कौन सा डेट खाली है नेक्स्ट डेट में फिफ्टीन 2 बजे कौन सा खाली है खाली है 15 December at 2 p.m. is especially fixed matter.
Lordship,
The petitioner is directed to inform the other side and to file affidavit of service. Yes, next.
I'm on behalf of the petitioner, affidavit of service.
Give.
Lordship, that on 1st September 2025, Lordship, matter was listed as item number 292, Lordship, in the monthly list. And the matter called up suddenly for hearing 24th October 2025, after vacation in the first date of her Lordship of the Honorable Justice Amrita Sinha. Unfortunately, on that day, the learned advocate on record of the petitioner was out of city. For that reason, the learned advocate of the petitioner requested one of his fellow learned advocate to seek adjournment on his behalf as and when the matter will be called on. However, the matter was called on. The said learned advocate was on his legs before another.
What is the prayer in the writ petition? What is the prayer in the writ petition?
Writ petition is this is the matter of PH, Lordship.
Huh?
PH.
What is your relief in the writ petition? Tell me.
Relief. Kindly come to page, Lordship. Page number 5, Lordship.
Page number 5.
Of the can.
Having the writ petition?
Yes.
Yes. Show me the where is the prayer?
Yes, Lordship.
What is the prayer?
Prayer is, Lordship, a writ in nature, page number 13,
a writ in nature mandamus directing the respondent authorities to investigate the allegation of illegal land registration and unauthorized construction, direct the respondent to ensure that construction of the water supply station is carried out on legally acquired land as per the regulation of the Jal Jeevan Mission project, and to halt the ongoing illegal construction of water supply station, and to consider the petitioner's offer of valid land for the project. C, a read in the nature of the searcher, you are directing the respondent concern read and in its nature of the searcher
where is your offer? Where is your offer? Where is your offer?
Yes, Lordship. Page 29, Lordship. 28. 1 minute. Page 29, Lordship, P3. My representation, Lordship.
What you have prayed for in the representation? What you asked for in representation?
Representation, Lordship. এত দ্বারা আপনাকে জানা যাইছে যে মৌজা গোয়ালিন, this is one, it is the matter of the project PHE group, PHE's project, water project, Lordship, and massive irregularities and corruptions are going on there. Where land is allotted.
Who are you?
I am the local citizen and the
Go to the public interest litigation
and
the writ petition.
Because
if you are taking the cause of the total society, go to the
I will satisfy on the hearing, Lordship.
Satisfy
Lots of arguments are there, Lordship. Kindly fix any date.
No, I am hearing now. Otherwise, I will dismiss your restoration application.
Lordship, now I have not prepared all the facts for registration. Lordship, kindly allow, Lordship. I will satisfy your Lordship.
The petitioner has filed an application for.
I will satisfy.
Order dated 24th of October 2025. The petitioner submitted
with judgments, Lordship.
The matter was listed on that day. The matter was listed in the monthly list at serial number 292. But all of a sudden, this court has taken off her hearing, due to which the learned counsel for the petitioner could not able to appear before this court. Accordingly, the petition was dismissed. Today, when the application was taken off her hearing, this court has requested the petitioner to argue the matter on merit so that the writ application along with the can application can be disposed of. The learned advocate is not ready to argue the matter on.
Lordship, kindly, Lordship, kindly, Lordship, kindly allow, Lordship. I will satisfy, fully satisfy, Lordship. Lordship, kindly allow, Lordship, because of after vacation, this was the first date, Lordship, and it was dismissed, Lordship. Kindly allow, Lordship. The petitioner will suffer, Lordship. Kindly allow, Lordship. Honorable, the massive irregularities and corruption are going on there, Lordship. Kindly, Lordship.
My Lord, with regard to one of the bank accounts not being defreezed, my Lord, and being frozen by the bank, my Lord, we have approached your Lordship. My Lord would recall, my Lord, the private respondent had preferred a petition under the. We have now settled. Now we have settled. I am out on bail. Now, my Lord, I am only beseeching your Lordship. Now there is no impediment for my bank account to be defreezed. Settlement has been done, my Lord. This is the documents pertaining to that. I am now on bail. My Lord, everything is now, my Lord, between the parties, everything is more or less, my Lord, the issues have been rested. But that was never the case. The Arbitration and Conciliation Act, that was dismissed for default. Subsequently, I came to learn on the last occasion that all of a sudden a case was started and I was arrested. Then now I've been released on bail. The parties have settled the issue. Now, my Lord, may kindly, my Lord, directs, my Lord, the bank, my Lord, to defreeze my account. That is my only prayer, my Lord, before your Lordship now.
Who is for the bank?
The bank had not appeared. Your Lordship had asked me to, my Lord, serve upon them. I've done a hand service. They did not appear. My Lord, they've chosen not to appear.
The complaint which was lodged also, we communicated to the RE, but there was no response to that effect. So on the last occasion, your Lordship had taken note of in the order.
The petitioners are agreed with the action of the Axis Bank on the ground that on the action of the Axis Bank on the ground that on the basis of the complaint of one of the partner of the petitioner's partnership company, the Axis Bank has freezed the account of the partnership company. And when the petitioners have made a complaint and made a request to the Axis Bank has not defreezed said account according the petitioners of the present application. Full stop. Since 12/11, since beginning, the Axis Bank is not appearing before this court. Full stop. The matter was taken up for hearing on 12th of November 2025. This court is of the view that one opportunity is to be given to the bank, and accordingly, the petition is directed to issue notice upon them. In terms of the order dated 12/11/2025, the petitioner has issued the notice upon the bank, but in spite of the receipt of the notice, none appears on behalf of the bank. Full stop. This court finds that the private respondent had initiated a proceeding under Section 9 of the Arbitration and Conciliation Act against the petitioners before the London District Judge Alipo. But subsequently, the application under Section 9 was dismissed for default by an order dated 26th of 11/2020. In the meantime, the private respondent has also initiated a case against the petitioner, wherein the petitioner was arrested and now the petitioner has been released on bail. Today, when the matter is called, the petitioner has handed over a memorandum of understanding entered between the petitioner and the partner.
Yes, my lord.
The partner.
Respondent
Dated
6.
Respondent number 6, my lord.
partner, that is the respondent number 6, dated 3rd of December 2025. What do you mention here?
Lordship will find, my lord, it has been amicably settled. And
In the memorandum of understanding, it was agreed between the parties that the differences between the parties have been settled. Yes, madam, what is your submission?
I know the same which I had indicated on the previous occasion, that it is for the RE to respond, but we haven't yet heard from the RE.
Learned Counsel appearing for the RBI submits that the bank has not made any complaint, made any response to the RBI, and as such, the RBI is not in a position to give any
Closure to the complaint. Closure.
close up to the account of the petitioner, which has been freezed by the Axis Bank. Full stop. At the Learned Counsel for the respective parties, this court finds that on the basis of the complaint of the respondent number 6, the bank has freezed the account of the petitioner. Now the petitioner and the respondent number 6 have settled their dispute. Thus, settled their dispute. The bank has also not come forward before this court with any report that the account of the petitioner has been freezed by an order of any court. In view of the above, the bank is directed to defreeze the account of the petitioner being account number
921
2102016154322 and to allow the petitioner to operate this bank. Allow the petitioner to operate this bank. WPA number
deeply grateful, my lord. Deeply grateful.
Item number 3.
I am for the petition.
Yes.
I'm led by Mr. Kundalia. Kindly password, short password now.
Let me start with
My learned senior friend have already submitted on the last occasion, my lord.
I mean, that's quite few days back. My lord, the petitioner is.
But he is asking password.
But the only difficulty is, my lord, the matter has been fixed today before their authority.
Now already instructed not to proceed. Only because the matter is sub judice. should not, hearing should not be done. I have already instructed my lord.
My lord, may he come back at 1,
At 12?
12?
Deeply obliged.
মানে কিছু হবে না বলে দিয়েছি এটা ভুল বাদ ভেরি রং যদি কিছু করে
Item number 8. In this matter, my lord, Mr. Vishwabroto Basu was engaged as a state advocate. And now he has been defended and I have been given the brief. This is voluminous brief, my lord. May I get 1 week time, my lord, to prepare myself, my lord, if your lordship kindly considers me, my lord.
My lord,
If my learned friend has no objection, my lord.
since it is on my learned friend's personal ground, I don't have any objection. But the only problem is the authorities have withheld the PCPNDT and clinical establishment license of my client, for which he is not, he is unable to operate his pathological center and continue with his consultation service since 2018. He is suffering financially and mentally.
When you will be able, you will be ready.
Any day next week, subject to your time convenience, my lord.
As per the prayer made by the council for the.
আপনার কাছে কি সাপ্লিমেন্টারিটা আছে
Supplementary. Let the matter appear on 16th December under the same heading.
না 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 কবে থাকবে 16th of December.
I'm grateful.
My lord, in this matter, supplementary, there was a permission of filing supplementary.
You serve the copy. You serve the copy.
I'm serving it. তোমাকে দেয়া রয়েছে দেয়া না
Item 9, my lord, I appear for the petition.
Yes.
Please see the order dated 12th of June 2025. My lord, may I read it? Second page.
For inspection, ascertain the region under this connection from the latest. Who is for the CSC? Nobody.
But before mentioning, I have served notice to the private respondent as also to the learned advocate of the CSC.
Is any inspection was carried out? Have you instruction?
Inspection was carried out, my lord. We are yet to receive a copy of the report.
Kindly pass for my lord, in this matter, Shumon Ghosh is appearing.
Correct.
Pass for my lord, kindly pass for.
Inform, I am passing it over.
My lord, can it be taken up subject to my lord's convenience at 1 p.m., my lord?
1 p.m. Come at
1 p.m. Acta Shuman.
My lord, I'm appearing.
I am for the petitioner, lordship. Lordship, yesterday the matter was taken up by your lordship. Lordship, the matter was hard. Lordship, the CSC authority took time to take instruction whether a separate block meter can be provided in the name of the petitioner.
Congested area, my lord, and as per regulation 53, section 18, my lord, block meter is.
Lordship, I am praying for block meter, separate block meter. I am ready
Block
to
meter-
take the block meter.
My lord, block meter is, this is his regulation, my lord. Safety and security, my lord. My lord, petitioner resides a very small place, my lord, small room, my lord,
But whatever it may be,
and tile shaded, my lord.
Lordship, every
cannot
establishment
deny
is tile shade in the city.
My lord,
and
safety
you
and
deny the electricity connection.
no, my lord.
Lordship,
we
with
are
a separate
providing
block
connection,
meter,
my lord,
separate
but
block meter
convert the
Lordship.
convert the block meter, my lord, existing meter, from the existing meter, we convert the block meter, my lord.
Lordship, there is no provision in any regulation or any electricity act, any section, Lordship, to convert a meter in someone else's name, Lordship. Can two persons enjoy same meter, Lordship? I am putting this question to myself, Lordship. I am a separate entity living there, Lordship. I am praying for separate domestic connection, Lordship. May a block meter be installed in my name? I have no problem, Lordship. Lordship, but conversion, Lordship, father has
This
no.
is slum area, my lord.
Lordship,
Slum area, my lord.
Can be done.
My lord,
You are right on your way. They are also
my lord,
entitled to get
for the purpose of
electricity.
safety and security, my lord.
Huh?
Safety and security, my lord.
Correct. But what can be done? Now
But
the society is like that.
We are provide meter, my lord, from the existing meter. We convert the block meter. My lord.
There is no provision in any regulation, Lordship, to convert an existing meter into a block meter. Only provision is there in if it is a congested place, block meter will be installed. But there is no provision to convert a existing meter into a block meter, Lordship. And they have not provided any block meter to the premises, 25 single meters. Now, in my case, Lordship,
25 meters already existing, my lord.
they have provided. They have provided.
Give you another one.
My lord,
25 is
safety
already
and hazard
there
and
will be
safety
one,
and
one
security,
another
my lord.
meter.
Safety and security, my lord.
So how it can be solved?
Lordship, I am praying separate block meter be installed. I will comply with all the formalities, Lordship. Lordship, primarily when the writ petition was filed, they have stated that in their reply, I am getting connection from someone that was they rejected. Thereafter, filing the application, now 25 meters conversion, everything came up.
The petitioner has filed the present writ application, praying for direction upon the respondents for providing new electric meter in the premises of the petitioner. By an order dated 17th of July 2020, this court has called for a report from the CSC. The CSC has submitted the report.
But the reply has also been filed.
Stating that during the inspection, it was found that the petitioner is residing in a very small shed, a small room, shed at all, along with his father, and presently is getting the supply from electric meter from the meter number 6095525, having consumer number 0223501600003, standing the name of his father. It is further stated that there are altogether 25 meters in existing in a common meter board, and the landlords have strongly objected against the installation of another meter in favor of the petitioner. The counsel for the CSC has relied upon clause 18 of the West Bengal Electricity Regulatory Commission dated 2nd April 2013, wherein it is mentioned that in basti, markets, etc., where it may not be possible to segregate one consumer from an adjacent consumer because of existence of very large number of consumers in a relatively small premises, and where because of multiplicity of the wiring of such a large number of consumers, there may arise fire and safety hazard, the licensee may affect supply of electricity to all consumers of the intending consumers through a suitably located common meter of adequate capacity to be known as a block meter.
My lord, father and son, my lord, the name of the father and son.
I recorded.
Yes, ma'am.
The petitioner has filed exception to the report stating that he is not residing with the father. The father is residing and the petitioner is residing separately, and he is not having the electric connection in his premises. He has relied upon the judgment passed by the larger bench of this court in the case of Abhimanyu Majumdar versus Superintending Engineer and others, reported in 2011, Volume 2, CHN, and submit that even the illegal occupier is also entitled to get an electric connection. Coolest. Until and counsel for the respective parties furnish the material from record and the report submitted by the CSC. The specific objection raised by the CSC that there are already 25 meters are in existence from the common meter board, and the landlords have raised objection for installation of another meter in favor of the petition. Coolest. The authorities have stated that the petitioner is residing with the father and father is having the electric connection in his name. But the petitioner is denying that he is not residing with the father and residing in a separate premises. Considering the above, this court finds that every person is entitled to get this court finds that the electricity is essential for the human being, and it is a specific case that the petitioner is not having the electric connection. Accordingly, the respondents are directed. Who is the respondent number?
Respondent number 2, Lord.
Respondent number 2 is directed to provide the electric connection to the petitioner on compliance of all formalities.
Grateful, Lordship.
Within a period of 4 weeks from the date of receipt of this order.
My lord, father and son, my lord, from the existing meter, we convert the block meter, my lord.
Yes.
Grateful, Lordship.
My lord, kindly record, my lord.
I have recorded your submiss.
Grateful, Lordship. Extremely.
11, I appear for the state lordship.
Yes.
My lord, I am for the petitioner, my lord. My lord, what happened, my lord? My lord, petitioner who applied for, my lord, Pradhan Mantri Awas Yojana sometime in 2021, and a roster has been prepared declaring, yes, he is a beneficiary to have the fund allotted to the concerned persons. My lord, kindly have a look, my lord. My lord, kindly have a look to my annexure, my lord. P1 first. P1, my lord, left hand side against serial number 5. 5, it is 14. My lord, against serial number 5, petitioner name is appearing in the year, my lord, February 2020. My lord, kindly have a look, petitioner name and the list under serial number 5.
11, 12. What is your name?
My lord, my name is, my lord, Mukuluddin. My lord, here Mukur, but father name is same, Aadhaar card number is same. My lord, kindly have a look. Now, my lord, next page 93. Next page, serial number 93. Sheikh Shukur.
Next page.
Next page.
Serial number 93.
93.
It's not there in my brief. Okay.
Sheikh Mukur. My lord, what is relevant, my lord? Amount 1,20,000.
Just a minute. Pradhan Mantri Yojana.
Pradhan Mantri Yojana. But kindly now look, my lord. P2. My account detail of
Sir, please. Page number 15, P1 is the list of the approved name of the approved persons in whose favor the Pradhan Mantri Awas Yojana has been approved.
Yes.
Now you are relying upon 93. What is the 93? That is also the approval.
Yes.
Serial number 93.
93.
What is that? List of the Pradhan Mantri Yojana in Sangathan?
Sheikh Mukur.
Yes. What is 93 and what is the difference of serial number 5 and serial number 93? What is the difference?
Well, this is, my lord, actual sanction or approved details. This is actual sanction.
No, same. Both. Kindly see the caption.
Same. So from this, it can be submitted before your lordship that petitioner was one of the beneficiary under that scheme who is entitled to that amount. Now, my lord, kindly see that amount 1,20,000 has been, my lord, this page 18, annexure 2. I have to furnish the bank details, my lord. This is my bank detail account number whose last 4 digit is
0181. Right hand side, third item.
Yes.
My lord. Now, my lord, kindly see in whose account the amount has been credited. Page 21.
Page 21.
21.
Yes.
But kindly see, last but one series, last 4-digit account number.
Where from your
From right hand side, last but one, from right hand side, top. Last 4-digit account number.
Page 21.
21.
Page 21 is the table.
Yes, table. Table. One serial number 1, 2, 3, 4. Fifth column.
208.
4-digit account number.
2085.
Yes, my lord. Now, my lord, kindly match it whether the proper recipient, proper beneficiary account.
But kindly see the second.
Yes.
The WB number 52.
521463. This is the actual approved beneficiary registration number.
So 521463.
This is tally.
Where it is telling? Kindly come to the where is it is telling? Beneficiary number? Kindly come to 3245432. Your number is different.
Sanction number.
Your number is different.
Yes, my lord. So, sanction number, kindly see sanction number. Sanction number, kindly see sanction number, page 17. Sanction number, my lord, against 5, WB06 002 3/1774.
Where from you getting? 1774. Correct.
It is 1751. This is 1751.
1751.
Beneficiary.
Okay, let me hear the status.
Firstly, Lordship,
1751. Seta kothay?
I apologize because I have taken a picture from the soft copy, though it has the official stamp and seal.
So, my main thing is
let me see what is the
Lordship will come to point 2. There is no question of application as all households were surveyed and eligible beneficiaries were incorporated in the said PWL list of Pradhan Mantri Awas Yojana scheme. Then 3. The name of one Sheikh Mukur, what the petitioner showed matches with this, Lordship. Sheikh Mukur, son of such and such, is there, bearing RHS ID number such and such. But there was no person found named Sheikh Mukur at Hamidpur village in the Satisthan Gram Panchayat. In fact, there were 2 persons whose father's name is Dhanaula. One is Sheikh Mukuluddin, who is the petitioner in this case, and Sheikh Shukur. As per local inquiry, it is found that Sheikh Mukuluddin, the petitioner, has a Pakka house at present. So the fund was allotted to Sheikh Shukur, the younger brother of the petitioner. The local representative deemed fit. This has been done for better utilization of public money. And then a summarization. He owns a Pakka house. Since he owns a Pakka house, he is not entitled for this scheme in the first place. And this was never sanctioned in favor of the petition from the very beginning. So there is no question of crediting this account to his bank account.
Yes. My lord, kindly see in our document, my lord, this 1751 against sanction number in other document, Ravi Karmakar's name is not appearing.
No.
So
have you got the report?
No, I haven't.
Give the report. Go through the report. Their contention is that there are there are 2 persons in the name. And what is your name on inquiry? You are having the Pakka house. Your brother is not having the Pakka house. The Pakka house has been
No, my lord.
And see, if you take the exception, you file the exception.
In connection with WP, the matter.
Clause 3. Read the clause 3, clause 5, clause 7.
Son Baba Namta Dekho, Dhanaula is there in the PWL list, our regional list, but there was no person found named Sheikh Mukur at Hamidpur village in the and Gram Panchayat. In fact, there were two persons. এটা কি ঠিক? There whose father name is Dhan.
Yes, you go through the Learned Council for the state. You're for the state.
I'm for the state lordship.
State has filed the report after serving the copy to Learned Council for the petitioner. Police Learned Council for the petitioner prays for take action. The report he filed. How many? Within a week?
2 weeks.
2 weeks.
Then that
Make
side,
it 1
that
week.
side of the vacation lordship.
Then
That side of the vacation.
Make it 1 week.
Within a week, let the matter appear on
Honey.
23rd December under the same heading.
Grateful lordship.
12th, my lord. I am for the petitioner, my lord.
Yes.
What happened, my lord? A person, my lord, who without belonging to the scheduled tribe, my lord, after my lord having a first certificate, scheduled certificate, my lord contested the Panchayat Samiti election in 2023. My lord, the local person who belong to scheduled tribe community, my lord, they complained it. My lord, kindly have a look, but they say
So what you have prayed for?
I prayed for that he, my lord, by practicing for upon the community original who belong to scheduled caste, scheduled tribe, my lord, by impersonification of the caste and take benefit and contested the election of Panchayat Samiti.
Go to the election petition. How the writ petition?
And other benefit he also, my lord.
Maybe other benefit, but you are challenging the election. He is not a scheduled tribe, scheduled caste and scheduled tribe.
He
Correct. He got the false certificate and he got the seat for the scheduled tribe quota and he elected.
And
This is your case.
And my lord,
So you go to the election petition.
my lord,
How the writ petition will lie?
the election is over. My lord, 23, my lord,
So you wait for the next election.
my lord, all my lord,
The writ court cannot entertain your application, sir.
my lord, all
Bad advice.
my lord, it is sheer deprivation to the community, my lord. The person who belong to actual scheduled tribe.
Correct. I fully appreciate. I would have been in the election petition. I could have been granted relief to you. But sitting in the writ jurisdiction in the election
At
petition,
any
this court
form, I am
cannot.
before your lordship.
But
I am complaining the fraud.
But there is a procedure of the determination. I am not having the determination of the election petition. This is not the election petition. Say what you will do. Continuing with the writ petition. And you also cannot file the return, the election petition.
My lord, kindly direct the video concern, my lord, to verify SDO concern to if his
But your case is different. No? Your prayer is
my lord,
different.
kindly see my prayer, my lord. I have made that.
You have not made a
My lord, a
representation.
writ of mandamus must be issued against the concerned respondent by directing them to as to why they will not be show cause for not taking any steps against the private respondent even after receipt of complaint. Series of complaint, my lord, before my lord election, complaint by the petitioner and other inhabitants. I am not one and only person. That community, my lord, complained against him, my lord. Inhabitants of locality over the participation contest election, Panchayat Samiti.
But so you want to prayer be?
Prayer be, my lord. I am not pressing now, my lord. This is my lord. Something, my lord, my lord, invading the legal right of the actual, my lord, person.
Which for the private respondent? Yes.
I have obtained certificate copy from the concerned, my lord, SDO, my lord, gas, my lord.
So he is not pressing the prayer be. I am directing. Where is your representation?
My lord, page SDO. My lord,
Statement of representation.
page 15, my lord. 15, my lord.
Who has made?
My lord, kindly see page 15, read sweet fast.
My lord.
Who has made the complaint?
Yes, my lord.
Who has made the complaint?
Saumendranath Bera.
Saumendranath Bera.
Who is the petitioner?
My lord, yes, my lord. Another person, my lord.
Dipal Malik.
So he is my lord relation. My lord, relation of the private respondent.
But why he has not come?
My lord, kindly have a look at the contents, my lord.
Maybe you are not made a where is your representation?
Name.
My lord, kindly have a look, my lord.
Nothing.
My lord, yes, nothing. P3. P3, my lord, Ashok Baul Das, who
Yes.
belong to the
My lord, he is not the writ petition.
Maybe
This is representation of
P3, my lord,
yours.
kindly see P3.
I am there.
Yes, P3, my lord, kindly see.
My lord,
Whose
my
representation
lord,
is this?
petitioner is also not the contesting candidate also.
Ashok Baul Das, Ashok Baul Das.
So, Ashok Bauda is not here.
Same community.
The petitioner has filed the present application on the allegation that the private respondent has obtained scheduled tribe certificate.
Yes, ma'am.
Yes, yes.
Scheduled tribe
caste.
certificate.
The
Scheduled caste or scheduled tribe?
Scheduled caste.
Scheduled caste certificate illegally and has contested the Panchayat election.
Panchayat Samiti. Yes.
Panchayat Samiti election. Panchayat Samiti election. He submitted that when the petitioner came to know, he has reported the matter to the authority, but the authority has not taken any steps. Learned counsel for the state submitted the petitioner has not made any complaint to the concerned authority. The complaint relied by the petitioner or is of the third persons. He further submit that the prayer B of the present writ application is connected with the election and the writ court cannot decide the election under Article 226 of the Constitution. Learned counsel appearing for the private respondent submit that he has obtained the certificate of scheduled caste from the concerned authority in accordance with law and accordingly he has contested the election. Please heard the learned counsel for the respective parties. This court find that the petitioner has disclosed 3 representation, but none of the representation is filed by the petitioner. Prayer B of the writ application reads as follows. Inward comma, this court considering the above, this court find that the petitioner by way of writ application challenging the election of the private respondent which is not maintainable. Accordingly, the writ petition is dismissed.
Grateful, mate.
Sir, I appear.
This is a matter wherein, Milord,
Yes.
I am challenging the very initiation of a particular, Milord, notice at page, Milord, 21. This is in Bengali. What I did, I am handing over to my lords, Milord, a English copy of the notification, because now, Milord, this is being done by the Google. Now, why I say, kindly see that this notice was issued in connection with selection for the post of superintendent. Now, this was issued by the chairman cum convener and the BDO.
Advisory.
Chairman cum convener, advisory committee and the BDO. Minor block. Now, kindly come to the constitution, which is given at page 22. Page 22 of the writ petition, your lordship will be pleased to find that who are the persons in the advisory committee in urban areas.
Sub-regional officer, representative, the district inspector.
Now, this member convener, he is the headmaster or teacher in charge in item number 5, your lordship will be pleased to find.
Headmaster or teacher in charge had the.
Now, instead of the member convener, the chairman come Milord, the chairman come convener and the BDO Milord had issued this particular notification. Kindly see 5 as well as the notification. Five dada is it?
Yes.
So
convener is the headmaster.
Yes. Now, if I Milord, if I compare, my lord, this page 22 with the recruitment, with the notification at page 21, I find, my lord, that this has been done by an improperly constituted person or a person who has no authority to do it.
Yes. Recruitment over.
My lord,
Process is over.
recruitment process is over.
Appointment
My lord,
made.
yes.
Appointment made.
Not joined.
Yes, sir.
And another condition, my lord, sorry, my lord, just
Yes,
a second. My lord, I'm sorry, my lord, I'm troubling my lords, my lord. Page 25 also kindly see, my lord, this is also a particular, my lord, clarificatory notification issued on 18/6/2025. My lords will be pleased to find from page 24.
Yes.
It is a clarificatory notification, 18/6/2025.
Yes.
Now, kindly see the last paragraph. The criteria, my lord, which has to be fulfilled has been stated.
Yes.
Then, at page 25, to add to the above, I am further directed to mention that during the selection process, care should be taken to ensure that candidates who are familiar with the language, cultural ethos, and milieu of the prospective residents of the hostel are given preference, so that the children coming from tribal families are not put into a total foreign environment, and there are no gaps in the understanding between the people taking care of the children and the children and their families. Now, my lord, I find this condition which has been given had also not been indicated in the initial notification, that is, my lord, at page, my lord, 21. These are my submissions. First of all, my lord, this has been issued by an improperly constituted person.
Yes.
Could I now answer to the two questions? My lord, he has referred to page 22.
Yes.
Page 22, he has shown advisory committee in urban area.
Correct.
It's not in urban area. Kindly skip to the next page.
This is rural. Yes. Yes.
I'm sorry. This is rural area.
Yes, my lord, he is correct. He is correct.
My lord, I believe.
Yes, continue.
So, my lord, concerned block development officer BDO is the chairperson.
Correct.
And second point, he is saying about page 24 and 25. 25, he is saying that person knowing, my lord, the familiar with the language and culture would be given preference. Preference. He is saying the notification was issued on 7th of January 2025. My lord, I am handing up the copy. It is at page 25 of the bunch.
Page 25.
Yes. Bottom is the page marking is at the bottom. Sorry, my lord. This is on 7th of January.
Yes.
And he is referring to, my lord, the clarificatory notification at page 24 is on 7th of on July. This is in August. I understand. June, 18th of June 2025. So he is not a candidate. He has not applied for. He would have, if any person having the knowledge of, my lord, local language and ethics would be getting preference. Without applying for, you are coming and saying that clarification notification has not been given. Notice was issued in January, and clarification has been given that preference would be given.
When the notice, this notice was issued, when the recruitment notice was issued.
7th of January 2025. And my lord, only one thing I add, that
Well,
suppose.
let me complete.
Oh, I'm sorry, my lord.
7 January 2025.
25.
This the recruitment notice was issued.
Yes.
Yes.
Correct. And clarificatory was issued in 8 to 18.
Preference would be given.
So you said that is not applicable in.
No, even if it is applicable, preference would be given.
Huh?
One has to apply the and, my lord, claim for that. I am getting. I know the language. This person also knows language of the local. And, my lord, selection has been completed. My lord, engagement letter has been issued. Headmaster is not allowing, my lord, he is
permitting me to join the school. Reminder after reminder given by the video to the headmaster. What is the use of not allowing me to join the sport? I am the first candidate in
Milord,
interview.
Milord, if I am an aspiring candidate, Milord, if I make an application and my candidature is considered, Milord, automatically, Milord, my lords have laid down the law that, Milord, once a person, Milord, makes an application and participates, his right goes. And then, Milord, I cannot raise an objection.
He has no qualification as for advertisement.
He has not participated.
He has no qualification for computer with 6 months experience.
Milord, no particular submission is made with regard to the constitution of the particular, Milord.
I have made.
The constitution of the particular committee. I'm sorry.
He has not.
Please, yes.
My lord, with regard to constitution.
You have issued the notification, a recruitment notice on 7th of January 2025. Correct. How many applications have you received?
11 applications, sir.
11 applications.
Advertisement was made in the newspaper.
What is the composition of the committee? Of
Yes, was made.
Committee?
Yes.
What are
That is at page 23.
Composition of the selection committee?
Advisory committee meeting. Advisory committee at page 36, 37.
36, 37. 36?
37.
Where is the committee? What the committee? The meeting of the advisory committee regarding what? Where is the committee?
My lord, page 21.
Page 21.
Lordship, my lord.
Again the same thing. 21.
No. Kindly come to page.
21 is the same thing. Meeting notice. Where is the committee?
Committee was constituted.
When?
Comprising video, sub-inspector of school, Moina, headmaster.
Where is?
My lord, at the top of the, my lord. First page of the instruction, kindly see. Third paragraph. Fourth paragraph. A meeting, Lord, you got it. A meeting of advisory committee comprising video, Moina, subdivisional, my lord, sub-inspector of school, Moina, West Circle, headmaster of such and such school, then my lord, inspector.
Just a minute. Video Moina.
Yes.
Correct. Then sub-inspector of school.
Yes.
Where is the sub-inspector of school?
How
the sub-inspector of school Moina will come? Kindly come to the page 23.
Page 23.
Yes. Video Moina, okay. Chairperson. Correct. Sub-inspector of school.
There is no indication.
Representative of DI?
Yes. No, that's why it's okay. Okay, I will take the sub-inspector of school as a representative of the
DI? District Inspector of School?
Where is there? Where is that?
Serial number 2, page 23 of the
representative district inspector of the school primary. So okay, is the okay. Nine.
And my lord, inspector backward class.
Headmaster.
BCW.
Then headmaster. Then inspector backward class.
Yes.
Yes.
Then my lord, fifth is the headmaster.
Headmaster. Sabapati.
Panchayat.
Representative of Panchayat.
Okay.
Everything was complied with. Newspaper advertisement was made. If you are, my lord, a fence sitter is coming and my lord objecting to a selection which has been completed and my lord, engagement letter has been issued. Everything completed. Engagement letter issued as per back. As on my lord.
Yes, Mr.
Yes. My lord, only one thing your lordship may kindly consider that this notice at page 21 for a second, my lord, kindly take into consideration. Yes. Who issued it? The chairman cum convener and advisory committee and community development officer. Now, my lord, does his name features in page 22 and 23? That is the only thing. If your lordship feels that yes, then I have no case. But if your lordship feels that no, his name does not feature, then Milord, I have a case, let them Milord reconsider the matter.
So, where is the decision? Because as per your notification and advisory.
And we also do not come to know.
As per the advisory committee, the headmaster is the member convener.
Headmaster is the member convener, yes.
Correct.
And chairperson has issued.
That's why I'm telling where is the decision taken by the chairperson will issue the notice instead of
Yes.
the convener. That is the only question raised here.
No.
How the chairman can be a convener as per your guidelines?
Yes.
The notification convener is the headmaster. That is the only.
This is the only point.
That is the only question.
No.
So
This is in rural area.
maybe
Yes.
kindly send the rural area.
Yes.
Person.
Yes.
Chairperson.
Page 23.
Page 23.
Yes, I have seen.
Page headmaster, teacher in charge, headmaster so and so, member convener.
Member convener of the advisory committee.
Correct.
Committee. But
Correct.
advertisement has to be issued by the chairman.
How? Show me if the member the chairman is not a convener, how he can issue the notice? That is the only question.
They have to take a resolution, impose the power.
So if the chairman has been given the power to hold as a work as a convener.
Just give me a second, madam. He as chairman has issued the notice. My lord, there is no defect in it.
But chairman can issue. I have no agitation.
Yes.
But as a chairman come convener, how the convener as per your
Convener would be convening the meetings. But with regard to advertisement,
sir,
he is the government officer.
Please see the 21. Please see the 21.
Yes, 21.
Chairman, I appreciate. Chairman can do, he is the higher authority, he can issue the notification, no problem. But how he can say he is the convener? That is the only question. How he can act as a convener?
My lord, chairman is the highest authority.
I am not disputing. But he can, chairman issue notice, no problem, he will go out. But how he can say come convener?
My lord, if it is written, my lord, I don't find any defect in the notice.
But he cannot. As per your notification,
or there must be a meeting for that.
As I'm asking, where is the meeting
Decision.
giving you, authorizing you to act as a convener?
At the block development officer, he has said. Kindly see.
এবং সমস্ত উন্নয়ন আধিকারিক
এবং সমষ্টি উন্নয়ন আধিকারিক ব্লক ডেভেলপমেন্ট অফিসার
Correct. I am not on that.
But I am saying, my lord.
You see, you come with the instruction whether convener, whether any meeting has been
That's all.
called, giving you as
The
a
power
convener,
to do it.
as a convener.
If he is, I have no case.
Convener. How you can because you are chairman, you can issue the notice, all the things.
Next week.
Learned counsel for the respondent is directed to produce the document so that the chairman of the advisory committee in rural area has been given the power as convener for issuance of the recruitment notice dated 7th of January 2020. Let the said report be filed on 16th of December 2025. The matter on 16th December 2025. Under the same heading.
or 17
He has some personal difficulties. My learned friend is
17. Come that on the document.
Yes,
only thing. That's all. I am
my lord, I was saying a very short point. A person without applying for an
No, that is the law. If suppose a post advertisement has been made and I am challenging this advertisement, holding that the advertisement is wrong, I cannot apply for it. Directly he has challenged. I appreciate.
It's a everything has been completed now.
That's why I am not on that.
I am for the petition. Lordship, on the last occasion, Lordship, matter was heard by your Lordship. And CSC authority filed a report. Lordship directed the CSC authority to file a supplementary report. Lordship kindly goes through the order to ascertain whether the said block meter is pertaining to the existing building or to the any other place, Lordship.
The plan is specifying that whether the meter number so and so is provided in the building where the petitioner is residing, or whether the meter is provided in some other building.
Lordship,
report is filed.
No.
This is the report, my lord.
Lordship, I have not got a copy also, Lordship. Lordship,
Divanjan Mukherjee is appearing in this matter, my lord. I will serve the copy, my lord.
the copy.
এই দেখো, তোমার কপি দিয়ে দিয়েছি। I'm sorry, my lord, I was stuck up in courtroom number 3.
Okay, no.
May I hand over an original copy of the report, my lord, and take give it?
It is there.
My lord, I've given it to my lord.
A big plot of land. We found the
My lord,
petitioner-
kindly see the last 2 lines. My lord, I think, my lord, the KMC has to be made a party to this. And will, my lord, we kindly peruse the next page and we'll see the building, my lord.
বিমল এখন আওয়াজ করবে না হ্যাঁ
ওকে দিল আমার
No. See, my question is, specific question was there. Kindly come to the, you have an order, last order,
last order.
order dated 24/11.
Hmm.
24/11. You are having the order. This court has categorically directed you to file supplementary specifying whether the meter number is provided in the building where the petition is.
Yes, my lord, we have stated that there is no meter in the building.
Lordships.
May I kindly see? May I read? During inspection, we found that the premises number such and such is a big plot of land. We found that the petitioner is residing in 2nd floor of a 4th-story building. All the 4th-story building residents are getting supply from adjacent service position of the same premises. Block meter bearing number such and such is standing in the name of Lakshmanan, Ojha and 20 other persons. Bracket, block meter is installed in adjacent service position of the same premises. No separate service connection is installed at the 4th-story building where petitioner is residing. From local inquiry, it was revealed that the 4th-story building has no sanction plan. That is the reason I submitted my lord. If the
Query
claim
was whether the said building was provided with the service connection. I have applied for the service connection. The said building has no service connection. It
Yes,
was
no.
It was my submission on the last occasion.
But it is the, without the building plan.
So that I have to take instruction.
Well, let the KMC be made a party to this.
No, see, if it.
They are the authority to say whether it is they have got sanction or not.
As per section 43, I am an illegal occupier. I am also
Whatever it may be, is in possession of the property. You have to provide.
If possession of the property we have to provide, but my lord will no, my lord, there are matters which are going on in respect of wetlands. Where are wetlands? May I submit, my lord? Therein also, my lord, we have given supplies to where, my lord, this plan has already been sanctioned. There are orders passed by this honorable court, my lord, wherein, my lord, if the building is not sanctioned, my lord, we cannot give. My lord, let the KMC be added and come and say it is an unauthorized building or not. My lord, we are here before your lordship. If my lord directs us, we will provide supply. But first, my lord, let the prima facie case be established by the petitioner whether that is an illegal building or not. Let the KMC come and say. My lord, from the photograph.
Who are you in the building? You are what the now who are you? Occupier. Who is the owner?
Owner lordship is a big plot of land. What has happened, lordship? Different developers have constructed buildings.
And more so, my lord, they are getting supply.
Different developers has developed buildings. Thereafter, they left, and petitioner and other occupiers are residing in the said building. Now, Lordship, there is a judgment by Justice Prabhusachi Bhattacharya, where Justice Bhattacharya specifically held that if the building is without sanction plan, if in settled possession occupiers, PSC has to give connection. That was against the WBSCDCL, but it is against the electricity authority. Lordship, I will come up with it. I am in settled possession.
And Manor, in the meantime, Manor will make KMC the party.
There is no 401
Respondent has filed
no demolition.
the
Manor, that doesn't mean that the illegality will be perpetrated, Manor. Manor will kindly make KMC the party.
2025. After serving the copy to the land counsel for the petition, let the syndicate with the record, counsel for the petition, place for time at 10 case adjourned. Let the matter appear on 18th of December under the same matter.
Manor, in the meantime, Manor, I will visit your Lordship. Manor, kindly make KMC the party. Manor, there is judgment. Manor, I can also bring.
Bring.
As your Lordship. Manor,
No case of
अरे judgment देना ना तो अद्भुत कथा
Yes.
May I remind your Lordship, it is that matter where the petitioners are challenging the levy of my lord facilitation fees by the state government for providing my lord online queue management service regarding export of consignment from India to Bangladesh through West Bengal. My lord, I would beseech your Lordship, my lord, if your Lordship kindly directs the state, learned Advocate General is here, direct the state to, my lord, we have got hold of most of the notifications issued by the state in this regard. If your Lordship kindly comes to page 50 rather, of the writ petition.
Page 51.
50.
Yes.
My lord, unfortunately for us, my lord, we have not been able to trace this particular notification, which is dated, my lord,
29 September 22.
notification number 3846-WT, dated September 29, 2022.
Yes.
Yes.
We checked that.
And also, my lord, the earlier
My friend wants me to supply weapons for him.
My lord, what can be done, my lord? If the weapons are hidden somewhere, my lord, the weapons are to be found out, my lord.
If it is a Brahmastra,
My lord, that has to be supplied to us. My lord, your Lordship may pass a limited direction today.
No, that is not required. My lord. If it is available, I'll pass
My
on.
lord,
That's not
kindly, my lord, record an order because my
No,
lord,
no,
very well. And my lord, then my lord, in that event, my lord, kindly keep this matter, make this matter returnable in the first week of January. My lord, there is urgency in this matter.
as per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on January में कोई date दो, एक fix कर दे.
First week, my lord, subject to your Lordship's convenience, my lord. Under the same heading. Under the same heading.
पाँच छः 6th at 2 p.m.
Yes,
6th
yes.
January at 2 p.m.
Yes, grateful, my lord.
But could it be one day before or after? Because 6th where the matter is fixed.
5th खाली है.
5th, my lord.
5th January at 2 p.m. as
চিন্তা করো না।
Very
Motivation-টা।
Yes.
Lord, I appear for the petitioner. I am filing my reply. Lord, the matter relates to refusal of renewal of passport. My lord, the fact remains that there are 6 criminal cases pending against the petitioner. One has been dropped. So there are 5 cases are pending. I have applied. My client has applied for the passport renewal. He was holding a passport which has lapsed. He has asked for renewal. Now, my lord, he was refused that get the order from the court below. Now, my lord, in one of the matters, he applied for, but the court below refused to grant him any permission. So I approached this court. My lord, my submission would be, I have gone through their report filed by my learned senior friend. It appears that I have to get permission from the court below in each and every matter.
Correct.
My lord, with that direction, let this writ petition be disposed of. I will, with this order, I will approach the court below and take permission.
My learned friend is submitting that there are 5 cases pending, but it appears from our record there are total 11 cases, and that will appear from his own disclosure of facts. So there are 11 cases. So your lordship is aware that on the question of section 662F of the Passport Act, for that benefit which was given to the citizens in terms of a notification under section 22, 570, GSR 570, there are 2 conditions laid down. So his prayer was rejected earlier by the criminal court. He has to make an application anew in all the courts. And in terms of this,
Each and every cases you have to
Yes, my
upload
lord.
your
Kindly
orders.
come to page 30. I have given the list of cases which are pending against me. Page 30 of the writ petition.
2, 3, 4, 5, 6, 7.
7. Out of 7, 1 has been dropped. That is my instruction. My lord, let the writ petition be disposed of with a direction upon me to approach the court below in all the concerned court below and take necessary permission, and that should be within a specified time.
and in the application for renewal, he has given a declaration that no criminal case is pending.
So again one case, 5, section 5 something.
Yes, my lord.
Again one case.
Again one case. But actually, no declaration that no criminal case is pending.
So that's why again one case for the wrong false declaration.
No, false declaration, no case was given. That was pending in Barasat. That next case.
No, I am telling if he has given the
We
wrong
can.
declaration.
Definitely we can, but we have not given. But actually, from my records, it appears at page 14. The declaration is that there is no criminal case pending, but kindly find that there are very well. You kindly.
I am disposing of.
My lord, with that direction, my lord, to petitioner to go below.
Praying for the direction upon the respondent number 2 and 3 for actions for renewal of the passport. Renewal of the passport. Full stop. The counsel for the petition submitted.
Kindly record renewal.
Renewal of the passport. Counsel for the petitioner submitted. The petitioner is having the passport. Is it expired or it is going to be?
No, it has expired. It has expired.
Validity of the passport is expired, and according the petitioner has made a representation and made an application for renewal, but the same was rejected on the ground that the criminal case is pending against the petitioner. ASG appearing for the respondents number.
Respondents will not
All respondents.
All the respondents.
All.
Submit that. There are altogether 7 cases are pending pending against the petition before the learned magistrate court, and the petition, if the petitioner intend to renew the passport, he has to obtain no objection from each and every cases from the learned magistrate court.
Valid for 1 year.
Magistrate court. That is different thing.
That is the court for the court to specify.
The petitioner has also disclosed the details of the case pending before the court. He submitted out of 7 cases, 1 case has already been dropped, and further 6 cases are pending. In view of the above, this court find that no order can be passed in the present application for directing the authorities for renewal of the passport as prayed for by the petitioner. But the petitioner has liberty to approach before the criminal court where the case is pending for obtaining no objection from the learned court on each and every cases. And if the petitioner obtained the no objection from the learned.
No, Kari don't record no objection. He gives permission in terms of the GSR 570 of 93.
No objection oblique permission. Permission from the learned court where the criminal case is pending.
In terms of the relevant notification.
The relevant notification dated is there, na? Dated
August 1993.
25th August 1993. GSR is same, 91 is same. 93 or
25th
25th
August 1993. King GSR number? Not there. Okay. 25th August 1993. Full stop. If the petitioner made any application before the London magistrate, the London magistrate shall dispose of the said application in accordance with law within a period of 2 weeks from the date of filing of the application.
I can now speak on
May please, your lordship.
Yes. What you have prayed for?
I have prayed, my lord, stay of the proceeding.
There is the interim order. So cause notice.
My lord, we are challenging the show cause notice because it is already delayed by 28 years.
Yes.
Very quickly, may I take you to the papers, my lord. At page 33, we were granted some licenses. We exported the goods, filed the documents with the Joint Director General of Foreign Trade, DC Part 1, Part 2 license at page 33. Lordship, look at the date, 25th August 1998.
Yes.
Now, along with that, we gave a statement also giving particulars. Next page, page 34.
This is your letter.
This is my letter, my lord. Thereafter, my lord, they issued a show cause notice.
Continuation, we are submitting here with the following document for an. Yes.
Thereafter, they issued a show cause notice. They gave a notice of hearing at page 44.
So what has happened to this notice, this request?
After we went to them, but nothing happened. Then, my lord, we find that at page 48, we came to know that some orders have been passed. We asked from them, we gave a letter that you have passed some orders. Page 46, capital A. We understand that some orders have been passed. You've got it?
46, yes.
Page 46A.
Yes.
Some orders has been passed, give us copies as copies. So, by letter dated 47, at page 47, as 47, they forward the copies of the orders.
Yes.
Lordship, can you look at the order at page 48? It is dated 1st February 2006. Lordship got it?
48.
Page 48. Dated 1st February 2006 and is signed on next page 49, 7th March 2006. That's not the charm here, my lord. Lordship comes to page 62. That was the order. And page 62 is the show cause notice which they supplied later on.
Yes.
Lordship, look at the show cause notice date, 1st February 2006 and signed on next page 63, 7th March 2006. Same day show cause notice given and same day adjudication order passed. No notice, nothing to me. Thank you. Then I came up before this honorable court, my lord. Lordship Academy sees at page 68, the order passed by this honorable court. It starts from 68, the relevant portion at 69 bottom. In the facts of the present case, Lordship got it?
Yes.
In the facts of present case, interest of justice would be subserved by requiring the respondent authorities to serve the notice of show cause. Lordship mark next portion. Order, last order. Page 69. From writ petition. Active bleeding আছে সে আবার কি এটা কোন মামলা
Document that the prosecution seeks to rely upon.
রোজারাঙ্গা দিয়েছে কেন?
Page 69. In the facts of case, interest of justice would be subserved by requiring the responding authorities to serve the notice of show cause as also all documents that the prosecution seeks to rely upon in such proceedings to the electronic mail identity submitted by petition in court V91 relief mail. Court said, they will say they have signed, you will say not received. Give an email, I'll record in the order, and they'll submit all documents and show cause notice to that email.
Yes.
But thereafter, nothing is done.
Nothing was there.
Nothing was done. Then Lordship come to page 70.
Order dated?
This is order dated
2017.
no, on the left hand side top. 2nd March, left hand side, 2nd March 2017.
Correct.
Nothing is done. Lordship can come to page 72.
Yes.
Suddenly we receive a notice, page 72. The personal hearing has been fixed. Copy of show cause notice not given. Copies of documents not supplied.
This person hearing with regard to that.
That hearing.
2017 notice.
But the court said first serve you, show cause notice be served. You supply the documents, thereafter give a hearing. Nothing done. State after logically how many years? 17 and 25. First notice in 2025. Thereafter, my lord, I point out at page 79. I point out.
Yes.
At page 79, I say I communicate the judgment at page 80 top. Page 80 top, the order I have set out. Then we record in the letter one more email, additional email ID was also provided this. Till date, no copy of any show cause notice or any document to be relied upon by the Department of Foreign Trade has been served in any of the above two email identities or on my client physically. Nothing has been supplied. Then at page 81, we last but one paragraph, we on behalf of client request you to comply with the order dated 2nd March and furnished our client copy of show cause notice and all documents. In connection thereto and all documents you may seek to rely at the time of adjudication. After serving our client the show cause notice and all the documents, kindly allow client 6 weeks time to file the reply. Some time to file the reply. My lord, they say again at page 82.
Yes.
They send a letter to the advocate. You are given an opportunity, no document, no show cause notice.
Yes.
Then, my lord, the hearing, he gave a hearing. We filed our a preliminary reply because without documents, we cannot file. In the preliminary reply, we have taken the points. Preliminary reply is at page. It's not that we are taking adjournments. Page 90, we filed a preliminary reply. There at page 95, Lordship kindly sees, you have taken legal submissions. At page 97, you have taken the point stale proceedings. Well, there is no page 97, we have specifically taken the point stale proceedings. Now, surprisingly, my lord, at page 131, the adjudicating authority himself, he became judge of his own cause and gave a reply to my reply. He records so submissions. He says that before that, one thing, my lord, page 120, I'm sorry, page 129, Lordship kindly comes. Yes. In the course of hearing, I personally went there, my lord. Their file was not traceable. There was no file to keep the order also. Then he said that to resolve the impasse, why don't you apply to customs? Customs should be having documents. I said, after so many years, you write a letter, I will pursue. That was the understanding. So accordingly, wrote a letter to the customs. Assistant Customs, page 129. Customs, so he wrote, we are granted 7 licenses. However, recently in the course of hearing, before Deputy Director General, it transfers that documents are not currently available with DGFT. Clearly, to resolve the impasse and strictly without prejudice to our rights and contention, we, at the desire of DGFT, humbly request to furnish our copies of authenticated Xerox copy of documents as per annexer as early as possible. So we wrote to customs as desired by. Now the adjudicating authority himself writes a letter, my lord. Writes a letter at page 131, it starts. At page 132, he totally takes a volte-face and he says, during the hearing, the above deficiencies in the respondent's reply were brought to the attention of learned counsel appearing before the adjudicating authority, who sought reasonable time to enable him to collect and submit the requisite documents, including evidence of fulfilled export after obtaining them from the customs authority. But I didn't ask for any adjournment. I say your proceedings have become stale after so many years because there is no period prescribed in section 14. Yes. The whole proceeding has become stale. And he recorded this. My lord, he has a preconceived mind. After this, my client obtained legal advice. He was asked to approach this honorable court. Today, my lord, let us formulate the legal issues. My first point is that the proceeding have become stale. If Lordship has the book, বইটা ছিল ফাইলে আগের দিন একটা ফাইলে একটা বই দিয়েছিলাম এই বইটা এরকমই দেখতে yes Lordship takes up section 14 maybe at page 11 of that book. Yes. Giving opportunity to the owner of the goods, including the goods connected with services or technology. No order imposing a penalty or of adjudication of any confiscation shall be made unless the owner of the goods, including the goods connected with service and technology or conveyance or other person concerned, has given a notice in hearing. Section 14. Now, my lord, there is, Lordship can see that there is no period prescribed, there is no limitation. Yes. There is no limitation prescribed. Now, where there is no period of limitation is prescribed, it must be a reasonable time. Now, what should be reasonable time depends on facts and circumstances of each case. And if there is a time prescribed in any other section of the same statute, that should be considered as a reasonable time. To that, my lord, I have cited one decision. reported in give half a minute. বইটা বার করে দে ওই আগের দিন জাজমেন্টটা দিয়েছিলাম
2014
14-1 লর্ডশিপ দাদা না না আমার মার্ক আছে না এখানে
Yes, it is here.
লর্ডশিপ half a minute.
Para
Webel
15.
Webel রিট কোথায় রাখতাম হ্যাঁ নিশ্চয়ই Webel রিট 2014-1 paragraph 15 লর্ডশিপ
Yes.
so far as the ওদের একটা কপি থাকলে দিয়ে দিচ্ছি হ্যাঁ দিয়েছো কপি I'm giving copy to Mr. Kundali I have worked as a junior to his father, my lord. How can I refuse him? If his father, his uncle, whole family, my lord. My lord, our court, my lord, I have found, my lord, is a family. It's a family. Somebody's father was my senior, then his son is my junior, and his son is my junior, my son's junior. It's like a family, my lord.
Correct.
So far as the power of the governor with regard to review of an order is concerned, Rule 31 of the rules does not prescribe any period of limitation, as in Section 14.
Yes.
Normally, when the period of limitation is fixed for exercising a power of review, the power of review should be exercised within a reasonable period from the date of the order which is sought to be reviewed. In the instant case, the governor has reviewed the order after about 5 years. In any case, the period of 5 years cannot be said to be a reasonable period. In my case, documents submitted 1998 and hearing at 2025. In any case, the action with regard to review of the order, so far as to make it effective, ought to have been passed within reasonable period, and the facts of each case was determined as to what period would be reasonable. In the instant case, this was under Rule 31, Lordship has seen. Now they look at Rule 32. Looking at the fact that Rule 32 of the rules prescribe period of 6 months as limitation for exercising power of review in disciplinary cases, one can reasonably infer that period of 5 years cannot be said to be reasonable for exercise of power under Rule 31 of the rules. We therefore conclude that even if governor has power to review the order dated so and so, which pertains dropping of the departmental proceeding initiated against the respondent, the said power could not have been exercised after about 5 years. By no stage of mentioned period of 5 years can be said to be reasonable in the facts of the case. Now, Lordship, can you look at Section 14, capital D. The Director General or an officer authorized by him may, by order, suspend or cancel a license to import or export or specified goods or services or technology without giving the holder of the license a reasonable opportunity of being heard. But such persons shall be given reasonable opportunity of being heard within 6 months of such order. And thereupon the Director General so authorize may necessary order confirm, modify, revoke such order. So, if you take the reasoning taken in this judgment, Rule 14 does not provide repetition, but 14D do provide a period of 6 months. So, in this case, the period of 6 months should be constituted as a reasonable period. Even Lordship forgets everything. The show cause notice is 2006. The order passed by this Honorable Court is 2017, and the proceeding initiated in 2025. But this is by stale, have become stale, first one. There are other issues. Secondly, the authority has become judge of his own cause. He himself is giving reply to my reply to show cause notices. And then, my lord, the documents till date he has not given. I need not cite any judgment on that, that if in a show cause notice or charge is given by an authority he has to supply the documents he wants to rely upon. Without that, more so on the teeth of specific order passed by this honorable court. Those are my submissions.
First of all, my lord, it's required to be clarified what is this whole imbroglio about. Imbroglio is that advance authorization licenses were given. These are given basically on a scheme of the economic policy of our country, which DGFT comes out with. Earlier, it used to be once a year, then it became a 5-year term thing, where at different times amendments used to come in via notifications, etc.
Yes.
Now, this particular scheme had this concept that one could import certain things for the purpose of using it and export that amount, a particular amount, say X is imported duty free, which otherwise would have been dutyable. X is imported duty free and will be there would be an export obligation. A book is maintained. It's called the EODC, where export obligation discharge certificate is given. Now, this can be done only after that export obligation is made by them. Now, in this case, it is the duty of the petitioner's client to come before the DGFT, say that this is my EODC and I have fulfilled my obligation, you give me the certificate. Otherwise, they become liable to pay duty on the goods imported, say 8 years ago.
Including the duty.
Now, time is not the essence here. At the time when this scheme came in, the import that you have made, the obligation of this import, which was done duty free, has to be probably done within 8 years or 10 years. So it is their duty after 8 years or 10 years to go before the DGFT and say that this has been done, and thereafter go before the customs authorities. Otherwise, customs will come back to you with a show cause notice seeking recovery of the duty amount, which happened in this case. In such a scenario, they came before the High Court, and that's when the question of these documents came in. These customs notice, show cause notice was quashed, and DGFT was said to complete the whole process. Thereafter, once it is found out whether the documents that were given to the DGFT are correct or not, based on that, the customs will deal with it. Now, ideally, in this case, if customs was a party, it would have been the ideal situation, because when the import was made, and the duty-free import was made, it's there in the records of the customs, and customs, based on which, had given a show cause notice to them, saying that you have not paid the import duty. At that point of time, it was their duty to bring from the DGFT the certificate, show it to the customs, yes, I have paid this duty. Now, he comes with a story today that DGFT doesn't have the documents. Which documents should DGFT be having?
No, so the
Now, I'll come to that also. I'll come to that. He says he has submitted these documents before DGFT, which is not. If that were the case, then the letters that he has annexed here and has given to the DG, none of them have any endorsement of receipt. None of them. I say it with authority. Now, today, the impasse that has come in is, he says, I have changed my office, therefore I can't locate my documents. DGFT says, I have not got those documents. How can I give the documents? Those documents are documents they are supposed to show DGFT and get the certificate and go and give before the customs authority. Now, based on which
in 2017, this honorable court passed an order that you go into and see the documents are supplied to them. Now, at that point of time, when it was said documents are supplied to him, the documents that could have been supplied to him could have been only by the customs, couldn't have been by the DGFT, because if documents were with DGFT, then there was no problem. I am coming before him with the show cause notice saying that you have not complied with the export obligations with regard to duty and exporting the goods in lieu of the DEC scheme after the duty-free import. This is the reason I am coming before him for the violation of the Foreign Trade Act, which is why we are saying that penalty is leviable on you. Now, there's the question. The main thing is that this is a stale case. This couldn't have been a stale case because it's going on. He has actually gained. The benefit is with him. The government is today coming and saying, you have taken the benefit of duty-free imports. What happened? Why are you not paying that? Why are you not fulfilling the export obligation? To which he says that I have already given you documents. And then he says, I don't have a copy. Department says, I have not received. Department can't have a copy. The whole aspect that has been shown before my lord is as if it is the duty of the DGFT to have his document of the EODC certificate. It is his obligation. He has to give that document to the department. That he has imported and that he has exported consequent to import, that could only be with him and the customs department. It can't be with DGFT. Which is why an opportunity was given to him. If you have lost it, then go before the customs officers, go before the customs department, try to get those documents from them and place it before us. Once you show that you have made the exports and fulfilled the export obligation, then your case is over. That is one, my lord.
So in the 2017, when this order was passed by this court,
My lord.
who are the party?
There were two. If my lord sees, there were two writ petitions that were being disposed there.
Correct, two writ petitions.
One was the customs. There was a show cause notice by the customs department also, and one was of the DGFT.
So, Director General of Foreign Trade submits that the petition was given
Yes.
so cause notice. He submits that during the pendency of the writ petition, notice of hearing was issued and fixing a date.
Page number 2.
Writ petition is pending 2007.
Right, gotcha.
Same order.
60. If my lord sees page 71,
Yes.
they say the order of the customs authority is on the basis of the order passed by the DGFT. So DGFT at that time had passed an order, which was subsequently both these show cause notices were in view of the directions for rehearing the show cause notice issued by the Director General of Foreign Trade. The order passed the customs authorities is rendered invalid.
Correct.
Same is set aside.
Correct.
The customs authorities are at liberty to proceed afresh on the conclusion of the proceedings by the Director General of Foreign Trade. None of the proceedings will be prejudiced by any observations made in this order. So this was the order that was passed.
No,
My lord, auto,
For economic offences, this is not an offence yet, my lord.
my lord, short levy of duty,
Offence, lordship can seize.
short levy of
Offence,
duty comes under smuggling, my lord.
no, cannot be.
Short levy of duty will come under section 111 of Customs Act.
It cannot, my lord.
My lord,
Because
but yes, my lord's suggestion of making Customs Department a necessary party would completely solve the issue here.
So once for all, it can be decided. Once for it can be decided, let the custom be made a party, and your representation is let the.
but that should be without prejudice to my rights and contentions in the writ petition, my lord.
Yes.
Lordship, Lordship gives a direction, I'll make them a party, my lord. And in the meantime, proceeding before the
The stage of the proceeding now. Before you, as per this notice.
hearing, only one hearing given.
Today was a date fixed. I have myself told them not to proceed with the
Let
hearing.
for the time being, let it be.
My lord, my lord.
Stay.
But
Let
instead
there
of,
be an order of court, my lord.
instead of there being a stay, my lord just makes an observation that I will inform that no further.
No. My lord, only difficulty is, my lord,
Without court order, they will not.
so without an order of court, my learned friend will be in
Record, I
difficulty.
will record, not, I will record this.
একই ব্যাপার।
আবার নোটিশ দিয়ে দেবে
Petitioner
আবার নোটিশ
has
দিয়ে দেবে
challenged
হ্যাঁ কোর্ট হলে ভালো কিন্তু ওখানে তো প্রবলেম করে দিচ্ছে উল্টো পাল্টা চিঠি দিচ্ছে
ছিল তারা কনসিডার
উল্টো পাল্টা কথা বলে হিয়ারিং এ এক কথা বলে
জানে না জানে
বন্ধ করে দিই স্টেল করে ড্রপ করে দিই
আমরা কত করেছি চাই বাবা আমি তো কাস্টমসটা শিখলাম হাসপাতাল সত্যি কথা কাস্টমস লটাই ওনার কাছে আমি বলি দাদা হচ্ছে না এটা এইভাবে করুন কিছু কিছু
কি বলছে
P number 28770 within bracket W of 2016 with WP number 5449 within bracket
ছুটি পড়ে যাবে
dated 3rd March 2017 where this court has passed the following 29 से लेकर के 71 ठीक है set out full stop. The petitioner has raised an issue that this court has directed the correspondent authorities to serve notice of so-called as also all documents that the prosecution seeks to verify in such proceeding. Identity is submitted by the petitioner in court. Okay, but the order was passed in the 2017. Till date, no document has been supplied. 8 years. Then it comes to the authorities that the document in the above referred matter, the custom authorities were also the part of it. Custom authorities have to serve the document, have to supply the document to the petitioner, not by the respondent. This would find that the custom authorities are not the representatives. The specific case of the petitioner that the no document supplied to the petitioner. And without the document, it will be easier for the petitioner to proceed.
all pending until further.
Considering the above without prejudice to the rights and concern of the petitioner, comma, the petitioner is directed to imprint at the custom authority as respondent number 4 and to issue notice upon the respondent number 4. the respondent number 4 by informing the next date of hearing.
জানুয়ারির ভেতর হবে না
Next date of hearing. This is the matter. So I don't think before vacation it will be.
You know, my lord.
Let the matter appear on 8th of January 2025. Under the same. On the returnable date, the petitioner shall file the affidavit of service showing the service of notice upon the custom authority. Full stop. In the meantime, this court hope and trust that the respondent shall not proceed with the so-called notice
In the
issued
meantime.
against the petitioner till the next date of
until
hearing.
Lordship, kindly not use in the meantime. What happens, they constitute as if till 8th. Lordship can say,
Lordship also means that.
no
until little 1-2 days more, my lord. Let the interim
Okay.
order be till
Okay,
end of
till-
January.
Till 14th of January 2026.
Huh?
no
The custom, my lord, which authority if they indicate?
No, they know the so-called notice giving authority. Who have they written to?
Who is the custom authority? You don't.
Who have you written
Well,
to?
we have written to export obligation cell. Is that
To
the
whom you
correct
give the
authority?
representation?
I don't know, they can know who will have.
You
the-
have given the representation.
Yes, there's, yes, cell, export obligation cell.
Assistant Commissioner of Customs.
Assistant Commissioner of Customs, export obligation cell.
You give that.
Are you
Let
competent?
they come, they are not the competent authority.
And as well as Commissioner of Customs.
Yes,
Port.
Commissioner of Customs.
Commissioner of
also.
Customs port হবে কারণ question of
এটা ইনপুট করে
Input করে দেবো।
Then, my lord, Lordship can also include Commissioner of Customs port.
Careful, na? The petition is given liberty to make the custom authorities, I stated.
custom.
Custom authority.
আমি তুমি Commissioner of Customs.
By which date? By tomorrow?
No, my Lordship, can you?
Within a week from date.
Commissioner of Customs, আর লোকে স্যার?
Assistant of port or Assistant Commissioner.
Assistant Commissioner of Customs।
8 তারিখে রাখছে
Looking service.
Grateful. Within a week.
আমাদের 17 দাও
Add a respondent.
17 is my petition.
I am for the state lordship and SSC is representing at a दिन
Final of judgment hai.
दिन other.
Like today, my lord, they have served me with a copy of the report as directed by this court, my lord. Now, my lord, I have gone through the report, my lord.
Where is the report?
This report was sought for to understand what is the stage of the selection process. Now, my lord, so far 11-12 is concerned, my lord. So far 9-10 is concerned, they have completed up to my lord verification, as I have understood, my lord. So far 11-12 is concerned, it is still in process.
Which one?
11-12.
11, 9 and
My lord, if lordship,
have also been declared. 9. You are in which post?
11-12.
Huh?
9-10 and 11 both.
9, 10, 11. The result has examination have been declared on 24th of November and the preliminary interview list is in process.
Now, my lord, I tell you, lordship, my lord, they are rightly saying that they have fixed a cutoff date on which you will have to be in this category of EWS. Now, my lord, the category, my category will be determined based on my my date of application for EWS, my lord. Page 17 is my application, my lord, which I have made on 4th July 2025.
Correct.
Now, my lord, I have to satisfy them that as on 4th July 2025, I belong to this category. Now, my lord, they have quoted in their report in the first page, last paragraph. Before that, first paragraph, last line. However, this addendum did not extend the criteria of obtaining certificate prior to 21st July 2025. And then clause 11 has been quoted that for consideration of belonging to reserve categories, certificate issues by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications
Correct.
shall be treated as valid document.
Correct.
Therefore, according to them,
The certificate must be issued prior to this first 21st.
On that cutoff date, you should
Must
you should possess
now
the,
my lord kindly takes up the next page, my lord.
Yes.
And my lord rightly. Now next page, first paragraph. Persons who were issued EWS certificate by the competent authority in the previous financial year and had reapplied for issuance of EWS certificate for the current year 2025. The commission has commission even accepted acknowledgement slip application form if the same was made on or before 21st July. But so far I am concerned that I have that receipt that on or before 21st July 2025. Therefore, this is not correct that you must possess the certificate before 21st July. In fact, they are this certificate is valid for 1 year.
So earlier you have got the certificate EWS.
No, I didn't. My contention is, even if I possess a certificate.
That's why, because the persons who were issued EW certificate by the competent authority in the previous financial year and had reapplied for the issuance of EW certificate for the current financial years, the commission even accepted. Because you are not having the EW certificate previous year.
No, that's my point, that the certificate issues in previous years remains valid for 1 year. Therefore, after 1 year, I don't have any certificate. In fact, I have to apply again for certificate for this year. That is the guideline. Therefore, this reissuance of certificate has no meaning. It's in fact a fresh application for the fresh.
Whatever.
My submission would be, Milad, that
no,
every year.
But their contention is that prima facie they were the EWS.
I follow. I follow. But in law, you understand that yes, there is no certificate after 1 year, and you have to apply again. And the difficulty is every year. If the authority remain tied on my application, then in every year I will be losing.
That's why now you cannot.
Now, for this year, today the number of litigation is going on. The order was passed that whether 10 marks can be added prior to interview or after interview. Whatever the interview list has been, because the rules is like that interpretation is under challenge, and court has passed an order that whatever decision you are taking, that is subject to the result of the writ petition, and court is giving day-to-day hearing on that. Since Supreme Court has passed a direction that you have to complete the selection within a certain period. Now, till today, they are yet to complete the verification process. If certificate is issued today, and that will take effect from the date of my application. Now, therefore, I'll be eligible for this selection process.
We don't know, but because if the certificate.
If certificate is not issued, but nothing.
No, not issued. If the issued, it will be issued on the date when the certificate been issued to you, not from the date of application.
That certificate will be issued to me for this financial year only. Not that if today the certificate is issued, it will be applicable from today to next financial. Not the financial year is fixed every year, and it will remain for valid for 3 months only, not beyond that. Therefore, for this year, whatever certificate will be issued today will remain valid up to 31st March. Therefore, if they issue certificate to me, they can well consider it for this financial year from last.
That's correct. That's correct. But once the examination is over,
examination is.
How
can
be accommodated now?
I tell you, Lashim, I have participated in the written examination.
You participated?
Yes, I have participated.
How?
They have
on the
in the category of OBC.
No, EWS. Kindly say some blood. My application, page 21. Page 21.
Short the issue, Milord.
Action. Nak shesh korni.
Past, Milord.
Nak shesh korni.
Identical things. I want to place that.
But now kindly take some blood. The facts are different.
One order, another order, Milord. I only have soft copy because it has been uploaded just today.
Facts are different. Maybe the point I am arguing is the same. In my case, I applied under EWS.
He applied without any certificate.
Yes, kindly.
I've gone through it. I have gone through it.
Uploaded just a few minutes back. It is more detailed.
I have gone through it. But I have blood order of coordinate bench. I'll be placing blood. Nag. Nag.
আজকে সামার ভ্যাকেশন করে দাও।
The order was passed day before yesterday, possibly. Now, I have seen the order. And I have the order of the same bench in my favor. Now, page 21 is my application. The factual is different. I applied under category EWS. Can you see blood? Category in the second column, date of birth, subject, medium, category. And prior to this, I have applied for EWS certificate. That's the procedure. Now, they have allowed.
Where is your application for EWS?
EWS, yes, at page 17. দাঁড়াও কথা বল নাক গুলিয়ে দেয় সবসময় নাক এসেই গুলিয়ে দেয়
Yes, okay.
Page 7
So this is 7th of April.
Yes,
7th April 2025.
In fact, it is from 1st April I am entitled to, from 4th April, 7th April I have applied.
Yes.
And it will remain valid from 1st April 2025 to 31st March 2026. Now, I have applied under EWS. They have allowed me to participate as EWS. Now, I have qualified. Now, verification is going on. I have to produce certificate during verification. Now, if the authority refuse my EWS certificate.
When you applied for 25th of July, 4th of July.
4th of July.
4th July.
Now, if the authority tomorrow refuses my certificate, nothing remains.
And you have your application is the 10th of July.
Yes.
Correct. So where is your admit card in?
Oh,
allowed to admit?
Page 22.
Page 22 is the admit card.
Yes.
So you appeared in the examination.
Yes, now verification is going on. After verification, they will add 10 marks for experience or not. That is subject matter of. Now, if tomorrow the authority refuses EWS certificate, nothing remains. If they allow grant certificate, then the commission will have to consider during verification. So therefore, nothing will not prevent them from consideration, or no equity will be created in my favor if this is issued.
So how much time it will take for concluding the interview?
They are yet to start.
He has already applied. He has already attended the examination. Correct. And prior to attending,
You get everything except for the EWS benefits.
just a minute. Before that, he has applied for the EWS. The application is under EWS. Correct. And he has appeared in the examination. Now, which category is to be taken? So, what subject to correction? Subject to correction. If today I dispose of this application, directing the concerned authority to dispose of his representation for grant of EWS certificate, if he is entitled to immediately pass a grant EWS certificate. If it is not granted, to pass an appropriate order. And I will fix a date, time. And if he got the EWS certificate, his candidature may considered as a EWS candidate because he already attended the written exam.
Right.
Please you confirm, see whether he has attended the examination or not.
Lordship, at that relevant time, he was the category of OBC. I have filed that.
He was OBC, but
He has not forgotten that category OBC.
Recording my submission.
That's why he's submitting that he will not claim any
Benefit out of OBC certificate.
any benefit under the OBC, not today or in future.
On
In the future. That I will
Then,
record his submission.
after consideration of the authority, if he got that, if he get that certificate, then that time that will be valid, Lordship. Before that, that cannot be accepted.
So that time, what time, which period the EWS certificate will be issued, that the authority will decide. If the authority is issuing this, because he has already applied for this, but the authority has not considered that. If the authority would have been considered in the, he has applied in July. If in October, November, he could have been, so he can produce the certificate during the interview. He has not.
Lordship, unless he has filed an undertaking that he will forgo that
After accepting that undertaking, then he is entitled. And on that cut-off date, he is entitled for EWS. Before that, whatever may be.
Decide.
Lots.
So not by the court only. The
Lots.
court say his submission I will record, I will send it to him, but only the question is if he will get the EWS certificate. So whether any possibility, because he has already attended the examination. For the attending the examination category is not required. Any person can appear. Only at the time of interview and
Preparation of list.
this verification, the category will be taken into consideration for preparing the merit
list
in terms of the category. That is to be.
Merit is already published.
Well, there are two difficulties. First is, my lord, we have been rejecting the similar categories, my lord, who have not furnished the certificates, and by virtue of these two orders, my lord, as they were challenged to our decision, my lord, that
That two orders, that's why.
Court will record that no benefit for the fence sitters.
That this candidate gives, in this detailed order which has been uploaded today, whether the candidates have appeared in the, because the court is appeared in the exam.
Appeared in the exam. All appeared in the exam.
But somebody didn't approach the court, the fence sitters, for them no benefit is there.
No, it cannot be like that. It has to be a equal level playing field for it.
Article 40. If somebody doesn't claim his right,
Will kindly take up page 16
forego his legal rights.
Page 16 of the writ petition once.
Yes.
But he is relying upon this EWS certificate.
Correct.
This is issued on 22nd June 2020
Right.
for the financial year 1920. That means, my lord, from 31st April 2020, he does not belong to a EWS category.
Correct.
This is valid for 1 year only.
But he did
That I have made clear from the beginning.
He would have and we asked him to produce the EWS certificate of the last financial year.
I don't have.
He did not.
In the meantime,
That
he,
is the reason he did not.
in the
after
meantime,
1920, he did not pursue it at all.
Okay.
in the
Any
meantime,
further?
he.
Yes. Any further?
But I will
Lordship.
provide that that hard copy of.
Lordship, there is no averment in this writ petition. After the EWS the certificate is expired,
Recording my
no,
submission.
no. He has not availed the OBC in any exam, whether that is pending, that has not been declared, and that is under process. There will be very difficulty for that, Lordship.
And look, all the coordinate benches order, the commissioners have participated. Participated, approach rejected.
Give the copy to that.
Miller will see the order I handed over, paragraph 1 itself says so. The petitioner participated in the second SLST prior to filing of his application form. He applied for a certificate under the economically weaker section. So the Miller, it is identical. It is identical. He participated and he applied before filling up the form. But he did not have the certificate.
Participated not as EWS. Participated, but not as EWS. Not as EWS, my lad. In all other cases,
Applied for certificate under the economic weaker section on EWS, and certificate was issued to him on 10th of September 2025. Grievance of the despite opportunity of commission details and not provide.
that is different. Yes, Mulad, kindly see why they are saying so. Mulad, kindly they see their report, Mulad. Kindly see their report. Last page.
Okay.
Last page, Mulad. Last page of the report. There was a notification which allows not change of category. For that they have not availed. And that's the reason that court has refused.
The petitioner has filed the present application playing for a direction upon the sub-division officer Malda Sadar to forthwith process and dispose of the petitioner's application dated 4th of July 2025 for grant of certificate under the category economical weaker section within bracket EWS for the financial year 2025-2026. 2026. Counsel for the petition submitted for the year 2020 for the financial year 2020-2021. The subdivisional officer Malda Sadar within West Bengal had issued the certificate to the petitioner under the EWS Act. Subsequently, on 15th of October 20, what is the date of the page 18, Mr.
Page 18.
Yes, page 18, this OBC certificate date.
That it is dated that 15th October 2022.
2022.
15th October 2022.
Subsequently, 2022, authorities have issued the certificate for the category of other backward classes. In the meantime, the West Bengal Central School Service Commission has issued a notification for recruitment of the teacher. The petitioner on 4th of July 2025 had applied for grant of EWS certificate. Grant of certificate under the category EWS. And on 10th of July 2025, the petitioner has submitted application for preparing the recruitment process. Which where is the application? Which post you applied for?
Yes, ma'am.
Page 19. Which post you are applied for?
Page 19.
Yes. Which post you applied for?
But for the post of assistant teacher.
Post of assistant teacher. Full. Counsel for the petitioner submitted. Petitioner has applied for the EWS certificate, but the authorities have not.
But two applications I have annexed for 910 and 1112.
Yes. 19?
910 and 11, secondary and senior secondary. Your lordships can find from the top that black shaded portion. 19 is for secondary and 21 is for senior secondary.
Right, for the assistant teacher in class level 9. Assistant teacher for 2025 in class level 9, 10 and 11. 9, 10 and 11. Full stop. Issue certificate, EWS certificate. He submits that though the petitioner is having the other backward classes certificate, but the petitioner is ready and willing to forgo the benefit of other backward classes in future, if the EWS certificate is granted to the petitioner. Full stop. This court has called for a report from the respondent number 5, that is the West Bengal Central School Service Commission. With regard to the status of the recruitment process of the assistant teacher in the secondary and senior secondary level. The authorities have submitted the report wherein it reveals that as per clause 11 of the recruitment notification dated 30th May 2025, it is clearly stated that for consideration of belonging to reserved categories, the certificates issued by the competent authorities of only the government of on or before the last week of receiving online applications shall be treated as valid document. Submit that when the petitioner has applied for the post of assistant teacher, the petitioner was having the OBC certificate and not EWS. Unless the candidature of the petitioner cannot be taken into consideration as EWS candidate under the EWS category. We further submit that the petitioner has not disclosed in the present documentation whether the petitioner has taken any benefit with regard to the OBC certificate unless the petitioner is not from the report, it is also found that for the class 9, 10, and 10, 9, 10, written examination has also been poor. Result has been declared. This interview Learned counsel for the respondents have relied upon judgment was confined the failure of the and others dated 26/11/2025 wherein instances coordinate bench of I put up the part time updating certificate amount to unsettled interview list developed by the and a counsel for the petitioner submitted the case of the petitioner the fact of the case relied by the respondents is distinguishable from the facts of has before the present case before filing before submitting an application for appearing in the recruitment process in class level 9, 10, 11, 10, 9, 10, 11, 12. The petitioner has already applied for the tenth of July. Further submitted, the petitioner has appeared in the examination. Consider grants of EWS who issued the petitioner for the financial year 25-26. Right to and thus the petitioner can be treated as the EWS candidate. But the learned counsel for the respective parties initially in the year 2020, 2021, in the financial year 2020-2021, the petitioner has obtained EWS certificate from the concerned authority. But subsequently in the year 2022, the petitioner has obtained OBC certificate instead of EWS. Now on before filing of the application for revision, has applied for EWS certificate. And now before this goal, the petitioner has undertaken that the petitioner will not claim any benefit under the OBC. If certificate is issued under the EWS. Process has already been and the examination has already been completed and the interview process is going. That at this stage, where the petitioner for updating the reservation certificate is allowed among the same with unsettling interview list prepared by the commission. Considering the above, this court find that that at this stage, no relief can be granted to the petitioner. Accordingly, writ petition is dismissed.
Grateful lords.
Sorry. Yes, next.
I'll be coming with a better case with Mr. Nag.
Lord, I am for the CSC, my lord.
Lord, I appear for the petitioner. A report was called for by a coordinate
My report is
bench.
there. My report indicates about the problem and the
Will you let a copy be given to
my
me?
lord, of course, and the solution as well.
Because you will not take the solution, then you will be the financial loss.
Absolutely. And at the end of the day, my lord, the consumer and the company needs to exchange flowers. At a কাগজ দেবেন? এই যে।
Yes, sir.
Lord, please pass necessary directions in terms of D. D.
So who will
My lord,
renovate the work?
may I press, my lord? The fact is that there are several disputes by and between the parties. Now, my lord, upon inspection, we have seen that the meter room is locked, but the main switch room is locked, but all the 4 meters are live. And your lordship knows much better than anyone, my lord, in terms of clause 7.2, regulation 55, my lord. Our duty is from the pole to the meter. From meter to the main switch, my lord, is the responsibility of the consumer. Where, my lord, we have got no role to play. Now, my lord, we have identified a place which is indicated to be common. But for that, my lord, we need to receive an application from the 4 consumers, my lord. And upon compliance of the formalities, my lord, and due payment, we will shift the entire service line to the particular place, my lord, so that no complication arises in future.
2nd of July, I have applied. This is my document.
No, with regard to D,
Yes.
so who will renovate?
My lord, if it is outside the tenant's portion, I will renovate at my own cost.
My lord, the fact is that we cannot shift the meters and the service line on piecemeal basis. My lord, because each meter, each service line will not be feasible. We have to shift the entire meter board position and a common service line.
But you have stated that
My lord.
CSC service cable at the premises in order. The main switch of Santanu was found.
Shifting of service.
No, the main switch of Santanu Shah was found in covered condition with padlock and in off condition.
My lord.
How?
No, the main switch is not the domain where the CSC can work.
That is where, my lord, the tenant is playing.
My lord, our domain is from the pole to the meter. From meter to the main switch, my lord, is absolutely under the domain of the consumer.
So how the main switch is off condition?
But the main switch is located in my tenant's portion against whom an eviction suit is going on. And tenant is represented.
You are the owner.
Yes.
Solution is the only solution, my lord, that we need a common space where, my lord, we shall install a new service line, and from where, my lord, all the consumers will be duly catered. And for that, my lord, certain formalities are to be complied, my lord. We need to receive an application, and subject to an inspection and compliance of the formalities, my lord, we will go ahead with the work.
Other two persons are, you are in occupation of 1 room, 2 rooms. Other 2 persons are, they are the tenants.
But they are tenants.
Paragraph 1, paragraph A. 4 separate rooms. It appears out of this
4 meters are there, my lord.
2 rooms are occupied by you.
Yes,
Correct. And the other 2 rooms are occupied by Nimai and Krishnandu.
Yes,
Who are they?
tenants.
They are the tenants, and you are the owner.
Yes.
You are having the documents. You are
Yes, yes, even the eviction suit is going on.
so. Can you identify where which they have identified the place? Can you can make a renovation so that I can pass an order to
Yes, yes, yes.
with the police?
my lord, we have already identified, my lord. It is there.
Identify.
My lord,
The place is not indicated.
indicated in player D. A common position was identified.
Which place?
Where is that? If it is in the tenants portion, again the mischief will go on.
Which place you have mentioned? Because he is the owner, so he can ask for the
Subject, but my lord, as far as shifting of the entire service line is concerned, my lord, in a single premises, several service lines are very dangerous and unsafe. So, my lord, we will go ahead with a single service line with 4 loop meters.
That's what I'm telling.
My lord,
The existing only he has to shift it.
they have to shift.
They have to shift.
They have to shift.
They have to shift. How it can be shift? Because if they are not ready, they will not ready.
My lord, let them indicate which place I am to shift. I will do the needful. All 4, how can I, my lord?
That's the problem.
My lord, because the entire service needs to be shifted.
Because it's telling the shifting of service.
My lord,
Shifting of service, it is service cannot be piece
my lord, my lord, my lord.
one place.
And from there,
No, no, all 4 may not agree.
That is the problem. So that is the problem. So who will because shifting is upon the person who is having the service line.
Very well. Will you kindly directs me, my lord? I will let them identify the place. I will shift. I will conduct all the renovation work.
if the landlord approaches us for the shifting,
Correct.
and if my lord, if the payments are made on behalf of the tenants as well, we have no issues.
Petitioner is the owner.
My
If
lord,
the petitioner is ready to shift and he will make a request to the you can shift the identified place.
subject to payments of the entire amount
Compliance.
and compliance.
Compliance.
My lord,
My lord, I have already applied on the 2nd of July. This is my application.
Shifting.
my lord,
Yes.
we need to make an online application, my lord.
My lord, the answer is this.
Yes, they
My
are
lord,
requested for
kindly see. This is addressed to 3 persons, and 2 and 3 are my tenants. That means they are obstructing in this shifting.
They are individual consumers, so we have to approach them.
7th July, my tenants write to the distribution licensee.
So tenants are
Resisting.
no, they are party here.
Yes, they are represented.
Who is appearing for the tenant? You are
For the state lordship, I have.
for the tenants. Have you served?
Yes, yes. My lord, with the mentioning slip, the notice is there. Mr. Mukul Agarwal.
So you do one thing. You issue the notice informing the date. I am fixing on
Online application, my lord.
No, I am fixing a date for hearing
What?
of this. You issued the notice to the tenants informing the date. If they will appear, otherwise I will pass an order.
In the meantime,
Let it.
Against them, I will pass an order for
Yes, yes, yes.
one opportunity is to be given.
Yes.
So either Monday or
My lord, let it retain its position as an upgraded motion.
it is.
Monday, my lord.
The CSC Limited has submitted the report wherein it's found that inward comma during inspection, a common position was identified by the undersigned near the main gate, which is technically suitable for shifting of service, subject to some renovation work, which is to be done by the occupiers of the premises and upon compliance. It is including payment of requisite charges. There is a dispute in the police. The petitioner is the owner of the property in question. In the property, there are 2 other tenants, and they are the consumers of the CESC. For shifting of the service, an opportunity is to be given to the stated who are the consumers of the seals, but they are not appearing before the court in spite of service of notice. Accordingly, only for giving an opportunity of hearing the private respondents, the case is adjourned till 15th of December 2025. In the meantime, the petitioner is directed to serve notice upon the private respondent informing the next date of hearing and to file the affidavit of service on the next date fixed. It is made clear that on the date fixed, if the private respondent, in spite of receipt of the notice, will not appear from appropriate order.
My lord.
My lord, may it retain its position as an updated motion.
15th up under the same heading.
Great.
Much obliged.
Item number 18, my lord. Next matter.
Lord's order. The new connection. It is new connection. I have purchased the new flat, applied. One objection has been raised by the, my lord, the promoter. Copy of the objection I have never been served. I asked the CSC by notice to provide, my lord, electricity, new connection, domestic. My lord, passed order for doing inspection and submit a report.
May I shorten the?
And my lord,
My lord, on the last occasion, there was a direction given by your lordship to have an inspection. My lord, today I am having a report wherein good, bad, indifferent, my district engineering is stating that they have gone. The petitioner was not there, so they could not do the inspection, my lord.
Absolutely false.
And I don't know whether it is false or true. It is my duty to, my lord, solve the issue. I'm only praying, my lord. My lord will fix a date and time, preferably tomorrow or day after.
Tomorrow I have no difficulty.
Wherein, my lord, my district engineer will again go. I'll hand over this. This is the report. I've given a copy. Again go, my lord. We will inspect and we will file a proper detailed report by Monday. My lord will dispose it of this petition on Monday as to. Please help.
My lord, may I?
We will go on to Friday at 12 o'clock. My lord will keep it on Monday. We will give a detailed report on whether we can give or not. 99% we can, because this is a multi-storied building, but just for ascertaining whether we can provide or not.
There are place. I talked to my client. They inspected. I have been sent with the, my lord, the voice recording. My lord, may I? Yes. My lord, now the report is coming. I don't know why the CSC. One person came with the cycle and he has been inspected. May I play just for 2 seconds, my lord? 2 seconds, my lord.
I don't want to go into all these things.
No, my lord, they are
report
referring
says-
a report that I was not present.
Forces me, my lord, then my lord,
Who present there?
It is the duty of the petitioner to open the padlock, my lord. We could not inspect the meter board. My lord, I am only requesting, if not going into all this detail, another chance. The minor will fix a date and time. My district engineer will go along, or the officials.
My lord,
of
the report
CS
says.
জোর
So-
করলে আমার আর কিছু
No. It may be done, but the report is, my lord, we are not there. Although we have got the access at the meter shed, got access of the meter shed, but due to absence of the applicant, we have not able to inquire any details about his possession. My lord, may I, my lord, kindly allow me to play the conversation. How this is going on?
If
For
it is not
obtaining
in possession, my lord, how can we give supply?
Not in possession. I have the deed. Everything. They have inspected earlier.
If it is, if the deed will give possession.
My
There
lord,
are
they have
thousands of deeds where the petition persons are not in possession. Without possession, we cannot give, even if it is an illegal occupier. We have to ascertain that.
They have inspected earlier. What objection has been raised against me?
By force, a person cannot come into possession. It is his duty to point out. That is what.
What objection?
But your report is contrary to the report of the police officer.
Yes.
But I don't have a copy.
My lord, kindly allow me to play just a second.
That is the reason, man, on the first.
Paragraph 6, kindly read the
দেখি আমাকে একটা report there.
Yes, Manuel, kindly come to my last point of the report. What we are saying. On the scheduled date, we have carried out inspection at the site, but the applicant was not present during the said inspection at 11:47 a.m. Now, Manuel, the important part comes. Though we have not got access to the meter shed, but due to absence of the applicant, we have not been able to inquire any details about his.
My lord, I fail to understand where from
Giving
he
electricity,
read
my
not.
lord, we have to take whether it is in possession or not.
My lord, what he says, my lord, not is there. My lord, kindly allow.
By an order dated 19th of November 2020.
একটাই আছে, the-
My lord, the CSC Limited saying the flimsy grounds.
CSC. Directed to CSC.
It says what?
Respect the premises of the petitioner to ascertain whether there is a feasible to provide electric connection to the petition as stated under the petition.
আমি তো সেটাই
The CSC has submitted report
তাই তো বলছি আমি।
wherein it reveals that on the scheduled date, that is on the scheduled date, the CSC have carried out inspection at the site, but the applicant was not present during the inspection.
আমি তো পজিশনই বলছি।
During the inspection, though the CSC have got the access at the meter set, but due to absence of the petitioner, the CSC not able to inquire any details about his position. The counsel for the petitioner has denied the contention and the report filed by the CSC on to the effect that the petitioner was not present during the inspection at the premises. Whatever it may be, this court is not going into the facts. Accordingly, the CSC is directed to again inspect the premises on
No difficulty.
on 12th. On 12th,
But I fix the time also.
Friday. Friday.
I have
Friday at
any,
12.
my lord, I am out of electricity. If it is done today, I have no difficulty.
12 noon. At 12 noon. Directed to at 12 noon. 12 noon, and the petitioner is directed to be remain present on the date fixed at the premises to identify the premises and the inquiry, if any, be made, and to give answer to the inquiry, if any, made by the CSC authority for providing electric.
And my lord, CSC would certainly, my lord, serve me the copy of the objection which has been raised by the promoter.
Why in respect to
Let the
inspection, why we?
No, no, yes. What type of objection, my lord? I am,
15th of, 15th
yes.
of December 2020.
Yes.
Well, we'll place it before the. 15 তারিখ।
At this, in the same.
Let the police officials be also be there. Let one direction be there in terms of the earlier order.
In terms of the earlier order, the police authority may provide proper police assistance.
My lord,
CSC officers for inspection of document on 12th of December 2020. Next.
My lord, can it be on 17th, my lord?
Yeah.
17th or prior?
Why?
তোমারই তাড়াহুড়ো।
I will not be there. That is the difficulty. I will not be there.
When 17?
On 17th, my lord.
17.
17th at 12 noon.
No, tomorrow inspection 17 is fixed the date.
Inspection is on 12th, my lord.
12,
Tomorrow,
12.
day after.
Day after.
Day after two. My
I
lord,
prefer the registrar of companies.
under the same,
Number
same
one.
heading.
I appear for the respondent number 3 and 4, the
Yes.
private respondent. There's only one request which has been made on the part of Mr. Ratnabha Banerjee is leading me in this matter. He's stuck in some court, your lordship, not being told if your lordship can pass it over for some time. Because I'm being led by him. That is the only difficult.
My lord, I appear for the petitioner.
Otherwise, I am ready, but since he has this a request, so that's why your lordship.
Lord, a very short point involved. In fact, my lord, I've challenged this DIR form, which has been filed by the respondents with the ROC saying that I've resigned. On the last occasion, your lordship directed the ROC to produce the DIR form. My lord, on Monday, the ROC has handed over the DIR form to your lordships and served a copy upon me. Now, my lord, it's very interesting. The ROC is saying that the DIR form is defective and null and void. And that's exactly what I'm seeking because, my lord, what the respondents have done is they filed the DIR form with the ROC saying that I've resigned as a director, whereas there is no resignation, which now the ROC has confirmed. Very short point, my lord. I'm only seeking that this rogue form has to go.
Okay, pass. Let them pass.
Yes.
Next.
This is my application. My lord, service is here. My lord, my respectful submission before your lordship is this, my lord. Devinto, just make it a bit of service. My lord, the petitioner was entrusted, my lord, the civil construction, my lord. Work order has been issued in favor of the petitioner. And my lord, completion, my lord, certificate has been issued in favor of the petitioner, 90% of the work. Now, my lord, 5 installments of payment has been made by the petitioner, my lord, till date. My lord, performance certificate is annexed at P3, page 17.
Yes.
And my lord, page 18, lordship, kindly have a look, my lord, that Milord, out of 5,36,022,831, they have already paid, Milord, 4,47,000, 4,47,000, 13,315. Milord, remaining portion is this, Milord, 89 lakhs and also. Milord, I made a representation before the authority. In the meantime, Milord, they have, though the defect period has already been over, Milord, they have issued a letter in favor of me, Milord, directing me, Milord, to repair some cracks. Milord, I agree. Ekটু দেবেন just একটু দুটো। The day before yesterday, Milord, they have issued the letter. I agree, I will do that. So the Milord defect period is over.
Defect period is that is with regard to the performance guarantee.
My lord, I am ready
What
to.
about the bill?
My lord, my instructions are that we're willing to consider the representations. The only direction that I'm beseeching is their representations have been made to the executive engineer that may be forwarded to the chief engineer, and we'll consider the representations of the
Along with the Milord security deposit. Kindly mention this.
Security deposit after the this
Milord, no, Milord, work order has been completed. Lordship, kindly have to look.
18.8.
My lord, we are willing to consider the representation.
Yes, yes. 18 Milord, they have issued the work order.
Correct.
Yes. My lord, kindly clarify the position.
The petitioner has filed the present application for the direction upon the authorities for release of the amount of rupees 89,09,516 along with the security deposit. Counsel for the petition submitted. The authorities have issued the work order on 3rd of June 2019. And the petitioner has completed the work and the authorities have issued the completion certificate on 18/8/2020. The petitioner has raised the bill total amounting to rupees 5,36,22,831, out of which the authorities have paid only 4,47,315. The remaining amount of rupees 89,09,516 is still unpaid. He submitted the petition has made a representation to the authorities on 29th of October 2025, but till date, the respondent authorities have neither released the balance amount nor the security deposit. She further submit that on 5th of December 2025, the petition has received a communication from the executive engineer requesting the petitioner for repair of certain works. On receipt of the said letter, the petitioner has sent a reply intimating that the petition is ready and willing to repair the said work. Learned counsel appearing for the respondent authorities submit that the petitioner has made a representation to the executive engineer, but the same has to be considered by the chief engineer.
It has to be done to the chief engineer instead of executive engineer.
Chief engineer not a party.
My lord, he's party, respondent number 5.
And the chief engineer, E&AM sector, Kolkata. Chief engineer, Mr. She submitted if the representation is made to the chief engineer, the chief engineer will consider the representation of the petition and will pass appropriate order. Consider the submission made by the council for the respective parties, peruse the materials on record. There is no denial that the work order has been issued to the petition. A petition has completed the work order work assigned to the petitioner, but the remaining amount of rupees 89,09,516 is not paid. In view of the above, the petitioner is directed to submit a detailed representation to the executive to the chief engineer within a week from date.
My lord.
Within a week from date, and on receipt of the representation, the chief engineer to consider the representation, if any, made by the petitioner, and to pass and to release the amount. And if the chief engineer found that the petitioner is entitled to get the amount, the said amount shall be released in favor of the petitioner within a period of 4 weeks from the date of receipt of the representation. If the chief engineer found that the petition is not entitled to get the amount, the chief engineer shall give an opportunity of hearing to the petitioner to pass a reason speaking order within a week thereafter.
Grateful.
And
My lord, only
communicate
one-
the said order to the petitioner.
My lord, only one line, my lord, the remaining portion of money along with the security deposit. Kindly add this.
Amounts
It's already there in the representation.
My grateful.
Next.
I am for the petition, Lordship.
I for the CSC respondent.
Lordship, on the last occasion, Lordship directed the CSC Limited to make an inspection of the petitioner's premises, Lordship, on Friday at 2 p.m., Lordship.
Pursuant to your Lordship direction, my lord, we carry out an inspection, my lord, to the premises of the petitioner, my lord. This is the report, my lord, inspection report. I am served, my lord.
Just now. এখন আর কোর্টে দিচ্ছ দরকার নেই।
This is the injunction order, my lord.
Who is the party in the injunction? The civil suit. You are the.
I am also the party, Lordship. I have also averred in my petition that
You are plenty for the defendant.
Lordship defendant.
So the property appears on joint owners, so both the parties directly.
Lordship, for 1/4 share, for ownership of 1/4 share of the said property, they have filed the instant suit. That is pending, Lordship. In the meantime, Lordship, I am without electricity. I have applied for a connection. Lordship, the CSC authority has held us in possession, Lordship, and they have also stated in their paragraph number 1 that I am entitled to get 1 loop meter. I am paying for 1 loop meter, Lordship.
Go prevail for the civil court.
My lord.
No, Lordship,
There is an injunction order.
no, Lordship, in case
That
of
requires
injunction
an
order,
annex,
Lordship, High Court has already directed in case of where there is status quo, electricity authority can give connection. Lordship, I am with the judgment, Lordship. Justice Joymallo Bagchi's judgment, and also that has been cited here in the said judgment. Lordship, kindly goes through paragraph number 15, 16, 17 also, Lordship. Reported judgment, Lordship. And various judgments are also there. Justice Shobhashachi Bhattacharya's judgment is also there, Lordship. Anyway, it is settled, Lordship, in case where there is a status quo order, petitioner can get electricity, Lordship.
Yes.
That's the only thing, it will not create any right in my favor.
The petitioner has filed the present application praying for grant of electric connection. By an order dated 4th of December 2025, this court directed the CSC to inspect the premises of the petitioner and to submit report. In compliance with the order dated 4 December 2025, the CSC Limited has submitted the report, wherein it reveals that on 5th of December 2025, the premises of the petitioner was inspected. In the report, it is mentioned that the petition is living separately and she is entitled for a new loop meter at the existing meter board position, subject to necessary direction from the court of law. But the authorities have further informed that the report further reveals that the co-sharer have handed over the copy of the order passed by the Learned Civil Judge Senior Division 7th Court, Alipur, in title suit number 965 of 2025, wherein the Learned Court had directed the parties to maintain status quo with regard to nature, character, and possession of the suit property till 31st of July 2025. Counsel for the plaintiff submit that he is also the party to the suit, being a defendant in the said suit. Counsel for the plaintiff for the petition submit that though there is an order of status quo, but it is settled law in status quo order will not prevent the CSC for providing electric connection.
Actually, I have cited
in the premises of the petitioner. The petitioner has relied upon the judgment in the case of K. Samsud Doha versus West Bengal State Electricity Distribution Company Limited, reported in 2012 within bracket 5 CHN Calcutta 772, wherein the current bench of this court has held that
paragraph number 15, 16, and 17.
held that order of status quo as to the nature and character of the suit property is not violated by affecting electric supply to an admitted occupier of the such property. In the present case also, there is no denial that the petitioner is in occupation of the property. It is also appears from the report that the petitioner is not having the separate electric meter. The CSC authorities are ready and willing to provide the new loop meter from the existing possession, subject to compliance of all formalities by the petitioner. Of the above, the CSC Limited is directed to supply the new loop meter at the existing meter board position in the premises of the petitioner within 4 weeks from the date of compliance of all formalities by the petitioner.
In case of any objection, Lordship, police help.
It is made clear that if the authorities find that any person is obstructing the CSC for providing electric connection in the premises of the petitioner in terms of this order, the authorities, the police, concerned police authority, that is
respondent number 3, Lordship, officer in charge, Haridepur police station.
The respondent number 3 shall provide appropriate police assistance to the CSC authorities for providing electric connection in the premises.
At the cost of the petitioner.
If any cost is required to be paid for police assistance, the cost shall be borne by the petitioner.
Grateful. Lordship 22, I am for the petitioner, Lordship.
I appear on behalf of CSC.
Lordship, this is my affidavit of service.
You are the contractor of the Haridepur.
Yes.
No, Lordship.
Giving bamboo to everybody.
Very bad, Lordship. This is my affidavit of service, Lordship. The parcels has been returned as refused, Lordship. I cannot annex it in, Lordship. I am handing over. All 3 items has been refused by the private
service connection. Yes.
Lordship, may I
we have given a letter, my lord. He has asked for service connection. We have given a letter, I think 2 letters, one on 2nd of September, another one on 29th of August. Clearly stating, my lord, that the service connection already exists.
Lordship, now may I submit, Lordship?
It already exists.
Lordship, partition deed is there, Lordship. Entire property is partition. Connection exists in 9A, Lordship. Kindly seize my.
There is nothing written in the writ petition subject to correction that whether the partition has been done meets and bounds.
Lordship, paragraph number 10 kindly comes, Lordship.
Yes.
Lordship, your petitioner states that Srimati Nupur Khara, Ganesh Khara, and Dalia Khara, who are the objectors, Lordship, I have served. Being the respondent, are the owners of the premises situated at 9A, Kedarnath Chatterjee.
Whether you are having the electric connection?
No, Lordship. It is in 9A, Lordship, and I am applied for 9B. Lordship, it is entirely different premises, having separate entrance, everything is separate, Lordship. And the objectors.
My instruction is, since there is a service connection already exists, he can apply for a new loop meter. He can apply for a new loop meter.
You do one thing.
My lord.
Inspect the premises. submit the report.
Lordship, whether only 9B.
My lord, will fix the date and time, my lord.
The
Any day
petitioner
next week, my lord.
Only 9B.
No, why, my lord? What is there in the partition did we will inspect? My lord, my learned friend cannot have the cake and eat it too.
I have applied for
In a
9B.
roundabout way, he cannot have this. Maybe.
connection.
Madam, may I hand over the copies of the letters?
Where is your application for electric connection? Which premises you applied for?
9B, Lordship.
Where is your application?
Lordship, kindly comes to
Wait, I could do
paragraph number.
Not paragraph. Where is the paragraph? This application. Online
I
application.
have not received any communication from them. I have about the reference number.
Application where you have annexed?
Paragraph number 6, Lordship.
Annexed টা কোথায়?
Paragraph number 6, Lordship. My reference number. Paragraph number 6, page 3, Lordship.
क्या बोला? Electric connection. Full stop. Before passing full stop, this court is of the view. Before passing any order, a report is required to be filed by the CSC. CSC. Full stop. After inspection of the premises in question, wherein the petitioner required the electric connection. Accordingly, the CSC authorities are directed to inspect the premises of the
Well, keep it on 18th at 12 noon.
petitioner on 18th of December
2 o'clock, 2 o'clock, 18th at 2.
2 o'clock.
Annexure B4 is my reference.
Premises in question, 18th December at 2 p.m. The petition is directed to be remain present at the time inspection of the premises. Full stop. The CSC is directed to file the report on 22nd of December 2024. Leave the matter on 22nd.
Madam, can it be on 23rd?
On 23rd.
Urgent motion.
Under the same heading.
Grateful.
তোদের নামের আগে দিন।
Next.
Item number 23.
I am for the respondent in this matter led by Mrs. Aparita Ghosh. Lordship, I am praying for not today, my lordship.
Yes.
I am praying for not today.
Why?
My lordship, Mrs. Ghosh is appearing before some other.
So tomorrow it will be the last matter of the.
No, I will suffer. Then I will suffer. No, my lordship. I am for the petition.
Freezing of the saving. Who has freezed the bank account? Who has freezed?
Without showing any risk.
Who has freezed?
Lordship, there was an order there was a judicial.
Who has given the order?
Lordship, I am.
Has the bank or bank
Yes.
has the
Bank.
whose instruction the bank account has been freezed?
Lordship, I am lacking any instruction. Lordship, I will be back tomorrow.
Well, out of 3, 1 has been released. After filing, one released.
In whose instruction it was freezed?
Well, no intimation, no information, even how I have been entangled with the facts or with that very illegal, that has not been yet to known to me.
Consider the later judgment of the Bombay High Court, Division Bench, Bombay High Court.
Well,
Last week it was. Cannot.
Lordship,
Even the police authority cannot without the order of the court.
I am lacking any instruction, my lordship. Lordship, may kindly keep it tomorrow.
When?
Anytime, my lordship.
You sure that your senior will not be having any matter tomorrow? Then you will appear.
I have.
As per the prayer made by the counsel for the respondent, the case is certain that the matter appear tomorrow under the same heading.
Thank you, sir.
Well, affidavit service be kept with the record.
Affidavit of service we kept with the record.
Sir, thank you, sir.
I'm grateful.
Item number?
Supplementary list for the item number 1.
It's 228.
228.
Next matter, my lord.
1 minute is.
But next matter, my lord.
I will take. Let's supplementary.
I had mentioned in view of the urgency tomorrow.
Yes, I will take.
Oh.
Not today.
No, next matter.
No, supplementary later, then I will.
Oh,
But I appear for this case.
Who is for the?
Again, my learned friend has come up with the mischief matter.
Have you brought that the permission?
No, my lord, no permission because permission is not
I'll
for
just-
any permission.
I'll just run very briefly, my lord. Initially, the application was for a rally followed by a meeting. Now, my lord, para 4, we have specifically pleaded, we are not having the rally. We are having the meeting at the football ground, my lord, of this particular club, which has granted us the permission, the no objection to use their land. The only, my lord, limited extent to which, my lord, we are knocking the doors of justice is, my lord, 8th of November, we had approached the SDO seeking permission to use, my lord, the loudspeakers and amplifiers. But there is a deceptive silence as usual, my lord. Tomorrow is the meeting.
Just now, well, I've taken instructions from the subdivision officer. But what has happened, Lord, this is similar to the procedure, Lord, no objection from the police authorities. But that was not done. That's why, Lord, he has said so. But if court directs, Lord, it can be.
Well, I am in fact armed by, my lord, an order passed by your lordship only, my lord.
The memory.
Memory.
জানি তো বলো না তুমি দেখানোর কি আছে so many orders. So many,
It's a small gathering of 2,000 people only.
2,000 blood only blood. I will beseech your lordship.
In the sports
Blood,
in the
kindly
football
blood,
ground.
kindly reduce the numbers.
How it cannot
And
be
kindly blood, দেখো,
the-
সব জিনিস মেনে নিয়েছি একটু মানো আমাদের
but it's a private
Blood,
land.
What is the gathering?
2,000. Only 2,000. Memory was 7,000.
Lordship kindly blood
Memory
reduce
was
the numbers
7,000.
and reduce the microphones blood your lordship.
Microphones, my lord, in terms of yes.
As per the
In terms of, my lord, the conditions laid down in your lordship's order.
No, that is sounds blood.
Permissible limits.
Limits, but blood the so far as the blood the microphones blood, that is the blood speakers blood your lordship kindly reduce that.
How many
30 speakers your lord. Yes, 20 speakers they have said.
But 3 speakers,
No, 3
mics, 3 microphones plus 20 speakers.
20 speakers.
So it's
Let
my
it
lord,
be 10,
the stadium
let it
itself,
be
my lord,
10 and blood 1,000.
the football ground
Only blood I
can
beseech your
house,
lordship.
can house 15,000 people.
And
It's a
blood
small
without-
meeting, my lord,
Without disturbing the
of 2,000.
convenience
That-
of the public at large.
that-
blood,
But
lordship
we are not
kindly
having
blood-
a rally, my lord, so that it's on
No,
a
no,
private
not
land.
rally, blood.
It's on the land.
They will come.
It's on a land belonging
They
to
will
the club.
not. They will not come on the air.
It's
They
on a
will
land
come
belonging
to road.
It's on a
Lordship,
land.
kindly blood.
It's on a land belonging to the
And
club, my lord.
specify that blood, lordship. Blood,
Even, my lord, last Sunday, Calcutta witnessed, my lord, a gathering of over 5 lakh people, my lord. There, my lord, I understand, my lord, there was no traffic snarl. There was no, in Maidan, my lord, there was a,
নিজে এসেছো তো সেদিন 10টার সময়
there was
বাজে
a
কথা বলছো কেন?
রোববার দিনকে কোথায়
তাহলে রবিবার কোথায় 21 জুলাই তুমি বলেছো যে এত
রোববার,
সুন্দর
রোববার,
কন্ট্রোল হয়েছে ও
রোববার,
যাই হোক, ও বলুক
So these are my humble submissions, my lord.
lordship kindly blood take note of it blood number and
First it was number of participants, now
number 2,000 they are blood, let it be 1,000
but they cannot regulate, they cannot do that.
1,000 and blood the speakers 20 blood,
But
it will be 10.
But neither the
Your lordship blood and
my short response will be, my lord. Very well.
You applied for how many speakers?
But we have applied for, my lord, page
20.
23,
Where is their application?
page 23, my lord.
application সেখানে কোনো বলা নেই
3 microphones, 20 speakers.
So you will not hold the rally?
No, we
Only
are not
public
holding rally.
meeting.
Para 4, we have specifically pleaded, my lord. There is
Public meeting.
only a public meeting.
So rally will not be there.
No.
Public meeting from which time to which time?
But from 3 to 8.
3:30,
From 3 o'clock to 8 p.m.
3 to 8 p.m.
Yes.
Three
My
to
lord,
8
may,
PM,
my lord,
your
may,
lordship.
excellent. My lord may kindly record that by 8 o'clock, the entire gathering will disassemble, my lord.
but
আমরা হয়তো 7:30 মধ্যেই শেষ করে দেবো 8টার মধ্যে
3 to 8 p.m. Then
3 to 6 your lordship kindly
I will come to you.
3 to 8, my lord. It
3
is
to
there in
8.
the subject matter.
11, 12, 20, 25.
Yes. Place of public meeting is Amta Sporting Club football ground.
Yes.
Expected participants 2,000.
Yes.
And the stage details we have indicated, microphones we have indicated.
Public meeting, details of stage is also there.
Yes, there will be a
Open stage it is.
open stage.
Speaker 3 plus 20.
3 plus 20, my lord.
Three-
3 microphones and 20
20.
speakers, yes.
And volunteers 200.
200
Volunteers, my lord, we have already, my lord, furnished names of page 27. We have annexed. We have furnished names of 10 volunteers. Even if they want any more, my lord, we'll do it by tomorrow morning.
50 volunteers minimum blood
50, very well. We'll furnish names of 40 more volunteers, my lord, by tomorrow morning. We'll furnish it to the SDO, right?
Yes.
The SDO.
What is your no?
I have already
1,500. 1,000.
1,000 and blood the 20 to blood 10
Huh?
20 speakers blood it may be 10 And my lord, the time, my lord, 3 to 6. Only, my lord, this is my submission.
20
And
speakers.
without disturbing the convenience of the, my lord,
No, they have asked for the 20 speakers.
20 speakers, but I visit your lordship 10 speakers.
10.
10.
And microphone 3.
Microphone 3.
And volunteers for 40.
No,
50, total
10
50. 10 we have
names they have
provided,
given.
40 more.
For the 30.
But my short response will be, neither the police nor the SDO, my lord, has any authority envisaged under the 4 corners of, my lord, the Police Act to make this submission regarding reduction of speakers if we use it within the, my lord, permitted sound levels, my lord. And regarding the gathering, my lord, also, the police, my lord, since it is a public property, under section, it's a private property, under section 30, the police has, my lord, no authority.
Police, my lord, I'm not.
I'm just responding.
I've submitted on behalf of the subdivision.
Oh, then the subdivision officer even, my lord,
No,
does not have more authority.
There
He has no authority,
Yes,
my
yes,
lord.
no.
He has
Sir,
no authority, my lord.
Administrative.
I'm grateful to Mr. Banerjee.
Your lordship can't
But
say.
you applied before the sub-DO.
Yes.
We applied before the SDO
SDO.
for the sound permission, and initially the contemplation was a rally
Police.
followed by a meeting. So we had addressed representation to the SP,
Public convenience
OC,
should
everyone.
not be disturbed. Your lordship kindly make it clear.
The petitioner has filed the present application praying for a protection, praying for upon authorities. The petitioner President of Aurora district within bracket rural Bharatiya Janata Party to organize public meeting from 3 p.m. to 8 p.m. by using 30 microphones and 20 speakers. Their expected number of participants are 2,000, and the place of meeting is Amta Club Football Ground. Learned counsel for the petitioner submitted on 8th of December 2025. The petitioner has applied for permission to the subdivision officer for conducting meeting on 11th of December 2025 at Amta Sporting Club Football Ground from 3 p.m. to 8 p.m. in a peaceful manner, but till date, the counsel for the petitioner submitted the Amta Sporting Club Football Ground, wherein the petitioner intended to hold the meeting of Bharatiya Janata Party is a private property, and the concern and the said sporting club has already granted no objection to the petition for holding meeting in the said ground. Learned counsel for the state submitted that the petition is to hold the meeting with the participants of 2,000 persons and also intend to use the 20 speaker, which will create the havoc to the general public of the area. And as such, she prayed for reducing of the participants as well as the use of the speakers. The petition is also given the name of 10 volunteers, but further 30 volunteers for conducting the meeting by the petition. At the learned counsel for the respective parties peruse the materials on this court find that the petition officer on 8th of December 2025 for conducting a rally as well as public meeting on 11th of December 2025 from 3 p.m. onwards. The authorities have not given any permission to as our for the submission made by the indicated. At the time of submission, the consent for the petition submitted, though the petition has applied for Delhi as well as the public meeting, but the petitioner will not conduct any the public meeting conducted from 3 p.m. to 8 p.m.
Because approach, your lordship, kindly make it clear, they will come from road or to the destination. But kindly make it clear.
Consent appearing for the
There will be no obstruction. আরে রোডে তোমরা যে আসবে কোথা থেকে ঘুরে আসবে
একে একে করে আসবে
একে একে করে আসবে ঘুরে আসবে নাকি
place, strictly directed that the general public shall not be disturbed and the
সেই প্যারাগ্রাফ পুরো বলে দিয়েছো না করছে তো বলছি তো যাওয়ার নেই এখানে মিছিল না
considering the above, the petition is about to conduct the meeting at Amta
this is
football ground from 3 p.m. to 8 p.m. But it is made clear that by 8 p.m. the total gathering shall be dispersed. And if the meeting shall be conducted in a peaceful manner without disturbing the general public of the said locality, as well as it is in the main road.
But it is adjacent to the main road.
Adjacent to the main road.
As well as the main road adjacent to the said sporting club. The petition is further directed to use the microphone and use only
But as per the prevalent pollution control norms as prescribed by the government of
15 microphones, use only
15 speakers, not microphones.
Speaker.
But speakers, I'll tell you, Lordship, these are all small speakers, which are most of them are on the stage itself.
At least
we have already indicated that kindly takes the application. At the bottom, we have indicated that the sound system will be used as per the prevalent pollution control norms as prescribed by the government of West Bengal.
That is
as prescribed by the government of West Bengal.
That is
already stated that.
But so far as the speakers are concerned,
People will come there to hear to the speech of the leader.
সবাই শুনবে.
And the petitioners shall abide by the all applicable norms and rules of the sound system as prevalent under the pollution control norms as prescribed by the government of police.
But Lordship, number your Lordship.
Number 2000 only. But in this very place, but this
making 15,
but this place is
1,500, 1,500.
This place is
kindly.
It is used as the helipad also. When VIPs come,
2000 nothing.
Yes,
nothing.
Just 2000.
They're not connected.
We are not.
During the election,
1,000 people.
But during the elections, my lord, there are around 15,000 gatherings, my lord.
And time 3 to 8 or
3 to 8.
Exactly.
They have to disperse the total public.
May I file the affidavit of service? Extremely
and
grateful.
if there is, your lordship, kindly make it clear. If there is any violation or anything,
It is made clear that
no hot speech and
Kindly make Mr. Shobhan Banerjee the special officer.
police will take appropriate steps.
Maintaining the peace in the said area. If the authority found that the petitioner is violating any terms and any
And the police should also, my lord, be vigilant enough to look after the law and order situation.
Yes, yes.
violating any law, the common the authorities are free to
It goes without saying.
The police authorities are also directed to make necessary arrangement so that the meeting can be conducted in a peaceful manner.
Extremely grateful, my lord. Henceforth, in all these matters, my lord, may kindly make Mr. Shobhan Banerjee the special officer.
My
He
lord,
can go and ensure whether there is
knows me from
compliance.
Yeah, not from the court there. Knows me very well.
Yes, call the matter.
Item number 24. Item number 24, my lord. The petitioner participated in the process for maintenance kindly comes to page 24 of the my lord brief.
Yes.
But this was notice for application for lease of maintenance of Mayur Mahal Picnic Garden at such and such.
Picnic garden.
Yes.
Yes.
Applications are hereby invited by undersigned from bona fide agencies for taking lease of maintenance of Mayur Mahal Picnic Garden at Rajghat, Hooghly for a period of 60 months. 60 months is 5 years. Terms and conditions laid down it's not required. I was selected, kindly comes to page 26. I came out as the, my lord, successful tenderer. But my lord, while allotting, kindly sees next paragraph number 2. Now you may proceed for taking over the overall charges of next page 26.
Now you may proceed to taking over the overcharge.
Charge of Moirmal Picnic Garden from 12th December 2022, which ends tomorrow, 11 December 20. So while giving, they have given me a term of 3 years. I have made a representation for my lord, considering my representation that it should be in accordance with the tender floated, which is 60 months, 5 years. My lord, since it is, my lord, expiring tomorrow, I'll be praying that let my representation be considered, and until there is any consideration outcome, my lord, let me continue.
And have they issued the tender for the?
No further tender process. No further tender process.
I am for the state, my lord. I am not.
Executive officer.
That is the executive officer.
Panchayat Samiti, who is for the Panchayat?
But the executive officer is the ex officio, he is the block development officer also.
Correct. Whether they have issued any?
No, it has not been issued. Not been issued.
So, but the other side, have you served the copy to?
Yes.
Where is the-
Affidavit of service has been given.
Yes, what is your contention?
I am for the state, my lord. I am not responsible, my lord.
Not
I am
responsible.
respondent. In spite of that, my lord, your lordship can direct the executive officer, that is the Panchayat Samiti, that is the respondent number 3, to consider that representation.
Consider
And-
representation. What happened? Tomorrow is the last date.
That tells us representation considered within 2 weeks from the date of consideration, that they will consider the representation, tells us disposal, status quo maintained.
Yes.
That is the order.
That is what I am praying, limited.
That is the order. That should be the order. Otherwise, you will.
You should be a respondent for every time before this.
Oh, no. Oh, no.
The petitioner is by the claim of the petitioner who has presented application that on 17/11/2022, the executive officer Golba Datpur Panchayat Samiti had issued tender notice the maintenance of Mayur Mahal Picnic Garden at Rajghat, Hooghly. As per the said tender notice, the period of these for a period of 60 months. That is for 5 years. As per the tender notice, the petitioner has participated in said tender and the petitioner was declared as a successful bidder, and the lease of maintenance of Mayur Mahal Picnic Garden at Rajghat, Hooghly was handed over to the petitioner. Petitioner submitted as per the tender notice, the lease period was for 60 months, that is for 5 years, but it was given only till 11th of December 2025, that is only for a period of 3 years. 3 years. And as such, the 3 years is going to be completed on 12th of December 2025, on 11th of December 2025. He submitted, he has made a representation to the authority, that is the executive officer, on 9th of July 2025, consideration of the case of the for the period of 2 years, but till date the time of this period is going to be of December 2025. None appears on behalf of the executive. In spite of service of Learned counsel for the state submit that he has nothing to do in the matter. It is the case of the panchayat, and as such he has no role to play in the matter. Had the learned counsel for the respective the counsel for the petition we find that as per the tender notice, the period of lease, the lease has been the tender has been published for a period of for the maintenance of Mayur Mahal Picnic Garden at Rajghat, Hooghly for a period of 60 months. That is for a period of, that is for 5 years. But but it is the same as given only for the period of 3 years, that is up to 11th of December 2025. The petitioner has already made a representation to the authority for consideration of extension of the lease period of 2 years. The same is pending. According the writ petition is disposed of by directing the executive officer, Olba Datpur Panchayat Samiti, to consider the representation of the petition dated 9th of July 2025 within a period of 2 weeks from the date of receipt of the order till the disposal of the representation of the petitioner. Status quo with regard to petitioner shall not be. The petitioner shall be allowed to continue with the lease period. With the lease period. ये तो period बोला ना. Consider and pass in a period of 2 weeks. Order after giving an opportunity of hearing to the petitioner. And if the authority found that the petitioner is entitled to get the lease extended for a further period of 2 years, the same can be extended. If the authority found that the petitioner is not entitled to get an extension, the authority shall pass reason and speaking order within a period of 2 weeks thereafter. Till the decision is taken, the authorities are restrained from taking action from taking possession of the premises in question from the petitioner. The petitioner shall continue the lease period till the disposal of the representation. WPL is okay.
Item number 19,
On the next matter, Mala 25, I am directed to file a report of the legal amendments. It is that matter where assistant public prosecutors were.
Yes.
If I may.
Just a matter of I will call.
Don't know.
Okay, no problem. Which matter? 26 Monday. Mr. Ghosh, it will take time.
No, 2 minutes. They've given the report. As far as my grievance is against the
Monday.
When the petitioner number 1 and 2 are directors of the petitioner number 3. Directors of the 3, then we got this notice on the 11th of October saying that we have ceased being directors, including petitioner number 2 and the new directors we appointed. So we wrote to the ROC that this is done, that we couldn't have overnight, we cannot cease to be directors. Now the ROC and the DIR form that was uploaded is defective. That was our ground because we have not resigned and nor have we been removed. My lord will see the instructions the ROC has submitted on the next day, on the last day. Paragraph 6 mainly, 6 and 7. They are admitting. Then I'll show the form. The private respondents who my learned friend is appearing for, they have submitted this form, and I'll show my lord where they've said that we have resigned. Yes. Your lordship sees paragraph 6 and 7 of their instruction. So, and now if my lord sees the form that they have produced, page 1 of 13 at the bottom, the next after 2 pages, my lord, that is the name of the petitioner number 1. And if my lord comes to page 3 of 13 at the bottom, the reason for my cessation is resignation. Under 168. 3 of 13 at the bottom.
3 of 13. Resignation under 168.
168. And then if my lord comes to page 11 of 13, they say that the attachments right at the end, notice of resignation, letter PDF, but no letter is given. There is no letter. My grievance is only against the ROC. As far as the private respondents are concerned, your lordship, there is a dispute between us. They have, and your lordship will see their reaction. I have filed a supplementary affidavit. If my lord comes to page 5 and page 8, I won't say anything further. put it easy, they can, I'll show it again. If my lord comes to page 5, this is the day we filed the writ petition, we received this. This is a show cause issued by ROC. The main thing is in page 6, paragraph 9. Page 6, paragraph 9. It is noticed from the MCA portal that DIR 12 has been filed by number such and such for resignation of directors. Whereas the form has been filed for resignation of directors, no resignation letters from any directors have been attached. And the said e-form has been digitally signed by the directors and PCS, Pallavi. So the respondents 4 and 5 have signed this letter. Hence, from the above, it is seen that the directors have been removed, mentioning incorrect sections. That's me, the petitioner number 1 and 2 and 5 other directors have been removed. Incorrect sections of the Companies Act without attaching proper documents. Then certifying director, Mr. Abhishek Jain, that's my learned respondent number 4, is directed to furnish explanation in this matter, and Pallavi Bhagat is directed to give explanation to show cause why disciplinary proceedings will not be taken. And then, my lord, page 8. So this stand has been corroborated by the instructions. I've read out the instructions, paragraph 6 and 7. They are saying that they have not got a resignation letter. We have, of course, pleaded. We are running the company. We are 52% shareholders. We have not resigned. My lord, page 8 is the representation made by the respondents 4 and 5 on the 13th of October. My lord will see the straight, if my lord comes to paragraph.
So now what you want?
No, I want that is to be downloaded. That DIR 12, which is defective and it has been fraudulently done, it will be set aside. As they have said, they have no objection in doing so. But my lord will just allow me to place one part of their letter, my lord. Page 12. Their representation, why they gave this letter, they've explained it. Page 12 of the supplementary, paragraph 6. So we had appointed 5, after giving notice resolution, 5 directors had been appointed on 10th of October. Then, on notice of such illegal act, the Jain group subsequently took remedial steps and filed fresh form of DIR on 11th October to protect the interest of the company and stakeholder. So just to protect them, what they thought will protect themselves, they submitted a form saying that all 7 of us has resigned. And now they are show caused, of course. And then your lordship will see the last paragraph. They reserve their right to take action under 241 because I had appointed new directors. That is there. I am not even adjudicating one bit of personal rights. They could not have put in this form without following the procedure. 168, I'm not placing. There's a procedure. I'll have to resign, have to give the 30 days notice. Someone has to accept my resignation. That whole procedure is there. But I am before my lord, I haven't resigned. And now they have said that it is submitted prima facie. This appears to be defective and the cessation is null and void. But on this short point, there should be no further argument as far as at least the respondent, the ROC is concerned.
Yes.
I have filed, my lord, as per your lordship direction.
Yeah, that wasn't my lord's direction. My lord looks at my lord's order. My lord of the 4th of December 2025. My lord will kindly find. My lord will see, my lord, 8. Registrar of Companies directed to bring all the connected documents on December 8, 2025. He has not, my lord. It's only, my lord, I find, my lord, what he has given us. My lord, it's instruction in the matter. My lord, if my lord looks at, my lord, that document. We find it, my lord, a very, nothing signed, nothing on record, my lord, only instruction in the matter.
My lord, in my most respectful submission, my lord, they have filed as.
Yes. Let me just, my lord, first, my lord, is that. My lord, I quite perfectly understand, my lord, Mr. Ghosh's points. But, my lord, there are 2 issues. First, my lord, if there is a defect in the form, in terms of, my lord, Rule 11, it has to go to the regional director, my lord, for him to, my lord, look into it and then, my lord, decide on the issue. Secondly, my lord, kindly see why the writ petition has been filed. There are, my lord, 2 directors on his side, 2 directors on my side. My lord, they are the Godha group, I am the Jain group. He says he has 52% or what? I have, my lord, 48%. He appoints 5 directors, my lord, without calling for any board meeting, gen meeting, no notice and nothing. Then I raise a complaint to my lord the ROC, which is my lord what my lord should have been my lord also produced along with the ROC's report, which my lord is in the supplementary affidavit, which my lord Mr. Ghosh has filed. Kindly my lord see.
That
So
is
I
also
have
produced.
challenged. No, what I'm saying, my lord,
Report I filed
by-
10 is, if
it's in the supplementary affidavit. My lord, by way of my lord this writ petition, he cannot legalize his own 5 illegal appointments. Because quite naturally, my lord, these things generally don't come, my lord, before the writ court. Because, my lord, it's disputed questions of fact. Now, my lord, kindly look at, my lord, that letter, my lord, which, my lord, we have filed. And this is an earlier letter before, my lord, the forms. My lord, page 13, my lord, will find.
Take time, Mr. Banerjee.
I will, my lord, because, my lord, I can, my lord, file an affidavit to put this on record, or, my lord, whatever it is, my lord, is there. Because even if the form is filed defective, doesn't mean, my lord, his directors, my lord, become legalized. Because he himself has committed illegality. So
That's
he is
not
the
the
one, my lord, to
challenge.
first cast, my lord, or throw a stone.
No, that's correct.
That's not under challenge.
Challenge with regard to their 5
No.
directors in the writ petition.
I have, that's the complaint I've made to the ROC.
Made a complaint.
Yes.
But otherwise, if subject to correction, because already the application with the form, it is defective.
Form is defective. I appears, my lord, they should have, my lord, put the resignation letter if there was defect, my lord, if there was resignation. But I don't want, my lord, his 5 illegal directors to be legalized.
Correct. In that case, I am
Without prejudice to our rights.
disposing of this matter. The
Yes.
form which they filed, it as per the report, it is defective.
My lord,
So that
his form also should not be accepted. What will happen, my lord?
that cannot be taken into consideration. And if the ROC is wanted to take any further action, take appropriate action in
But may I just show, my lord, that rule 11?
With regard to your contention, you also raise the contention.
Because what will happen as soon as, my lord, my form, now his purpose, my lord, is to come and say, oh, look, it is defective because no resignation letter. As soon as my form goes, his forms, my lord, will stay.
Yes.
Yes, Mr. Ghosh, I know that is your purpose. That is exactly what I'm saying. Yes is the answer. My lord, that's exactly, my lord, what he wants. Then, my lord, his last form which he was filed with, my lord, the 5 illegal appointment will now be there, and he will go and say, look, the High Court has accepted. That's my form. Because the registrar, my lord, should have then made an inquiry in my complaint as well.
Correct. That's I'm telling. So I will direct the ROC to consider the case, both the parties.
Yes, both the parties.
Giving an opportunity
Yes.
to consider.
My lord, both the parties, my lord, his appointment should also be considered. The 5 appointment, my lord, which he makes.
You raise your contention.
My lord, if your lordship kindly
Well,
see
they
my
have
lord,
not-
page 5 of
Yes.
the supplementary affidavit. We have already, my lord, written to the, my lord, Nidhi, my lord, that the company, maybe Creative Infrastructure, that is, my lord, the letter dated, my lord, 7th of November 2025. If your
Para
lordship
five.
can take, my lord, yes, my lord, page 5
Page
of the
5.
supplementary affidavit, my lord.
Yes.
Correct.
They should show
Yes,
cause. They
we have
should
already
give the show
show
cause.
cause and everything, my lord.
Yes.
Your lordship kindly come to the my lord, paragraph 9.
No, before that, please show paragraph 1.
Acha,
Please show paragraph 1.
Yes, yes. Copy of the notice of meeting to all the directors and copy of proof of dispatch of notices to all the directors in pursuant to section 173 of the Companies Act 2023 from the period 1/4/2024 to till date be given. Now, my lord, 9. It is notice from MCA portal that DIR 12 has been filed with a SRN number such and such for resignation of directors under section 168 of the Companies Act 2013. Whereas the form has been filed.
Yes, that Mr. Ghosh has already.
Yes,
pointed.
that's so far as his complaint is concerned.
So cause notice, my lord, in this, my lord, if your lordship kind of takes, my lord, it's, my lord, to so cause, my lord, in the complaint of Abhishek Jain and Mahavir Prasad Jain, it is stated that the auditor's report clause 2E states that written representations were received from all directors regarding disqualification under section 164(2). However, no such declarations of the Jain group directors have been given or discussed in any meeting whatsoever. So you are required to explain about the said section. You are therefore directed to furnish information, explanation, parawise, comments.
So you have given the notice to all.
Yes.
So let the authority decide.
Yes.
But as far as this notice is concerned, admittedly, my lord, I showed the letter on the 10th. They received the notice. 11th, they filed a form. No resignation process has given. They've made a misstatement in the resignation. That's been shown, pointed out. No submission is being made on that. They're only saying yours was bad. Therefore, to protect myself, I have done this. And they will succeed. Is that the procedure?
What will happen to
They will have to do it in accordance with law.
What will happen to your application? That is not in accordance with law.
Yes.
No, my lord, 2 things happen, my lord. If my lord, my form is incorrect, then my lord, it will be marked as defective, will not be accepted.
Finished.
But my complaint which I made before the Registrar of Companies with regard to his 5 appointment, because it was 2 and 2. What you do, you first cleverly, wrongfully and illegally appoint 5 directors. When I come to know, according to me, you have resigned. I file a form. Then you come to the writ court to say, please cancel his form, which means, well, to get a stamp of approval.
No,
So far as
that's why the court is not going.
that is what I'm saying. Well, that is the two things. That is, well, that's why, well, just kindly see, well, page 8 once, just page 8.
Page 8 of supplementary.
Of supplementary, well, where my complaint is also, well, I'm the Jain group.
Yes. Yes, that has been on page 13.
Yes.
Paragraph 6, paragraph 6 of page 12.
Yes.
Illegal Jain group subsequently legitimate.
Well, page 8, page 8.
Yes.
Paragraph, Malad, 1, Malad will find, fail to circulate notices, agendas and minutes. Then Malad will, the detail, I don't want to trouble my lord with the detail. Then Malad kindly straight away come to page 12. How Malad this, page 11, last paragraph. Paragraph 5, kindly see, Malad. That Jain group, which is me, was shocked to receive an email dated 10th October 2025 from Ministry of Corporate Affairs portal. That is no reply and such, and which states that following individual has been appointed as directors. There are 4 of them. 5 of them.
Correct.
It is hereby clarified that Mrs. Nirmala Jain, Nisha Jain and Nidhi Abhishek Jain are relatives of the Goda family and the surname should not be confused with the Jain group. Jain group is represented by Mr. Mahabir Prasad Jain and Abhishek Jain only. Mr. Arunad Datta and Mr. Raju Das are not unknown to us. Copy of the email dated 10th October that this purported appointment is illegal, fraudulent and blatant violation of the provisions of the Companies Act and rules made thereunder, and it shook the conscience of the Jain group. The Godha group has taken this blatant, illegal and fraudulent action simply because Jain group asked some basic questions on the functioning of the company. If the company is showing 43 board meetings in a financial year, Malad, has that, Malad?
Yes, yes, yes.
And no notice of any information at all was shared with Jain group, then it was duty of the Jain group to ask questions on the functioning of the company. Godha group, instead of answering the legitimate questions asked by the Jain group, decided to usurp the whole company by illegally and fraudulently filing the form DR 12 with the Ministry of Corporate Affairs regarding the appointment of their own persons.
So, correct. This is your complaint.
So, well, first he does it.
Correct. So, this is your complaint.
Yes.
And where is your complaint? You have made any complaint?
Yes, yes. After I was removed, the 13th of October, page 274, 75, 76. That's the first document I showed, man.
274.
Yes. 274 or 5, actually. Yes, yes. 274 is what I received. 275 is immediately I wrote. And this on, I also wrote on the 13th. On the 13th also, I was allegedly removed as a director.
So 274.
274 I received. Then 275 I filed a complaint.
Filed by whom?
Filed by P1 and also by the company through P2. That's the next letter. My lord, but your lordship will note in these letters, 275 and the next letter, we asked for this form to show us how did we resign. So now the form has been produced. So my grievance against ROC is done. Without prejudice, let us fight out this thing. As far as my appointment is concerned, there was no any doubt. I was the petitioner 1 and 2. I've appointed new 5 people.
That's why.
So that challenge, in accordance with law.
You have filed a complaint, though they have submitted the report with the
Yes.
DR is defective.
Yes.
Correct?
This chapter's over.
They also filed a complaint that is at page 8
Yes.
of the
Yes.
supplementary.
Yes.
Let the ROC consider you got the form.
Yes.
So you give your representation with regard to the form, and the ROC will decide all the
Your DR and my DR.
But this particular form, your lordship will quash and without prejudice to all our rights and before the registrar.
I record the
Yes.
submission, I record the report, and I will
Yes.
send the matter to the ROC. ROC will discuss.
ROC, Malad, will not have the jurisdiction. Malad,
Who is the authority?
Malad, kindly look at Malad. Rule 11.
Yes.
Because I don't want Malad, Mr. Ghosh Malad, to use this proceeding to legitimize Malad his illegitimate.
No, but
what I don't want.
he has to challenge it in the accordance
Kindly
with
see.
law. He has just gone and put a fraudulent,
kindly
my lord,
look
a
at
client,
Malad.
litigant who has given an palpably false submission before a authority is coming and
Mine is also palpably
saying,
false because it did
no,
not been
you
caught."
prove mine is false. I'll show the board resolutions
I'm
that
quite
were
happy.
taken.
Mullah,
Notice
let me
was.
file affidavits, I'll prove it, yours is false.
Which
Mullah, rule 11, Mullah, at the site, Mullah, will find, Mullah, on the.
But it's not applicable for resignation, Rule 11. It's not their case that they've been removed or vacated.
The registrars are verified, that's same.
Mullah, regional director, Mullah.
No, I need see the 11(1).
Mullah, sub-rule 2.
Sub-rule 2, if the registrar on verification documents find that the company has violated any provisions.
He shall refer the matter to regional director.
So he will refer.
Yes.
First the registrar will say.
So, Mullah,
then-
Malad, 168
submit
comes
this?
under Rule 15. Why is this being shown?
Mullah, his DIR also has to be
Rule
considered.
15.
Either, Mullah, we both get relief here, or Mullah, we both do not get relief here. Mullah, my firm being marked defective, I understand.
Rule. Where's that rule?
So in
15?
accordance, Mr.
In which one?
Mr. Bose, if this court pass an order in accordance with law, the registrar or the competent authority shall hear both the parties.
Yes, and both DIRs will be considered.
And with regard to the DR form, which has already admitted that may also be taken into.
Yes.
That should be struck down, Malad. Otherwise, on record,
DIR should
without
also
a
be
single resignation. Admittedly, he's not saying I resigned. He would have produced the resignation letter. I wouldn't have anything to say. On the face of it, I am the
saying you are not
director.
director. You're illegal
I'm
director,
not a
appointed.
director. I've been removed. By who? And they are saying only by protection. So when
Pass order.
your lordship will stay the DIR 12.
Yes, concluded. Tomorrow for orders.
Form not be given effect. Mullah, both DIRs, Mullah, should be then, Mullah, considered.
No. Malad, as far as the form,
matter should
even
be heard
today, someone can tell me who are you now, but that form, there should be a status quo, there should be a injunction.
Pass the order tomorrow. Come.
Great.
Milord, it will appear as for orders tomorrow.
Matter appear tomorrow on the heading orders.
Mullah, I hope, Mullah, I've been, Mullah, kindly protect, Mullah. I'm not saying, Mullah, kindly protect only my right, his right also, but my right should also be protected. Because this writ petition, Mullah, then he'll go and go anywhere else and say this is now approved by High Court.
Okay. Sure.
My lord, seeking leave, my lord,
वो एक था ना.
seeking leave to mention.
It's the junk that leave.
Leave to mention, my lord. Sorry, my lord.
Next matter 25 we take
Yes,
up.
सुनता नहीं यार.
25 to return.
पहले तुम अपना काम कर लो.
On item 25 we called on, I have to.
All करो ना मैटर वही उनका अर्जेंट मैटर था.
Your lordship direct the alert to submit a report. May I submit the report, my lord?
That appointment of the public prosecutor in the last occasion.
Two matters, please.
And may I get the report?
Yes, sir. But this is not the administrative domain of the legal remembrance, sir, but it is the domain of the, my lord, the Directorate of Prosecution. And that's why, my lord, it has been on inquiry. It is found that two learned advocates are there as assistant public prosecutor. Lordship will get it at page 2 at the top.
Yes, got it. Got it.
So, my lord, this matter can be disposed of in this fashion.
My lord,
Nothing remains.
Yes.
anybody can.
And it remains.
But regarding my lord,
nothing remains.
number 2, my lord. No, my lord, regarding number 2, my lord, the name, my lord, against her, my lord, there is a complaint because she has acted in contrary to the orders passed by this honorable High
He
Court.
cannot have any choice. He
No,
cannot
my lord,
have
I
any
don't have any choice.
Then the court, the
But
presiding
number 1, my lord,
officer is there.
my
He
lord.
will take the.
Lordship.
So I am disposing of.
Yes, yes.
But kindly note, record my submission that for the number 2, there is an allegation and a
That will
writ petition
demoralize
is
them.
pending before this
That
honorable.
will demoralize. That cannot.
Kindly
that
record
cannot
my
be
submission.
This cannot be done.
No, I will record.
In
No,
terms
no,
of
no,
the
Lordship.
order passed by this court dated 2nd December 2025.
Sir, engage hoega.
The Leonard government pleader. You are the government pleader.
Lordship.
Government pleader, no?
Yes, I am the government.
Leonard government pleader has submitted a report from the legal remembrance of the government of West Bengal, wherein it reveals that Srimati Lopa Mudra Das Nandi is appointed as Leonard APP to the court of attached to the court of Third Court of Judicial Magistrate Chandan Nagar, Hooghly, and Srimati Tamali Biswas, London APP, attached to the London Second Court of Judicial Magistrate Chandan Nagar, Hooghly. Learned counsel for the petitioner submitted he has no objection with regard to the appointment of Srimati but he has certain reservation with regard to Srimati Tamali Biswas, as there is already a complaint against Tamali Biswas while performing the duty as learned APP on the earlier occasion. On the earlier. This court.
And a read petition is pending for the purpose, my lord. For removal of that is pending.
We further submitted for removal of Tamali Biswas, a writ petition is pending before the which court?
My lord, before this court.
Before this court. This court find that.
My lord, that is not in the list, my lord.
This court find that in the present application, the petitioner has filed an appointment of NFUP for conducting the case number 619 of 2012, GR case number 426 of 2013, GR case number 475 of 2017, pending before the second and third court, Chandan Nagar, Hooghly, and accordingly the government has appointed the learned APP. Thus, this court has not gone into the disputed question whether there is any complaint against Srimati Tamali Biswas, as the matter is pending adjudication before you.
Well, I have no knowledge about any complaint against that. I have kindly record that.
Peter submitted he has no objection, he has no information whether there is any complaint against Tamali Biswas. Considering the above, this court finds that as the government has already appointed the learned APPs to conduct the case on behalf of the prosecution, according nothing remains in the presented application. According to WPA number 26110 of 2025 is disposed. The report submitted by the government Peter be kept with the record.
Lordship.
Probably.
That's all.
My lord, may kindly allow me to mention item number 31, my lord. Urgent leave was granted by the lordship in item number 31.
Which one?
Item number 31, my lord.
It was a matter which I mentioned on Monday regarding the technical.
Come tomorrow.
Can it be upgraded? थोड़ा upgrade.
तो टॉप कर दो.
31.
शर्मा जी को एकदम टॉप में कर.
I am grateful, my lord.
No, not further.
Yeah, it's a truth.
Come tomorrow. Tomorrow is the mentioning date.
Lordship, may I?
Urgent side.
Lordship, may I be? When there is the original side, very urgent.
Wait. Let my staff.
Oh yes.
Change.
Wait, staff change to original side bolo. My lord, may I be permitted to mention one matter? Today's item number 29 of the urgent motion list, my lord. This matter is pertaining to the urgency because it is of the safety and security of the child, my lord. So tomorrow kindly fix it up, my lord. Tomorrow is not the date, my lord, of the urgent.
I already reached 24. Only 6 matters there tomorrow.
There is a severe urgency. All right, my lord.
If it is in the dawn, you mention them on.
Lordship, I was mentioning a matter which is an application for contempt, item 146 of the day's list. My lord, this is a new motion matter. My lord, Lordship had passed an order in the testamentary court directing status quo. Now, despite the Lordship's order, the immovable property which belongs to the estate has been sold. In the meantime, the learned testamentary court has already granted the final probate also. But in the meantime, we have come to know Lordship last order was 25th July, where Lordship has said that they will no further alienation, encumbering disposal. But the property has been sold for about more than 11 crores. Now, I was only praying, till date, even direction for affidavit has not yet been given because the matter could not reach. If it can be posted on
the other side.
Other side, we don't know because after service has not been called. I was indicating, Friday, if it can be kept at 3 p.m., we will inform
keeping, let other
on Friday.
On Friday, Lordship, or
Friday.
Friday, to be mentioned, we will inform them. So that at least direction for affidavit can be given. Because unless they appear and file affidavit, Lordship can't even issue the rule also, my lord.
My lord,
Good.
my lord, may I have your lordship's kind leave to mention, my lord, for correction in the judgment of your lordship's
Original side.
original side, my lord.
Which date judgment?
My lord, 17th September, my lord.
17th September, now you are coming.
My lord,
After 4 months.
only one defendant, my lord, not defendants, my lord.
That's all.
That has to be corrected, my lord. And my lord, when the decree was to be passed, my lord, on that time, my lord, this has stopped.
See, again you mention another's.
But
And
others,
we-
my lord, and others are the my lord, they are the pro forma respondents.
So maybe
They are the pro
either
forma.
performer or there are defendants, so others will come. If others will come, then S will come.
No, my lord, kindly delete S, my lord. Defendants, my lord, kindly care. Otherwise, my lord, this is a money claim, my lord. The pro forma respondents are the legal heirs of the plaintiff, my lord.
To be mentioned for correction, में file नहीं किया.
My lord, I am.
May I have my lord's
my lord, I am
kindly leave to mention, my lord, item number 13 of today's list, my lord, the interim order is expiring today, my lord.
I am opposing, my lord. I am for the.
As
defend
expected, my lord, she would definitely
No,
oppose.
my lord, defend number 1, 2, 3 will not oppose because they are benefited with the order. It is the bank only who is suffering. with
Item
the
number
order.
13.
13, my lord.
From last 2 years, we are suffering order or substantial.
My lord,
amount is that-
Why the bank is suffering?
My lord,
The bank is
My lord, this is that property issue, my lord. Surfacing measures taken. Property is not partition. Plaintiff is, my lord, I represent the plaintiff. Lordship was pleased to pass an interim order because measures cannot be taken.
The bank
It
is,
has been.
bank is not appearing in DRT to oppose my application. Here they are objecting it. As
Sir,
if
this is a hearing matter. It will take some time, my lord. Kindly extends it, keeps it any day.
reply at their end in the application is due, my lord. Kindly fix it within 1 to 5 matters, my lord, this side of vacation because the bank is suffering. I am in a bad position. I am not able to answer.
Whichever way lordship wants it, but kindly extends the interim order.
Issue, my lord, to the application.
Counsel for the petitioner plaintiff praised for extension of interim order. Counsel for the defendant number 4.
Yes.
Defendant number 4, my lord.
And defendant 1, 2, and 3.
So objection and submit that due to the interim order passed by this court, the bank is suffering badly.
No appeal preferred.
It's not a
The
ground for
counsel for the respective parties.
the barring me
This
from
court find that the interim order, the plaintiff is already enjoying the interim order for the last several months. Accordingly, the interim order is extended till. I don't think the matter will be taken up till 23rd of December 2025 or until further order, whichever is earlier. Let the matter. It is in the list, na?
It is in
Let
the
the
list.
matter remain.
and may it be upgraded.
Remain in the list.
It's appearing as 13, but it's not.
Let us see.
One is not.
Permit to mention item number 102 of your lordship's list.
Remain in the list.
It is, this matter is relating to electricity. Petitioner number 1, who is a cancer survivor, is without any electricity and the son of the petitioner.
Item number
102, your lordship.
102.
102, your lordship. If this could be upgraded, your lordship. This is my only prayer. And the son of the petitioner number 2 is about to appear in the board examination of ICSE, your lordship.
Examination of
ICSE, your lordship.
ICSC.
And petitioner number 1.
Who is for the other side? CSC.
Yes, your lordship.
कब लेते court application?
Also, let it be upgraded.
16th at the top, inform the other side.
Alright.
Yes, call the matter.
Prevention. But only for extension of time for completion of the commission. Plaintiff's witness is there, my lord. And one more witness probably.
Only one witness.
Oh, so my lord, I have only one witness. So kindly.
Plaintiff witness is over.
No, my lord, 1 or 2 days it will be still left. We are cross-examining it.
And you will adduce further witness.
One witness. We will have one witness. So, huh?
Here for the petition.
ওটা তো আর নেই বলছে।
Your evidence is closed.
No, my lord, I am cross-examining them. 1 or 2 days will be, their witness will be over.
Though the matter is fixed today for filing report by the commissioner, but the learned counsel for the party submit that still the cross-examination of plaintiff witness is going on. counsel for the defendant submits after cross-examining the plaintiff witness, comment of the defendant will also examine one witness on behalf of the defendant. In view of the above, time to file report by the commissioner is extended till 10th of February.
Slightly more, my lord, then entire thing will be over when we won't have to
Till
come.
27th of February 2020.
Can it be, my lord, March, 31st March, my lord?
So year ending.
Then it will be over. my lord.
By 13th of March 2026. This is the matter of
But let it be recorded that they have no further witness.
cross-examination.
Of like.
My lord, I appear for the petition.
My lord, before my learned offense starts, my lord, may I pray for one indulgence? My lord, this is a hearing matter. Can it be posted, my lord, after vacation? It will take some time, my lord.
No, I can start, my lord. It will take some time because this is relating to, my lord, an incentive scheme. Initially, my lord, there was an order in my favor.
I know 2 and 3.
There are, my lord, 2 writ petitions. Issue is the same in both.
Only 15 minutes.
15 minutes. Very well.
355, 345 other witnesses.
Very well. My lord, kindly takes the first writ petition. I will not complete in 15 minutes. Kindly takes, my lord, the first writ petition. My lord, I am a manufacturer of tea, orthodox tea. I have tea gardens. My lord, the present writ petition concerns 2 tea gardens. One is, my lord, named as Norkhoi. The other is Decom. So these 2 tea gardens are the subject matter of this writ petition. There was, my lord, a scheme floated by the, my lord, respondent authority, in terms whereof, my lord, we were entitled to fixed subsidies based on, my lord, the production at the tea garden at the rate of ₹3 per kg. This is, my lord, the broad, my lord, purpose of the scheme. Now, there is a period of the scheme, and the scheme also, my lord, postulates under the mechanism under which a tea manufacturer or garden owner will apply. My lord, my case in the writ petition is that I have applied, and these were, my lord, half yearly, my lord, for half yearly productions, we were entitled to, my lord, subsidies. Now, we applied throughout the period of the scheme, and save and except one, my lord, half yearly period, the entirety of the, my lord, applications made by our client, they were, my lord, considered, accepted, subsidy granted. In respect of, my lord, this particular period, which is the subject matter of the writ petition, though the applications were filed, money taken towards the application was found to be in order, and that I would show from their own documents, my lord, the subsidy was not disbursed. So my challenge was to that, my lord, non-disbursal of the subsidy. In the writ petition, my lord, because this was a, my lord, required, my lord, affidavits to be exchanged, my lord, the authority were permitted to put in their affidavits. In the affidavit, my lord, 3 main defenses have been taken. Before I take your lordship through the, my lord, documents. One is that the planned period is over, so we cannot honor the subsidy payment now. The second is whatever was the amount sanctioned by the central government for the tea board to disburse in the form of subsidy, that amount is exhausted. So I cannot disburse. This is the second ground. The third is there is no scope for revival of payment of subsidy, in the sense that since the period is over, now there is no scope to revive that claim. These are the threefold, my lord, objections they have taken.
You applied for after the period?
No, my application was within the period of the validity of the scheme. My application was in time, in, my lord, the format which is required under the scheme, and payment of ₹5,000 and odd, which was required in terms of the scheme to be made, to be, my lord, entitled to the subsidy, that was also done. That payment was also done. Yet, my lord, there, from the emails, my lord, exchange between the parties, I would show, my lord, their defense was that there was some technical glitch with regard to, my lord, acceptability of the, my lord, application, because it was being converted from, my lord, the physical copies to, my lord, soft copies, as in, my lord, web copies. Now, my lord, may I first show your lordship the impugned decision which I am challenging, which is at page 191, volume 2, lordship will find that. My lord, this is a document, volume 2, my lord. This is the impugned memo.
Yes.
This has reference to your letter dated 25th November 2022 on the subject cited above. It may kindly be noted that the board has adopted online system of processing of application of subsidy. It would be evident from the letter dated so and so that both the gardens have submitted an application for which specifically file number was created, but no acknowledgement was issued, as because confirmation of transactions were pending in respect of the bank end. So I need to show that payment was accepted. This position is clear. I'll show that. Your client, instead of raising help desk tickets, chose to file application afresh, for which the whole application got inactive and could not be processed further. In the meantime, other applicants who applied successfully, including subsequent application of your client, were processed and subsidy was disbursed. And in the meantime, the plan period for the disbursement of the subsidy expired on 30th September 2021. So this is their second defense. Plan period expired. And no further action could have been taken by T-Board. Since plan period is over and board has exhausted the amount granted by the central government for payment of subsidy, there is no scope for revival of the impugned application and payment of subsidy. So this is the third ground, my lord. Now kindly takes the scheme, my lord, which is there in the first volume. My lord, kindly comes to page 24 where the scheme starts. It is Tea Development and Promotion Scheme for Medium Term Framework. The period is also mentioned, my lord, 29th of December 17 to 31st of March 2020.
Page.
My lord, I'm at page 24, my lord, volume 1, annexure P2.
Yes.
Page 24, my lord. Tea Development and Promotion Scheme for Medium Term Framework, 29 December 17 to 31st March 2020. My lord, there was, my lord, and my lord, the period was enhanced by another 1 year. Kindly comes to page 25. Introduction, clause 1, second paragraph. The date of commencement of the scheme is 29th of December 17. Duration of the scheme will be 29 December 17 to 31st March 2020. Then my lord kindly skips the next two paragraphs at page 25. The fifth paragraph starting with the above components.
Yes.
The above components primarily comprises extending subsidy, financial incentives, grant in aid for various activities carried out by different stakeholders for improving the production, productivity and quality of tea in India and promotion of Indian tea in the international market and research and development, and also expenditure on salary, pension, establishment and administrative expenses for human resources of Tea Board for implementing the scheme. My lord, I need not bother your lordship with the entirety of the scheme. Now, my lord, kindly comes to page 69. My lord, clause 2.2, which is, my lord, eligibility criteria. Incentive for production of orthodox tea. Eligibility. All orthodox tea or kind of orthodox tea like and garden tea producers owning tea and factories within India and holding valid registration under tea marketing control order so and so in case of individual small tea growers are eligible for availing subsidy under this scheme. Then I'm skipping to kindly sees, my lord, B. Duration. Activity will be in operation till 31st March 2020. However, applications will be accepted up to 31st January 2020. I'll show, my lord, this concerned application was within this date. For the last financial year 2019-2020 or any other date specified by T-Board. Admissible rates of incentive. Subsidy at uniform rate of ₹3 per kg of actual production for both leaf and dust grades. I'm skipping, my lord, clause D, which is not relevant, my lord. Kindly comes to clause E. Procedure for payment of subsidy. The payment of subsidy on production of orthodox teas will be regulated on the following basis. Applicants may submit their application to the nearest field office of Tea Board for physical verification of the factory and manufacturing records. The claim for the first half-yearly production, January to June, must be submitted to the field office of Tea Board latest by 31st August of the year under application. Similarly, For the second half yearly production, that is July to December, the claim should be submitted to T-Board latest by 28 to 29 February of the following calendar year. My lord, in my case, this claim is for the second half yearly period and it is filed within, my lord, 28 or 29th of February of the following year. In case the cutoff date of receipt of application falls on board's holiday, next working day will be considered to be the cutoff date. Claims for July, December 19 are to be submitted latest by January 31st, 2020. Delayed claims beyond the cutoff date, well, this is the only caveat in the scheme. Yes. Delayed claims beyond the cutoff date will not be considered for subsidy and will be rejected and returned immediately by the field offices without referring to head office. Now kindly turns the page, comes to page 70, my lord. What are the requirements? I'm sorry, my lord, page 70, bold, underline, my lord, last line, kindly sees. Page 70, last line, my lord. The following documents will be relied upon for releasing subsidy. Now kindly comes to page 70. My lord, what is important is B, because the issue is only arising out of B at page 70. All the applications shall be accompanied with a non-refundable application fee of rupees 5,000. The fee is to be remitted directly by the applicant through electronic transfer to the respective bank account of the T-Board, and the transaction receipt is to be attached with the application depicting UTR number and transaction ID. Application fees to be paid by small tea growers would be 100 rupees only. I'm not a small tea grower, so not relevant. My lord, this is really, my lord, what is relevant from the scheme. Now, my lord, kindly comes to my application. My lord, may take a note. This is for the period July to December 2018, the subject period. So I was required to file this application by 28th or 29th of February 2019. Because this is my second half yearly period of claim, July to December 2018. Now, my lord, kindly comes to page 139, I'm sorry, 139. Lordship may stop me as and when Lordship has that other. Yes. My lord, 139 at the top, Lordship will find in the form of a table. Factory name is there on the left hand side. Yes. Lordship kindly marks DCOM Tea Estate. This is in respect of DCOM. Company name is Rossell, who is the writ petitioner before your Lordship. Then, my lord, if your Lordship, just after the table on the left hand side, DCOM Tea Estate is the, my lord, tea garden for which this application is made. And now, my lord, kindly sees just after the table on the left hand side, Lordship will find certain particulars. Application, sublocation, manufacturing type. Kindly takes, my lord, the entry period applied for. Yes. And on the right, Lordship will see 2018, then July to December is there. Yes. So this is the period for application. Then the next entry is date of application. Yes. Date of application, my lord, will again come to the right hand side of that page, 16th of February 2019. So within the cutoff date of 28th of February of the following year. Then, my lord, kindly comes down, and then another entry, orthodox tea other than Darjeeling tea. There is an entry. Yes. And the quantity is mentioned 730680. Yes. The rate is rupees 3. Yes. In terms of the scheme. So this is the amount 21,92,040 is what I am entitled to receive if I multiply 3 into that production, my lord, in kgs. So this was my application for subsidy claim of 21,92,000. Now kindly turns the page, comes to, my lord, page 140. This is to show that 5,000 rupees was, my lord, remitted on account of this application.
So this is an application. 139 is the application.
139 is the application, yes. And this is the application fee at 140. There is a transaction payment gateway transaction reference number, middle of that page, my lord. Yes. PHDF so and so. And last entry, my lord, amount is, Lordship sees 5,000. Yes. This is, my lord, paid online. And this was for towards, my lord, this July to December 2018, my lord, application. That the amount was debited from my account. I have disclosed the document at page 141, my bank statement. Yes. My lord, the second entry, 16th of February 2019, at page 141.
5,000.
5011.8. There is a bank charges involved, my lord. And lordship may take note of the, my lord, transaction entry number, which will match with 140. It is the same. I have, my lord, seen that.
Yes.
And for DCOM, we also have disclosed, my lord, an additional document, which is, my lord, the inspection report. Kindly comes to 142. This is of the, my lord, manager of the tea estate, who, my lord, says that this is how, my lord, the production is assessed. Lordship will find the claim period just after serial number 17. There is, my lord, on the left hand side, claim period at page 142. I am at 142, my lord.
Yes.
Claim period July 18, and lordship, if lordship goes down, up to December 18.
Yes.
So this is the half yearly claim period. Then, my lord, e-return figures, the fifth column, total production in kgs.
Yes.
For every month, the figures are there. Last it is, total is 852272. The claim quantity, my lord, last but one column, 730680, based on which I make my subsidy claim by multiplying it with rupees 3 per kg. And I arrive at the figure of 21,92,000, which is, my lord, at page 139, the application. Now, my lord, kindly comes to the next, my lord, tea garden, which is 144, Knockroy Tea Estate. My lord, at the top again, left hand side at the top, lordship will find the name of the tea garden, Knockroy. And file application, my lord, details are there, file number, and then the claim period is there. Lordship will see again the claim period is July to December 2018. My lord, this should be the fourth entry, my lord, after the table. On the left, claim period is mentioned. On the right, July to December 18. The entry just after that claim period entry, my lord, if I skip one entry, date of receipt of application, lordship will see 2nd of August 20, so I'm sorry, 8th of February 2019.
8 February, yes.
Then, my lord, the quantity is mentioned in the next table at the middle of the page. 30 lakhs, 3,08,291 is the quantity. And I multiply it again by 3 rupees per kg as subsidy, and I arrive at 9,24,873. So for my lord, DCOM, it was 21.92 lakhs and odd. For Knockroy, it is 9.24 lakhs and odd. My lord, same bank statement I have disclosed at 145 to show that the payment was made. My lord, the entry with the date 8th of February 2019. There is a figure of 5011.80 again to show that this payment was made. And the challan, my lord, the transaction reference, lordship will find at 146.
Where is the 5011?
My lord, this will be the second last entry, 8th of February 2019. 5011.80. Lordship has found that 145. Yes. So 8th of February application, 8th of February payment. So both the applications were within 28th of February, both were for the half-yearly balance, half-yearly claim period. And my lord, the challan, lordship may also take note of at page 146, the same reference number lordship will find, similar to, my lord, the DCOM, my lord, transaction. Again, 5,000 rupees, which was, my lord, towards this. Now, my lord, I need to take your lordship through the correspondence, to the correspondence exchange contemporaneously between the parties. When we point this out, they say you should have raised a help desk ticket. So my requirement, my obligation under the scheme was only to comply with the requirements under the scheme. And if my application is in order, my lord, I am entitled to the subsidy. If there is any issue at their end, even if it is a technical glitch, my lord, can today a tea garden, my lord, owner be denied of the subsidy, particularly when I raised this issue during the validity of the period and when the central government had the fund in the coffers? this would be the issue for consideration. May I take your lordship through the, my lord, correspondence today? Next.
For the petitioner has argued under adjournment, but due to paucity of time, hearing could not be completed. Only case is adjourned. Let the matter appear on. कब रखें? केसन का बाद क्या डेट है? 15 से पहले नहीं है? कितना डेट? 15th January 3 PM.
Grateful, my lord.
Yes.
My lord was looking at the share purchase agreement yesterday. Lord, clause 11 is what your lordship, my lord, will kindly turn to. Well, your lordship has seen. Well, please come to page 381. Well, that is clause 11.
Item 3. Yes.
Now, my lord, your lordship has seen, my lord, the conditions, my lord, which were to be complied with before the first completion, made no mention of any incentive or tax. Now, my lord, conditions subsequent to the first completion.
Yes.
Now, my lord, conditions subsequent to the first completion, my lord, what has to be borne in mind is by this time, my lord, the Chatterjee Group has already, my lord, become, my lord, owner of more than 60% shares in the company. Now, my lord, this is what it says. The government of West Bengal, WBTC, on and from the first completion date, jointly and severally, covenant and undertake to the purchaser as follows. The government of West Bengal confirms that the government shall not impose any new state taxes, whether direct or indirect, on the company in any manner. Now, my lord, pausing here for a moment. My lord, more than pious representations, what can this mean? My lord, today, can a contract, my lord, decide on the policy of the government? Can the government by a contract bind itself not to impose any further taxes? Well, that is a matter of the state legislature. Well, these were pious intentions that were being expressed.
If we choose to enter into the conduct, what can be done?
Well, there are
All this was argued, considered whether it is pious or holy.
Well, argue before whom? Before the tribunal. That is what I am challenging before your lordship.
This is what they agreed, and has considered all this. In judgment. Be that as it may, I hope I did not interfere at all yesterday. I hope he comes to the point of why this award should be set aside.
I will have to come to
contractual
that.
terms being discussed.
My lord, that is, my lord, important because, my lord, I have to show your lordship as to how, my lord, these contractual terms, my lord.
I am still on no deposit. I am continuing with no security, nothing.
My lord, is my.
That's why yesterday I told ask Mr. Shah what has happened to the execution. Mr. Shah said that
It's still going on. Execution is still going on.
Property has been secured.
No.
So I am thinking in my mind whether the High Court building is still not secured.
My lord, may I just make one comment and I'll sit down? Well, the property that's secured is the one, my lord, on which, my lord, my factory is standing where they are given leaves.
But challenge up to the Supreme Court. Supreme Court is not.
Court said execution is going to be heard out.
Supreme Court has not interfered.
Very good order.
The Supreme Court found it to be a perfectly acceptable order.
Not really. Yes. Anyway, my lord, we are on. I don't want to.
Anyway, my lord, we are not arguing. We are not arguing execution.
No,
So, lordship,
we are
on the award. Now, my lord,
we are arguing, my lord, the setting aside why this award, my lord, should be.
my lord, why, my lord? What is important is to understand, my lord, the contract. Because, my lord, the contract has an overbearing, my lord, emphasis on, my lord, what the award has turned out to be. Now, my lord, what we are trying to understand is, my lord, whether, my lord, these covenants, my lord, can be, my lord, valid covenants and can be, my lord, contractual, my lord, representations which, my lord, ultimately bind parties to a promise. My lord, I am just trying to identify it here. But I shall tie it up with the law. The law is very clear. My lord, please see 11.1. the government of West Bengal confirms and undertakes that the government shall not impose any new state taxes, whether direct or indirect, on the company in any manner. But I'm only trying to ask myself as to whether this can be a contractual covenant at all. Well, these are pious representations, and that is how we represented it to the tribunal. Well, this cannot be a term of the contract, and it cannot be a consideration for the sale of the shares, because of two reasons, which I've already said. I'm repeating myself. One is the price of the shares was determined through a fact-finding exercise, and two is this would be absurd. I give you my shares and I give you money to take the shares, and not 1 or 2 rupees. I give you thousands of crores to take the shares. Now, please allow me to read on. Then, B. The government shall provide on best safest effort basis all the necessary assistance and support in respect of any dealings and interactions that the company may have with the government of West Bengal in the course of business. Again, completely meaningless. Again, a pious representation. Then C. The government of West Bengal, WBADC, agree and undertake that the nominee of the seller on the board shall be a non-executive director of the company and shall not be the chairman of the company, provided the government of West Bengal and WBIDC shall have the right to appoint such nominee till it holds 10% or more voting power. It says that, my lord, we are going to sell the entire shares. We've already sold you the first tranche. We are going to sell you the second tranche, but till we do so, until such time we have 10% shares, we'll appoint a nominee, but he'll be a non-executive director. My lord, this can be, my lord, read to be a contractual covenant. Then, my lord, D. My lord, this is very important because this is where my learned friends, my lord, are really making a case. Government of West Bengal, WBIDC, shall grant to the company, now, my lord, kindly note the word, tax incentives as detailed in Schedule 5.
This is the only question.
Yes, now, my lord, please see, my lord, the word uses incentives.
Tax incentive.
The word uses tax incentives.
Yes.
Now, my lord, tax incentives, my lord, can never be a consideration for, my lord, a contract for sale of shares. Because, my lord, it is a tax incentive. And, my lord, an incentive is an incentive. It is not a part of a consideration for a contract. Now, my lord, if your lordship will please have a look at Schedule 5. That's at page 450.
$450.
450, yes, my lord. My lord, kindly see again Schedule 5, how it is, my lord, headlined. Tax incentives to be granted by the government of West Bengal on and effective from the first completion. So, my lord, up to the first completion, my lord, according to the language of this schedule, no tax incentives. Because it says tax incentives to be granted on and effective from the first completion, which means, my lord, after you become, my lord, more than 60% owner. Now, my lord, again, what is to be granted? Tax incentive. Can an incentive be a part of a contract? That is the question. My lord, the law says no. The judgments say no. Now, my lord, thereafter, the company has unavailed incentives under the West Bengal Incentive Scheme 1999. Please mark, my lord, that incentive is payable not under a contract but under a scheme. This incentive is payable not under a contract but under a tax incentive scheme.
Unavailed incentives.
Yes, my lord. The company has unavailed incentives under the West Bengal Incentive Scheme 1999.
Correct.
So, my lord, it's not under a contract, it's under a scheme. Now, my lord, benefits of which will be made available by extension of the same as hereunder.
Extension of the same.
Now, my lord, extension of what? Extension of the scheme. My lord, benefits of the scheme will be, my lord, made available by extension of the scheme. Benefits with respect to the unutilized incentives granted under the 1999 scheme. My lord, kindly see repeated and constant references to the scheme. HPL will be allowed to carry forward and utilize 75% of the unutilized benefit of the incentives under the WBIS 1999 over a period of 19 years. The unutilized benefit being rupees 4380.62 crores and 75% thereof works out to 3285.47 crores approximately. Input tax paid would be refunded quarterly by way of state support at the applicable discount of 25%. Conditions. This benefit would be effective on and from the date of receipt of first tranche of payment, first completion, and withdrawal of legal proceedings in terms of clause 5.7 herein above, and no benefit pertaining to the period prior to that would be applicable. There shall be no benefits on motor spirit, and the parties shall not press the same. In the event of any change in law such as GST, as a result of which the tax does not accrue to the state government, the incentives would be suitably adjusted so as not to cause any loss to the state government on that account, and the incentives would be payable only to the extent the tax accrues to the state government. The total period of the incentives would stand reduced to 10 years, and no further incentives would be applicable to HPL in case the entire second tranche with interest for the remaining 260 million shares, additional sale shares, is not received within 7 years during which the amount is payable, or based on the award of ICC Paris, its amounts become payable to Government of West Bengal WBIDC against ICC shares, and the said amounts are not received within the stipulated time frame. And well, this is basically what it is. Now, what it says essentially is that the government will make an incentive which was no longer available. The government will extend the period of that incentive for a period of 10 years. And it is really an incentive and not a contractual consideration, an obligation against the receipt of contractual consideration. Because here you pay the money for the shares, you take the shares, and that's the end of the chapter. And that is what IOC had agreed to do. Now, the question therefore would be, what is the effect and purport of this incentive scheme, whether it can become a consideration for the contract? So far as the other provisions of section of the agreement are concerned, they may not be very relevant, because you'll also see after that, there are restrictions on announcements, confidentiality restrictions, etc., which are not really material. Now, what I need to show your lordship is, the arbitration clause now. Please see now, dispute resolution, that is 390, page 390, clause 19. Now, please see, this language is very important. If any dispute or controversy or claim between seller and Government of West Bengal on the one hand and purchaser on the other hand, disputing parties, arises out of in connection with the agreement. Kindly pause here for a moment and see. Who are the parties to the arbitration agreement? Because arbitration contracts are independent contracts. It is the seller and the Government of West Bengal and the purchaser, which means the WBIDC and the Government of West Bengal on the one hand and the purchaser. HPL is not a party. Although it is a party to the agreement, it is not a party to the arbitration agreement.
Controversy or claim between the seller and West Bengal.
The seller is WBIDC and the Government of West Bengal.
And
the purchaser is Chatterjee. These are called the disputing parties. Arises out of in connection with this agreement. Agreement is for sale and purchase of shares. Then that will be referred to arbitration. I am referring to the purchaser as Chatterjee because these are Chatterjee entries. SX is the purchaser. That's right. We are referring to because SX is ultimately a Chatterjee entity. That is how we have said, and that is how the arbitration has proceeded also. Now, the question is very simple. While reading the arbitration agreement, can the court add clauses to the arbitration agreement? With the greatest respect, that is not the law. You cannot supplant a term, you cannot add a term. So, this arbitration agreement is an agreement which is confined to disputes arising between the seller, which is WBIDC and the Government of West Bengal, and the purchaser, which is SX or the Chatterjee entity. And this pertains to the agreement. The agreement is ultimately superscribed to an agreement for sale of shares. The transaction identified as a transaction for sale of shares.
defined term.
The defined terms are there I have shown you, lordship, and the consideration is the consideration for sale of shares, which is identified and disclosed. Now, the question is, and this would be a jurisdictional question which with the arbitral tribunal is confronted. The question is, whether the tribunal can make out a new contract for the parties. With the greatest respect, the law is very well settled. PSA Sikal, Saludyog, all these judgments are there. Sang-Young, etc. Now, this is the term which is very relevant. Now, the question is why? Why was HPL not made a party? Because the incentive is payable to HPL. Why was HPL not made a party to the arbitration agreement? Was it an oversight? No one claims it was an oversight. Was it consciously done? The presumption would be it is very consciously done because no one has claimed that this was a mistake. And this was done why? Because a tax incentive can never be a part of a contract. A tax incentive cannot be enforced through the mechanism of a contract. A tax incentive cannot be subject matter of adjudication by an arbitral tribunal. It's not arbitrary. And my lord, your lordship knows, my lord, in Vidya Dolia, it has been held that, my lord, the matter of, my lord, the tax incentive is not an arbitrable dispute. I shall be citing the judge. It's not an arbitrable dispute. So, my lord, consciously, HPL is kept out of the purview of this arbitration agreement. And, my lord, the disputes, the disputing parties, my lord, do not include HPL. And the dispute is a dispute which arises out of the agreement, and the agreement, my lord, says that the transaction which is the subject matter of the agreement is, my lord, sale of the shares, for which, my lord, a consideration is decided. My lord, can the consideration be elastic? With the greatest respect, when the consideration is identified, made definite, crystallized, my lord, there's no scope for the consideration being, my lord, elastic, being stretched. Now, my lord, it is in this background that your lordship will see, my lord, what was the case with which, my lord, the claimant came to arbitration. That is, my lord, Essex. My lord, please have a look at, my lord, the statement of claim now. My lord, that your lordship will find at page 291. Volume 3. Now, my lord, I have already told your lordship that, my lord, here, my lord, the purchaser, that is Essex, went ahead and completed even the second, my lord, completion, closing. That was in 2018.
The GST regime came on 1st July 2017.
My lord, GST came in 1st July 2017, but, my lord, they have completed this, my lord, transaction in 2018.
They never said.
Although, my lord, there was a 7-year time, my lord, period that was available to them. So, my lord, they became owner of the entire lot of, my lord, of the government's shares in HPL, apart from that 155 million, my lord, which is pending in arbitration. Now, my lord, please see, my lord, the background. My lord, page 292. My lord, there's a background, paragraph 3.
Yes.
On 23rd June 1999, the government of West Bengal promulgated the West Bengal Incentive Scheme 1999 by a notification dated such and such. The WBIS 1999 was framed to confer benefits inter alia in the form of incentives to all large, medium, cottage and small-scale projects and tourism units in large, medium sector, which were to be set up, and also expansion projects existing such and such in the private sector. Well, just pausing here for a moment. So this was not a scheme made available only to HPL. It was across the industry. The relevant provisions of the WBS 1999 are set out. Then, my lord, your lordship will find, my lord, commencement in duration, unless specifically mentioned against the respective items of incentives sanctioned under 1919 scheme, it shall come into effect from 1st April 1999. And, my lord, it will be valid for a period of 5 years ending on 31st March 2004. So, my lord, by the time, my lord, this agreement came to be, my lord, ultimately executed, this, my lord, scheme had come to an end. Then, well, I'll not trouble your lordship with definitions under the scheme, not relevant, which they've set out. Now, my lord, your lordship will kindly see, my lord, the applicability of 1999 scheme, my lord, which is at page 295. Again, my lord, here your lordship will find that this was not a scheme, my lord, that was ultimately devised only for HPL. It was a scheme, my lord, that was devised for industry at large. Applicability of the 1999 scheme. The 1999 scheme shall generally be applicable to all large, medium, cottage and small-scale projects and tourism units in the large, medium sector to be set up, and also expansion projects of existing units, etc. Then your lordship will please come to, my lord, paragraph 4.
Yes.
Now, my lord, what has been stated, and very fairly so, is, my lord, this was a tax scheme or a tax incentive scheme which was devised for the industry, not specifically for HPL. Then, my lord, paragraph 4, the instant dispute concerns disbursement of incentives to HPL. My lord, kindly mark these words. This concerns disbursement of incentives to HPL. Not to, my lord, Essex, not to the Chatterjee Group, but to HPL, which owns and runs a modern naphtha-based petrochemical plant at Haldia, West Bengal, etc. Then paragraph 5, in the year 1999, HPL was considered eligible and was granted incentives under the WBIS 1999 by its certificate of registration number such and such. Then paragraph 6, the incentives were granted to HPL for a period of 12 years with effect from 30th July 2000 to 19th May 2012, or upon HPL reaching a cap of 125% of the gross value of fixed assets amounting to 6258 crores. Then 7. Under the WBIS 1999, HPL was entitled to receive the following incentives. My lord, kindly see what were they entitled to. My lord, and my lord, this is very important. What were they entitled to under WBIS 1999, not under any contract? A waiver of tax paid on purchase of raw materials in West Bengal. Under this incentive, at the time of purchase of raw materials from its seller, HPL would issue an appropriate form to the seller, pursuant to which the seller would not charge sales tax. Then exemption from paying central sales tax payable on the sale of finished products manufactured in Haldia plant and sold outside West Bengal. Under this incentive, HPL at the time of selling products manufactured in its plant would not charge sales tax from the buyer situated outside West Bengal. Then C, well, this is really what they're claiming, remission of sales tax payable under the West Bengal Sales Tax Act 1994 on the sale of its products from the aforesaid Haldia plant within the state of West Bengal. Under this incentive, at the time of selling products manufactured in its plant, HPL would charge sales tax from its buyer situated in West Bengal and thereafter retain the amount of sales tax without depositing the same with the concerned authorities. So, my lord, what the scheme provided was that you may collect the sales tax and, my lord, what you would ordinarily deposit with the government, you can retain it as a part of the incentive without depositing it with the government. Now, my lord, this was, my lord, permissible under the West Bengal Sales Tax Act of 1994, but the regime totally changed, my lord, from 1st April 2017. Then, my lord, please see, the incentives extended to HPL under the WBIS 1999 were implemented in consonance with Chapter 6 of the West Bengal Sales Tax Act and 8(5) of the Central Sales Tax Act, along with the rules and the notifications. Then, during the subsistence of the incentive period under the WBIS, contemplated such. Or, my lord, may I just read this one line? My learned colleague is right. My lord, kindly marks this word. The incentives extended to HPL under the WBIS 1999 were implemented in consonance with Chapter 6 of the WBST Act and 8(5) of the Central Sales Tax Act, along with the rules and or notifications issued thereunder. Kindly mark these words, all of which contemplated and enabled such exemption and or remission of these taxes. So, my lord, the rules and the statute itself contemplated, my lord, exemption and or remission. Well, there was no bar, my lord, that will show you, lordship. During the subsistence of the incentive period under the WBIS 1999 on from April 1st, 2005, sales tax under the WBST was substituted by the West Bengal value-added tax and was payable under the new, my lord, VAT regime. Then paragraph 10, the effect of the introduction of value-added tax as per WBIS 1999 was that HPL would now have to pay full tax on its purchase of materials in West Bengal, and the tax so paid would be available as input credit tax. The credit could be used to pay off West Bengal value-added tax, which HPL would have to pay on the sales in West Bengal. However, since HPL was already enjoying exemption or remission under the central sales tax or West Bengal value-added tax as per incentive numbers 2 and 3, input tax credit remained unutilized. Insofar as incentive numbers 2 and 3 were concerned, the remission on sales, which had been extended under WBIS 1999, was continued to be granted in respect of VAT. So, my lord, change from sales tax to VAT. Effect of remission in respect of incentive number 3 was that HPL could charge its customers sales tax or value-added tax, as the case may be, on the sale of its products in West Bengal and then retain the value of such tax as income without depositing the same with the competent state authorities as mandated by the Sales Tax and VAT Act. And this was also permissible under the yes. The incentives extended to HPL under the WBIS 1999 after the introduction of value-added tax was implemented in consonance with section such and such, along with the rules and the notifications issued thereunder. Then, my lord, kindly marks, all of which were contemplated and enabled such exemption and remission. So, because all these were all permitted by law. May 1929, my lord, at this moment, up to this point, your lordship will find that, my lord, all of these benefits are, my lord, benefits that they are entitled to under the, my lord, taxing statute, under the taxing regime, under the incentive scheme. My lord, because the incentive scheme, my lord, read with the, my lord, taxing statute, made these remissions and exemptions possible. Now, my lord, the repeated refrain here is that the entitlement is, my lord, to the incentive under the scheme. Okay. Now, my lord, as on 19th May 2012, at the time of expiry of the incentive period under the WBIS 1999, out of the value cap of 6285 crores, rupees 4380.2 crores remained unutilized. Now, my lord, the scheme comes to an end. That is, it's an acknowledgement. And there's, my lord, some, my lord, incentives that could not be utilized. That is, my lord, paragraph 13. Now, my lord, please see, reference is made to the share purchase agreement. Pursuant to various developments concerning the shareholding, management and other affairs of HPL, on 11 September 2014, that is after the scheme had come to an end, a share purchase agreement was entered into between the respondent number 1, Government of West Bengal, respondent 2, WBIDC, Chatterjee Petrochem Mauritius Company, Chatterjee Group, HPL and claimant. The claimant is a part of the Chatterjee Group, TCG shareholder was a party, etc. SPA, wherein HPL is defined as HPL the company, the claimant is defined as purchaser, respondent number is defined as seller, contains the following. Then, my lord, the terms of the agreement have been set out. I will not trouble your lordship with that. They have been set out in extenso. Well, these are not really relevant. Almost the entire agreement has been set out.
Yes.
Well, here your lordship will find, well, ultimately, my lord, clause 11 is also reproduced. And clause 11 is what, my lord, D makes a representation that the government will grant tax incentives as detailed in Schedule 5. Schedule 5, I've shown your lordships, is, my lord, the scheme. Again, the scheme. My lord, Schedule 5 is also, my lord, set out. My lord, Schedule 5 says tax incentives. Now, my lord, we'll kindly have a look at paragraph 15.
I'm sorry, my lord, to interrupt my learned friend, but my lord, if he's, I think, my lord, he's showing the unamended SOC. So, my lord, if he,
We'll show the relevant, this entire photo, only
I,
paragraph.
No,
again, my lord, it should not. I don't know, my lord, whether-
No, your lordship is right, my lord. My lord, what was the amendment?
I don't want him again, my lord, to go through the SOC by saying, my
No,
lord,
no,
that's
no,
the
no,
other, now the amended.
Well, I am not going to repeat myself. I would
Right.
not like to. Well, please see, my lord, what was the case made out? Well, then I'll show you, lordship, what was the amended portion. Amendment was contested and permitted. Now, well, please see, this was the case made out. Original case. The conditions precedent to the activation of clause 11 of the SPA were satisfied by the claimant in terms of 2.1 of the SPA. The claimant remitted an amount of 653 crores to WBIDC on 31st December 2015 for purchase of 260 million shares. Now, please note the date. So, the first tranche is completed on 31st December 2015.
Correct.
Para 15. Now, the representation here is the conditions precedent to activation of clause 11 were satisfied. Although, my lord, first tranche, my lord, contained nothing with regard to, my lord, tax incentives. Claimant remitted an amount of 653 crores on 31st December 2003 for purchase of, my lord, half of these 520 million shares. Now, my lord, then please come to paragraph 16.
Yes.
Pursuant to clause 6.1 of the SPA, the claimant had the option within a period of 84 months from the first completion date to purchase the second block of approximately 260 million shares on payment of a consideration of 653 crores. Kindly mark the word, my lord, on payment of a consideration of 653 crores. Kindly also marks the word, my lord, in paragraph 15, which says they purchased the shares for 260 million shares for 653 crores. My lord, these are very important representations in the statement of claim because it shows what was the purchase consideration of the shares, and this is acknowledged by, my lord, the, my lord, Chatterjee Group itself. Consideration for first tranche 653 crores. Payment of consideration of second tranche 653 crores. Paragraphs 15 and 16.
Yes.
Now, my lord, paragraph 17. Under clause 6.2 of the SPA, if the claimant or its nominee exercise the option of that expiry of 2 years, then, my lord, 9% interest would have to be paid. Then, my lord, clause 18, in exercise of the option, under 6.1 of the SPA, the claimant nominated Inventage Materials to purchase the shares. Then, my lord, 28th August 2018, investment Inventage made fund transfer, etc. My lord, this is how the shares were purchased. My lord, I don't have to trouble you lordship with this. That, my lord, 21 is very important. Subsequent to the acquisition of the aforesaid shares from the respondent number 2, the Chatterjee Group holding in HPL went up to 72.66%. My lord, before the acquisition of the second tranche, their holding had, my lord, become more than 60%. Then, my lord, there are orders of amalgamation which your lordship need not be now concerned with. Now, my lord, please now see paragraph 23. This is the cause of action. As will be apparent from perusal of the terms of the SPA, the respondent made certain specific representations and warranties. Now, my lord, please mark the words made representations made, my lord, promises to the claimant, including that the respondents had the requisite capacity, instructions, and authority to enter into SPA. The respondents further represented and warranted. My lord, again, the word is representation and warranty. My lord, warranty, my lord, as we understand from the conventional use of the term, is, my lord, warranty on products, warranty on services. I supply you a, my lord, turbo generator. I say that it will perform, my lord, with the up to its, my lord, requisite, my lord, requirements for a period of 3 years. My lord, that is a warranty. I supply you, my lord, a automobile. I say they will run, my lord, without any defect for a period of 3 years. This is a warranty. But there can be no warranty in respect of tax incentives. But, my lord, please see what is the language used. Made certain specific representations. I can understand representations. But, lord, warranties in this context really has no meaning. Respondents further represented and warranted that the said SPA would constitute a legal, binding, valid obligation enforceable against the respondent. Such representations and warranties are, and where or at all material times, representations and warranties of fact were intended to be acted upon. Claimant honestly, my lord, please see this. Claimant honestly and reasonably believing in the said representations to be true and correct, acted upon the same and altered its position inter alia by making its specified the sum specified for acquisition of shares in HPL. My lord, I will pause here for a moment. I will, my lord, lay great emphasis on this. What is their case? Their case is you made a representation. Their case is I believed in and acted on the representation. How? My lord, by acquiring the shares.
Correct.
Now, my lord, so therefore, their case is one of a representation which would be enforceable as a promise. But, my lord, what your lordship finds from, my lord, the narration in the agreement itself is, my lord, that they had wanted to buy the shares notwithstanding anything at all. From 2002, they wanted. When IOC was ready to purchase the shares, they came and obstructed IOC and agreed to purchase it for a specified consideration. Now, my lord, that is important. But what is very, very important in the context of, my lord, this case is that they say that you had made a representation.
Based on the representation of warranties.
My lord, warranty, my lord, really has no meaning in the circumstance. I shall show you, lordship, because, my lord, warranty would attach to goods or services. This is neither goods nor services. And, my lord, warranty in the respect of, my lord, shares would be that the shares are unencumbered, nothing more than that. But, my lord, what is very, very important is, my lord, their representation here is you had made a representation. My lord, you had not, my lord, bound yourself contractually. You had made a representation. I had believed in your representation. I had altered my position to the detriment. My lord, this is the language that we employ for, my lord, promissory estoppel. This is not a language that we employ for contract. And, my lord, they say that they had, my lord, honestly believed in and relied on these representations to alter their position by making payment for acquisition of the shares. Now, my lord, the case made out in paragraph 23 is not a case of, my lord, a contract. It's a case of a representation, which is a promise. And, my lord, they would, for the purpose of enforcing this representation, not be able to, my lord, avail of a contractual remedy of arbitration. My lord, a representation of, my lord, this nature, which is not a contract per se, cannot be enforced through arbitration, which is, my lord, for enforcing the contract. And, my lord, your lordship has seen, my lord, the parties to the arbitration agreement are the purchaser and seller, and the dispute is the dispute of shares. Now, my lord, if today they had to satisfy, first they would have to then, my lord, establish, and, my lord, this was an argument, my lord, carried in the tribunal with all force. My lord, first they would have to establish, number one, that, my lord, this is a promise which is enforceable. As soon as they say that, and that is their pleaded case, and, my lord, I will, my lord, be arguing before your lordship that, my lord, it was not open for the tribunal to depart from the pleaded case. Then, my lord, they would have to show that, yes, this is a promise which is enforceable. That would immediately take them out of the purview of the arbitration contract. And, my lord, they would then have to say that, yes, I have actually altered my position, believing in your representations, but for your representation, I would not have purchased the shares, which is, my lord, an impossible situation in view of the narration in the agreement itself. But, my lord, this paragraph is, my lord, very, very important because this ultimately is their cause of action paragraph.
Correct. This is the only.
Yes.
See,
Now,
so you read 27, based on the representation and warranties, the respondent 1 and 2 inter alia with respect to extension of the incentives, even in the change of law by way of implementation of GST regime, and with regard to unutilized intensives. So this is a representation.
Yes.
Claimant being the part of the TCG, the other shareholders belonging to a TCG make substantial investment in the HPCL plant.
Yes, yes. So, Malad, at the end of the day, what is their case? Well, if your lordship sees paragraph 23, they said, had you not made me these representations, I would not have altered my position by parting with money to buy the shares. Well, is it believable in the context of what the agreement records? And well, we cannot discard or disregard any part or portion of the agreement.
Yes.
Now, Malad, even if it is believable, what is the case? The case is one of promise. The case is one of promise which has induced them to alter their position. So, Malad, it would be enforceable as a promise, not as a contract. Now, Malad, please have a look at the next Malad paragraph. Schedule 5 of the SPA contained a specific agreement between the parties that in the event of change in law and such a subsequent introduction of goods and service tax regime, the incentive given to HPL would only be to the extent of tax accruing to the government. Introduction of goods and services tax was contemplated inasmuch it was specially mentioned in clause 1B of Schedule 3. SPA categorically stipulated that the contents of Schedule 5 would include Schedule 5. Subsequently, in acknowledgement of the applicability of and in terms of clause 11 of the SPA, the Commerce and Industries Department of the government directed WBIDC and the said Commerce and Industries Department restored the incentives to HPL from January 2016 for a period of 17 years, 11 months. The revalidation of the eligibility certificate and the registration certificate of HPL under WBIS 1919 was also made.
Very important. Again, revalidation
Now,
under WBIS.
Malad, please, Malad, look at this language, 26, the revalidation of the eligibility certificate and the registration certificate of HPL under the scheme. So, Malad, it is again the scheme, nothing beyond the scheme.
SPA, it was the scheme.
Now, Malad, please see again. Based on the representations and warranties made by the respondents 1 and 2, inter alia with regard to extension of incentives even in the event of a change in the law by way of implementation of the GST regime and with regard to unutilized incentives, the claimant being a part of TCG and other shareholders belonging to TCG made substantial investment. Now, Malad, what is the investment? Investment is purchase shares. Now, Malad, therefore, Malad, I pause here for a moment. What would be the inquiry? The inquiry would be, even if you accept it to be a part of the contract, of which I respectfully submit that there was no scope because the term uses incentive and tax incentive throughout, which cannot be a part of a contract. Even then, the inquiry before the tribunal would be, would you have purchased the shares had this representation not been made? That would be an impossible conclusion to draw in view of the narrative in the agreement itself, which says that when IOC wanted to buy the shares, this 520 million shares at 26.10 rupees, you opposed them. And you said, I'll buy it instead at that price. Now, this is the submission. Now, your lordship will see the goods and service tax regime, the GST regime kicks in. And the dispute is there. Please see paragraph 28 onwards. So, up to paragraph 27, your lordship will find that there is an attempt to portray that this is a representation. I believed on your representation. I acted on your representation to alter my position to my detriment, which I would have not otherwise done. But this clearly takes it out of the ambit of a contractual dispute. Now, this is their claim. On and from 1st July 2017, the CST and the WBIT tax were subsumed and replaced by the GST tax. Then, next paragraph, Schedule 5 of the SPA stated that in the event of any change in law, incentive given to HPL would only be to the extent of the tax that accrues to the government. Now, again, incentive to be given to whom? To HPL. Thus, by reason of the introduction of the GST regime, the goods and service tax accruing to the government of West Bengal by reason of sale of the goods produced by HPL and sold within the state of West Bengal would be available for the incentives to be received by HPL. Further, and or in any event, all compensation received and or receivable by the government from central government arising out of the sale of goods produced by HPL and sold within the state would also be available for incentives as compensation would amount to tax accruing to the government. But, what is the dispute? Till July 2017, following the then prevailing system in place, HPL availed of the incentives from January 2016 to June 2017. The details of the same, they in fact received incentives of 317 crores, 13 lakhs, 40,913. This was received by them in the course of 1 year. However, after the introduction of GST regime on and from 1st July 2017, the WB VAT and the CST Act stood replaced. And since then, the incentives were to be made available to HPL under the SPA. Now, kindly see. Since then, please mark these words. Now, VAT and CST are repealed. And then since then, incentives which were to be made available to HPL under the SPA have not been made available. In such circumstances, the respondents have acted in breach of clause 11.1d, read with schedule 5 of the SPA. Further, and in the alternative, respondents acting in the aforesaid have acted in breach of their representation warranties. Well, please see what is the case made out. What is the cause of action? You have acted in breach of what? Clause 11.1d and schedule 5. What is 11.1d? Tax incentive. Well, is it a part of the consideration for the sale of shares? Clearly no. Their own case, it was a representation on which we acted, believing it to be true. This would be enforceable perhaps in a writ court, and only on satisfaction that they had actually intended this to be a part of the representation which would induce them to purchase the shares. And but for this representation, they would have not gone ahead and purchased the shares, which is absolutely an impossibility in view of the statements in the agreement itself. So, what I am driving at is, here the case, as the case made out in paragraph 23, as in 27, is a case of representation, a case of promise. And violation of 11.1d and schedule 5, which are not a part of the contract. These are not a consideration for the sale of the shares, which have been qualified. Now, if the tribunal was to hold differently, the tribunal would have to then say that no, notwithstanding the fact, the agreement clearly mentions what is the consideration for the sale of the shares. In fact, that was not the consideration. You would have to go contrary to the terms of the agreement and come to a new and different contract than what is envisaged in the agreement. Well, this was the case. Now, then they go on to say, as per clause 11 of the SPA, read with the Government of West Bengal memo of 2016, government is obliged to continue to provide incentives to HPL even under GST. Now, this the GST does not permit.
Show this letter. So their case is SPA read with this letter. So this letter.
Now, so far as this is concerned, show me the letter. Now, your Lordship will kindly see, as per clause 11 of the SPA, read with the memo of the government dated 15th March 2016, government is obliged to continue providing incentives. Now, please have a look at page 456 in this regard. This is the letter. Kindly give me a moment. Well, this is the government letter that is referred to. Yes. Well, please see.
Subject line.
Revalidation. Well, the subject is revalidation of registration certificate under WBS 1999. So it is, again, revalidation of registration under a scheme, nothing to do with the contract for sale and purchase of shares. I am directed to inform you that in terms of the decision taken in the 32nd meeting of the Standing Committee of the Cabinet on Industry, Infrastructure and Employment held on 29th May 2014, followed by subsequent share purchase agreements, Mrs. Holdia Petrochemicals is entitled to get the benefit of the unutilized incentives, 75% of the unutilized incentives, which could not enjoy earlier under the scheme for 17 years, etc., etc. Your request to revalidate the registration certificate under the scheme. So, it was a benefit that was being extended under the scheme. It was a representation, no doubt. It was carried into effect till such time that the law permitted it. But it was not a contractual obligation. And that is their own case. Now, coming back to the statement of claim, if your Lordship now sees, paragraph 33 now.
Yes.
As per clause 11 of the SPA, read with the memo of Government of West Bengal dated 15th March 2016, the government is obliged to continue providing incentives to HPL even under the GST regime. That is their case. And then, my lord, the amount is quantified at paragraph 34. And then, my lord, please see paragraph 35. Now, my lord, this is again very, very important. On a meaningful reading of the term of the WBIS 1999 read with subsequent documents and letters issued by the government of West Bengal extending the incentives and the share purchase agreement, it will be unambiguously clear that there was a positive obligation and promise undertaken by the government to continue to provide incentives to WBIS HPL under the WBIS 1999, notwithstanding any change in law. Such a promise, my lord, kindly marks the word, was made keeping with the spirit of the objectives of the WBIS 1999 and industrial policy.
Writ case.
Well, a writ case, very good case perhaps for a writ. But, my lord, enforcement of a contractual obligation. My lord, one would then have to, my lord, ultimately, my lord, take out these words from the, my lord, the pleading and, my lord, discard them. Because, my lord, it says, my lord, obliged to continue providing incentives to HPL in terms of WBS 1999, notwithstanding change in law. And then, my lord, paragraph 37. It is important to note that the entitlement of the claimant to the incentives under the WBS 1999 arises from the provisions of the WBS 1999 itself. Arises from the provisions of WBS 1919 itself, read with various approvals and promises made in connection therewith. However, the SPA contains a categorical representation and warranty that incentives would continue to be disbursed with a cap on the amount, etc. So, the case is, their entitlement to the incentives is under the scheme, not under the contracts. The contract, according to my learned friends, is a contract, my lord, which contains the representation, a promise, my lord, that, my lord, you will be made available the benefits of the scheme even thereafter. And their cases, they acted on such representation, acted on such promise by making payment of the shares, which but for the promise they would not have done. My lord, not a case of contract at all. But even from the pleadings, not a case of, my lord, a contractual obligation. My lord, when we talk about enforcement of contract.
Paragraph 37.
Yes.
However, the SPA contains the category representation and the incentives will be continued to be disbursed with the cap of amount being the extent to which the tax accrues to the
Yes, representation. Now, my lord, why representation? Because their own cases, you had represented to us, we had believed you in your representation and went ahead to purchase the shares. My lord, not a part of the contract for, my lord, consideration for contract of sale of shares.
Oh, that's why they are calling the SPA contains the category of representation.
What, my lord? SPA contains a representation. Now, my lord, I will show to you, my lord, judgments of, my lord, Supreme Court, which clearly says that, my lord, every part of a document need not be a contract. And, my lord, their own cases, that, my lord, this is an incentive. We are entitled to the benefits under the incentive scheme. And you had only made a representation in the SPA that you will continue this incentive.
Okay.
And we had relied on your promise to, my lord, to proceed.
Okay.
Well, I'll come back, my lord, tomorrow. Your lordship has kept it for tomorrow again.
Out of this one.
Tomorrow 3:45.
3:40, yes. 3:40.
3:45.
3:45, yes.
Learned counsel for the petitioner has argued the matter at length, but due to paucity of time, get tomorrow at 3:40.
Milord, at the time of rising, Milord, item number 32 of today's list, Milord, it is in motion. My election is going to be held on 12th. And tomorrow from your list, Lord, I came to know that tomorrow the hearing matter to be taken up by this court. And then, Lord, my matter to be infractuous. If your lordship takes up this matter tomorrow at any time.
That's why I am not understanding when the hearing matters will be taken, when the criminal matters will be taken, when the defense will be taken, when special matter will be taken, when the part had
Sorry, my lord.
On Thursday, the hearing matter to be taken up fast.
Because in the morning, half an hour I am spending only for the mentioning.
That's for the
Well, I'm sure your lordship's life as a counsel was much easier.
Okay, it will come.
Great.